Can y'all hear me? Hold on. Miss Lady T ain't blocked. Oh, somebody. Oh, wait a minute. Hold on. How Miss Lady T blocked? I see Miss Lady T. Y'all, wait a minute now, because it's been a minute. I ain't been on here. I don't know how to do all this shit. Wait a minute. Let me see. Hold on. Let me figure it out. Okay, let me go here. Hold on. Hmm. Shit. Hold on. Okay. Now, Miss Lady T. Let me see. Hold on. Oh, no. I'm looking. I don't see Miss Lady T blocked. I don't see her blocked. Let me go back around here where y'all at. I don't see her blocked, y'all. Oh, okay. Oh, okay. She got timed out. What's good with it? What's good with it? I don't know why y'all can't hear shit. Let me try this. Yeah, did you hear that? Yeah, I don't know what's going on over there. I don't know. I'm trying to get you hear me? Baby, it's so many damn new buttons and shit. I don't know if they new buttons or old buttons that I'm not familiar with no more. Shit, I don't know. But what's good with it? What's good with it? What's good? Let me go through here and holler out your name. Cause you came. Hey, Hammer Nation Funk. I think that Miss Tanya, I believe. What's up, Starra? What's better? Hey, Jennifer. The hell? What's going on? What's going on? Hey, shout baby one. Miss Lady T. Miss Lady T. Hey, Millionaire Rock. Oh, I was excited to see you. Yes. Wow. Okay. I don't know why y'all can't hear the music. I don't know. Huh. I have to figure that out some other time. Because, I don't have a lot of time. I wasn't planning on, ain't wasn't shit going on, so I wasn't planning on making nothing going on till after the damn holidays. What's good? What's good? What's good? Honey, I see nothing ain't, nothing haven't changed. Lord have mercy. Y'all, let me tell you something. let me tell you something. Shout outs to you people who get y'all asses up and go like for a specified amount of time to somebody's motherfucking designation to work under their authority. Okay? Because it is challenging. I have bitten off more than I can chew. I am so goddamn tired. I'm exhausted. And I don't be thinking about this shit, okay? Because it's, outside of, because it's like, I like, to know what's going on with, different celebrities and shit like that. Y'all ain't interested in that shit over here. Okay? Y'all ain't interested in no fashions and shit like that. Y'all ain't interested in that shit. Or I don't know who is. I mean, I know that I know I can speak to Uniquely Made about stuff like that. She'll know what I'm talking about. I know some of you guys, y'all ain't real pressed with that shit. I know Larry's wife knows about shit like that. So yeah. So y'all ain't interested in that shit. You ain't interested in sports. You ain't interested in that shit. Let me see. You know what I'm saying? So those are things that I would try to make time for. Now, I'm not coming on to just talk about no bullshit. I'm not doing that. I'm not coming on under the guise of talking no shits and giving none of that. I'm not doing none of that. Okay. I will cuss somebody out if the spirit leads me, but then you know what, that's not even worth my while. You know what I'm saying? The time I'm taking to do that, I could be doing something productive. Yes, and let y'all motherfuckers have it. What's good? What's good? Yes. So, and I figured out how to put it on what you call it, members. What is it? Not subscribers only. Yeah. So if you want to go off of my ass, you're gonna have to be a subscriber for me to give you any of my time, because I ain't charging you for it. So guess what? You don't have to do something. So anyway, yeah. But child, listen. I've been missing y'all, whatever. Sometimes I be tempted to go live, at them people's plantation, whatever plantation I'm working at. But hell, I have too many devices on. I'm gonna be honest. I got track on, I got this on, I got that on, whatever. And baby, listen, I'm gonna tell you. I don't see how y'all work with people that y'all didn't hire. I don't see how you do it. I don't like this kind of capacity. Now, I'm not spoiled. I'm not spoiled or anything like that. But I don't like no shit like this. And and I'm not a quitter. That's the boy, I'm trying to tell you, I'm not a quitter. You know what I'm saying? But baby, listen, sometimes the money ain't everything. All right. But let me tell y'all this. Let me tell y'all this secret. Because I pass shit on. If you're with a company that allows you to retire, and you'll get a check from them, your pension from them, and then that's outside separate of your I'm sorry, that'll be your retirement check, and then that's outside of your 401k, your TSP, your FEARS, if you work for the state or whatever. That's outside of all of that. That's a separate voluntary retirement savings plan that you entered in yourself, right? But if you are at a company that allows you to retire with the check, stay there, do all those years. Okay. You're in the military, you got to do 20 years. Anything short of it, they have to put your ass out, or you got out because something's wrong with your ass. 20 years and 30, you can't go beyond 30. I know that because I have a whole husband that did the whole 30. Okay. Do that. Don't move around, even if it's for the money or it's for the opportunities or whatever, and end up where you have to either build your, I mean, you should build your independent savings as well as have your savings that you do with the company. But if you can get that check out their ass as well, yeah, you can get that check. And then when you get 65 or 67, and by the time it be 70, then you'll get a check from the goddamn government. But right now, if you ain't with no company, if you're not staying the recommended, amount of years, was 25, 30, whatever company you work with, you got to wait to get that Social Security check. Okay, so that'll be your monthly check. And then you have your 401k, whatever volunteer service savings plan you entered into. And then if you build your savings, right? So I'm telling you, okay? I'm telling you, it's a lot different, okay? It's a lot goddamn different because your ass got the motherfucking come up with a whole bunch of money in a lot shorter period of time and stick it into a savings account and invest it and hope that it motherfucking flip so you can catch up. So you know your girl gonna keep you in the goddamn, I'm gonna tell you some shit you can use. Not no bullshit. Not no bullshit. I'm telling you. So yes, please. Please, honey. So, but other than that, because I'm gonna tell you, honey, listen, I don't be in the right mindset for bullshit, My patience is very short. I'm gonna tell you what I did. So I keep looking at my phone and I keep checking my email to see if I got any message telling me don't return back to that goddamn location. Okay, because let me tell you, I'm working with this lady, baby. I'm working with this lady. And she's new to the game. She's new to the to the game, right? Because the game done changed. True enough. But she's new to all of it, right? So she got a position with like the third party company, right? Where she came in as a team leader, right? Now, I'm with that third party company too, but not as a team leader. I'm with the vendors as a contract holder with the vendors. And we all just, go to the different stores. So me being, like I said, you got to wrap that money, you got to accumulate that money up quick. They allow me to work with as a vendor, with the vendor, as well as with the agency, the third party. So that means the days I'm on the floor, she's a team leader. The days I'm doing whatever, I'm just, on my people are, the people at the corporate. It's craft, it's polo, it's who else? It's a whole bunch of people. So listen. Oh Lord. So let me tell you. So she is so annoying. And she's racist. Now, I know y'all be like, you call it somebody always racist, somebody always crazy. So let me tell you something. I have not been 100% wrong about nobody and a situation ever. Okay? Ever. So I'm not gonna go against my goddamn my motherfucking gut. And my odds are pretty good. And pretty much she done said racist shit. So y'all can rule that out. I'm not making up people racist. Her ass is racist. I'm gonna tell you what the fuck she said. So and thanks to Exxon goddamn technology, the cops using shit, I done recorded this shit. I done recorded this motherfucker. Yeah, I done hit them trackers on our ass. I'm gonna hit that audio button. Click, click. Yeah, I got ass. Yeah. Oh, what phone is on? Oh shit. Damn, I uploaded to that phone. That's okay, but I'll get it off there. But anyway, so her motherfucking ass. So listen, so she knows, that I'm with the vendor, whatever. So she knows I'm pretty much doing whatever I want to do. I can anyway. So where she can harass people, she does that. She wants to be, she hollers on the floor, I'm above y'all and all that type of shit. And telling everybody she's the boss and all telling everybody, right? So she keeps coming into my personal area. And I do, I prioritize my stuff, right? I pull out all the shit I need or whatever for that week's work or whatever. So when I come in, I'm gonna be late. I'm late every day. I come in, I need to get right to it. I don't have time to be fucking around. So she calls herself taking stuff out, whatever, my personal area, whatever. So yesterday Sunday. Yesterday was the second day she did it. And I was over it. I'm over her anyway. So you know what I did? I went and I was already mad when I looked. So when I was back there, I started taking shit out of her personal area and scrolling it all over the motherfucking in the back office. Yeah, I did it. You goddamn right. I don't give a fuck. You doxing motherfuckers can call and tell them I did it. You goddamn right. I did it. And then when I got on the goddamn floor, I got so goddamn mad when I thought about it, because I looked and she done removed one of the key motherfucking essential things I need. Baby, I start walking. I'm trying to tell you, I'm the slowest walker in the motherfucking world. I can run, but I'm the slowest walker in the world. Okay. I got my ass up and I was moving so motherfucking fast and whatever. And I went back there and I took her goddamn nameplate off her motherfucking area and put it in the back somewhere and stuck it to a wall. I sure did. I don't give a fuck. I ain't gotta work now. Give a fuck. Fuck them. I surely did. What's up, Charlotte Bennett? I don't care. I don't care. Hell. Got time for that shit. Well, you fucking with. Me the fuck alone. Yeah. Just annoying for no goddamn reason, bro. Annoying for no goddamn reason. So, yeah, I did that shit. I surely did. Nah. What you gonna do about it? So, she tried to be in your face for no reason. And then they was accusing this girl, and I kept telling them, I said, this young girl is not the one coming in stealing shit and all of that. That young girl ain't doing that. Yeah, she did one bad thing, whatever, and she did a couple of bad things, and y'all got rid of her ass, but she's not coming back up here sneaking in through the back door and stealing, y'all, the shit. Oh, they said it was this black girl, whatever. And like, well, what's her name, whatever. I said, well, I don't know. Said, well, which one of the agencies hired her? I was like, well, Becky hired her, but I don't know her name or whatever. Hey, y'all fuck around and got rid of her. I wasn't finna get rid of her. So they blamed that girl. And come to find out, talking to the guy that was fucking around helping this lady that was stealing shit and coming in and doing stuff, she was coming in after we left. From 6 to 10, a lady between 50 and 60 years old, and they took so long to catch her. They finally called the cops on her, because the retired cop that works with me, there's a whole bunch of bullshit going. I don't have time for that. That's not what that's not what I do. Okay, I like to do the shit I like to do. Okay. So I ain't got time. I like to set up shit and all that. I ain't got time for that bullshit. So I don't give a fuck about none of that. So anyway, but the lady used the word. The lady told the dude that was helping the lady. She said, well, You should you shouldn't have been helping her. You should have carded her. You should have asked all these questions, whatever. He said, ma'am, that is not my job. And she told him, why you say that? Because she's your kind. Yeah. So don't tell me I'm making up she's racist. Your kind. That's one racist thing she said. Then she said, now this is a registered nurse. Yeah, this bitch, yeah. And she said some other racist shit. I forgot what that was. And she says she's a proud redneck and all kinds of stuff. All kind of racist ass shit. Anybody got time for that? I don't get down like that. So hey, I don't do that type of shit. I don't give a fuck. I don't. I really don't. And I'm gonna tell you how God works. Any other time, she'll come off that floor at 4:00. But see, I was gonna wait till I got off to cuss her the fuck out. She would not bring her ass back there. I don't know. When I tell you, it be the Lord and all kind of forces be saving people from a lot of stuff. But she wouldn't come back there. Go figure. I'm not fucking around. You know what I'm saying? She was going to come back there. But I did put a little nasty note. Oh, damn, that's on the phone too. Don't take shit. Let me see if I can get that motherfucker. Because, y'all, I got the, I sent my goddamn, I ran my tracking through my damn phone, the phone that's breaking. Child, this is a lot of shit going on. But yeah, y'all. So, but anyway, enough about my goddamn bullshit. What's going on out here? I'm saying nothing changed. I still don't understand how. And at some point, people gonna have to get the idea. They have to get the get the message that a lot of this back and forth and proving that is pointless. It is useless, and you still be stuck in the same little circle. You just be going around in circle. You know what I'm saying? It's pointless. Because we have, when I sit up here and I see where people would value, and I ain't trying to start nobody, so if anybody think they can go back and forth with me, you are sadly mistaken. I'm operating pre-YouTube Angie. Listen, anytime when a baby killer, child molesting person that didn't take care of their kids and talk, and sitting up there, and that's a preferred person, I know something is wrong. I know something is wrong. That's not when I tell you, when I start treating you like I don't know you, that means I don't even see you, I don't hear you, I don't see you, I don't nope. Not gonna be counted in that crew. Nope. No, I'm not. I mean, you got people who don't pay child support talking about other people who they say don't pay child support. What kind of shit is that? But I'm gonna let y'all have that. No, ma'am. No, ma'am. What's up, Dub K? What's up, Purple? Purple. Yeah, girl, I ain't going nowhere. I ain't been nowhere, child. I'm just been what? Chilling, working, and baby trying to stack it up. Stack it up. I say I can work real hard for about 2 more years, and then hey, that's gonna be it. Shit, I ain't got time for all this bullshit. Hey, I don't listen. I don't need the world. I'm good. What's that? But yes, honey. When I know our shit is slanted. When bats If I had a friend that did half of the shit these motherfuckers said, they would not be my friend anymore. I'm not talking to you. I don't know you. I'm good for acting like I don't even know you. Like I ain't never know. What? Huh? And don't call my name. Because I want nobody to know I know you. Or you know me. It ain't that serious. That's okay. Ooh, shit. Ooh. No, ma'am. But anyway, child, anyway, I can't, baby. I can't. Yeah. But one thing about it, ain't nothing you can do to the strong. There ain't nothing you can do but weak ass shit. And it's not even effective. Like, what the fuck? So, child, And then you got people that go live and until they talking about somebody else, nobody won't want to hear that shit. You got to go talk about somebody else. Talk about something that's other than talking about somebody else and see if anybody stay there and listen to that bullshit. Because one, you can't put a cohesive motherfucking live together about regular shit. So the fuck? Where am I? So listen, I'm and majority of the people over here, can read, write, smart, and got it all, down pat. So I know that we venture out to other areas where the people can read and write and talk about something that's meaningful or something that's going to, extend your life, something that you're interested in, something that makes sense. They could pronounce the shit they purchased, shit like that. That type of shit. And not have your ass looking sideways like, what? And they give a whole story and they could make the whole story make sense, not just a piece of it, whatever they want you to believe, not the whole thing. You know what I'm saying? So I know y'all venturing out doing other shit. Oh, child. But I'm trying to tell you, if it ain't reading up and I'm glad, other people reading the shit or whatever, trying to keep up with the shit. But baby, if it ain't reading no paperwork, breaking down, doing something meaningful, baby, don't expect to see me on here with the bullshit. I got other shit to do. Shit I should have been doing in the first place. Yeah, shit I should have been doing in the first goddamn place, baby. So, but listen, so let me get on here and talk about this bullshit here. That goddamn Daryl Brooks. Oh my goodness. Whew, Jesus. Was that not a thrill to watch? Let me tell you something. I had that shit playing all day at work, every day. Honey, I was getting up with the yes. I'm like, let me put you in my ear, and so I can listen what the hell is going on. That was a exciting case to watch, right? It had so many lessons in it. And let me tell you this, right? Let me tell you this. I ain't never seen nobody try everything under the sun to get out this case. He tried sympathy. He tried to stall it. He tried to dismiss it. He tried every goddamn thing known to man. And none of it worked. And here's the thing. And this is the beauty of it. And this is and let me tell you something. Only people that don't have a degree think that going to school for a particular thing, you should know everything. Only people that think that don't have a degree or they just dumb, right? So, if that's the case, then the judge will never have to overrule shit and shit like that, overrule or sustain or whatever, She wouldn't have to do that because all of them should know what's a proper objection, right? And how to object, right? So that's one. And number two, laws change all the time. Medicine advances all the time. So there's always constant conferences, extended education, stuff you have to read up on. And let me tell you something, you don't have, once you come out of school or even when you're on some job, like a lot of jobs, they'll give you periodicals and refer you to different things to read to stay up, with the industry that you're in or whatever. But a lot of that, you got to remember to do that yourself. So there ain't no teacher calling your ass after you done got that paperwork and say, hey, there is an advancement in medicine. You might need to go to the conference out in Nevada or Colorado, and catch up or something like that, right? So that's not the case. So, but he tried every goddamn thing, and it was so funny. But this is one thing that, depending on your teacher, they teach you the tricks, and some of those tricks you get, just by being in the industry or whatever, right? So all the while, they were on to his ass. They was on to him. Okay. They knew exactly what he was doing. They knew it. They knew that he was trying to create appellate issues. Yes. Yes, girl, grounds, child. He that boy ran me crazy. I was like, if you don't shut the fuck up. He objected to every damn question damn near. Like, are you crazy? Wrong objections. I'm like, dude. Leading. No, they're just asking a damn question. That's all they're doing. That's not leading. Just asking a regular question. It's very few leading questions that can be asked on direct. You can ask leading questions on cross. Like, oh my gosh. Let me see if I can get up some of his some of the shit he done. Let me try to find the channels that's not like private channels or whatever, so we can see. He objected to every goddamn thing. He got on my goddamn nerve. I'm gonna tell you that right now. He did. I mean, you was yelling at the TV. Oh my god. He was terrible. Let me see what I can pull up. Like, he thought every goddamn question was a leading question. Like, no, fool. And it's like, and I don't know if somebody told you, and you know what? And I'm gonna tell you something. And let me go back to something real quick before I get into this. For some of us, we know if your ass is crazy or if you playing crazy. Just like we know if your ass is ignorant or playing ignorant. Okay? And if you sit up there and think that just because somebody went to college that they can't be ignorant, you're gonna be led astray. You're gonna be led astray because you can be ignorant in certain, areas. It don't have to be mean a total ignorance. You got some people that's totally ignorant. You got that, okay? But like the people who saying Kanye ain't crazy, you must be don't know what crazy is. Kanye is crazy. He might not be insane. See, there's two different, classifications. But Kanye is definitely crazy. You can look in his eyes. Daryl Brooks, he got a problem, but I want to say he's a little crazy, but he has a personality issue. I believe he has a personality issue, and it has something to do with being a narcissist. It has something to do with, you know, it, it, he has anger issues. It's a lot going on there. It's a lot going on, and but people look at Kanye. So he made a bunch of money. You can be smart and crazy at the same motherfucking time. You can be business. You know what I'm saying? You read up on a lot of the people personalities and some of the mannerisms and some of the issues a lot of people had, like Steve Jobs and all these other people. And when you hear about their workplace antics and their the antics of their personal lives and shit like that, you're gonna say, something ain't right. Something ain't right. Mm-hmm. Yeah. So let me tell you. So he thought that, like I said, he could stall that trial, get sympathy, get it dismissed, whatever. And a lot of people, a lot of defendants think that that is a smart course of action to do, right? And I think he thought that, he wanted to do all those things. He thought that, doing that sovereign citizen thing was going, he thought maybe that was a legal claim or legal right or whatever. And I'm pretty sure he probably fired his attorneys because he know his attorneys wasn't going to do that. Okay? Because it's not legal. That's just your personal belief. It's not legal. And sovereign citizens, we ain't learned nothing about that in no school. Okay, remember I graduated in 1998 and 2000. We ain't learned nothing about nothing, no shit like that. Or we did, I forgot. Because it's not, of a legal ground, right? It's not a legal argument. But I seen it play out, and I said this years, like 2 or 3 years ago, when I was hearing it floating around, on the YouTube streets. And I would say, well, you know what? Every time I've seen it used, it's been in civil court, and it's usually somebody trying to get out of paying some kind of judgment, right? And the courts here, they, the judges have fun with it. And as one of the clips I shared on my community page is how to do the judge in Florida was like acting crazy, just having a good time with it, with this one guy that came before him, claiming that he was a sovereign citizen, right? So it's a belief, and I wanted to do something with Dana on it because he could bring because he knows all about whatever and whatever that paperwork is, whatever he be doing about that part of it. I don't know all about what they be doing, and I can come with the legal portion of it. And and have a, like a, good conversation about it. But honey, so I believe he abandoned he got rid of his attorneys because he wanted to pursue that. So I don't know if he picked that. I don't know. And I'd be interested in knowing how long he's been claiming to be sovereign, right? You know, and somebody went back and found where he was on meth at one time. He was part of a meth documentary. Yeah, that was him speaking. Oh man, it when I tell you it was so much shit going on. What's up, Sonya Davis? What's good? What's good? What's good? But it was real interesting. But like I said, I've only seen it 3 times, and I remember all those 3 times in court because it was on the civil end, and it was like one of the judges I never forget said, "Well, you can consider yourself whatever, but you're gonna take this bill with you." I was like, "Wow." And it wasn't nothing I was, went to study about, well, because I knew it wasn't a legal argument. So ain't shit I had to be concerned with, you know. So but yeah, but it was it was quite entertaining. That case was quite entertaining. Now let me ask y'all this, because I don't know, I forgot. Did they say that they're gonna allow cameras in R. Kelly's case for the state? Let me key up what I found. So I'm trying to stay away from, like, I don't know if that law and whatever site will let us share it. I'm so scared. Child, I don't forgot now, baby. Shit, what the fuck? How to share this shit? Oh, here we go. I don't forgot if they might hit us, child. Fuck around. Oh shit, wait a minute. Let me get the video up first. Shit, I've got to do all of this. My bad, y'all. Let me do this. Hold on, let me. Okay. I mean, this was a goddamn fool. Like, and he is facing. They offered him six. What did they offer him? Six. I think they offered him 6 life sentences and 859 years, or that's what he's facing. I forgot. Either or, it's still a lot. And thanks everybody been hitting me up. We gonna go live. We miss you. We need something in the streets. I'm like, child, I'm tired. I'm tired, baby. By the time I get in, baby, I be sleep on this motherfucker. Yeah, I ain't got time. Hey, listen, I won't give y'all a complete live. It'll be only about 10 motherfuckers and stuff like that, baby. I'll be tired. Hell. I have to give y'all about at least 100.
Don't tell them all the information
Mr. Brooks,
they
I'm
need to
going
know.
to take up all of your objections outside the presence of the jury. I'd ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason, because you asked. I see what you people are trying to do. It's not right. It's not fair and it's not right.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Hopper, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr. Brooks, I need to make a record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue. I indicated I would.
Accurate, Your Honor. Can we have the prior counsel testify to that then? Because
not at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit.
Mr. Brooks, I presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What does that have to do with what we're talking about?
Because I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons. The first of which, it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that and what relevance, if any, evidence have, but you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it. Because the still image was of your back.
Okay.
So that opened up the door and it's proper. There's absolutely no surprise to you that that video exists. And that is my finding as it relates to that.
It's no surprise to me that it exists. That was not the issue. The issue was how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue.
State can make an offer of proof on that because obviously they marked it as an exhibit.
So let me stop that right there, right? So I know that everybody that's been over here, whatever. So y'all did hear the familiar language, right? They used to the trial. Y'all heard about the elements. Y'all heard about the 3 R's more, but more of the relevance part. You guys heard. I don't know, but just let me know in the chat, y'all, if anything that they said during the process of this hearing, you guys remember that we already went over and things like that, right? I went over briefly in a appeal. So I went over that, but very brief, right? And that's just an appeal that's just generated not by, it doesn't have to be by someone requesting it, someone at the next level, right? Because appeal is going to go above her, just say, hey, we're going to review this case, right? So he don't have to request it, or he wouldn't have to request it. It would just automatically something that would be done, but that court would have to do that. So we went over, so a lot of stuff, it was a repeat. So, but let me stop it right there. So when he said, and I have a guy that said this, when she said, you don't, the video isn't new to you, meaning it's not new evidence to you. It's like it didn't exist. And he said, well, that's not the point. I want to know how it's made it was made an exhibit at the last moment, and he didn't know. So let me tell you something. So let me tell you this about that, right? What she was trying to say, and you got to be careful because he's representing himself, right? So she can't, it's a certain, she can't address a lot of his questions and stuff because that'll be seen as, her acting as counsel, giving him legal advice and blah, blah, blah. So you can't do that. So she had to be careful how she words stuff to him, as well as the questions she answers. And in fact, and you're probably, and I know a lot of y'all was probably telling, why she just won't answer it, or why she's, why she won't, why is it back and forth and she just won't give him the answer? And a lot of y'all probably knew the answer, and probably later because of blah blah blah, y'all probably getting annoyed with the judge. Because when I was looking in some of the chats, people was getting annoyed with her, and it's because you can't, okay? Because you can't. It's a law. You so crazy. Thank you, Star. So because see, they could drop that video in there on him. It's not evidence. It's not a tape that he doesn't know about. Okay, this not brand new evidence. It's not something out of the clear blue sky, whatever. Okay, so he can't later on make that claim like, oh, they dropped that evidence on me, and and I ain't know nothing about this. I ain't know nothing about that evidence existed. So because he know about it, it is therefore discoverable. Even if he didn't, he didn't put it in. Of course, he wasn't gonna put that in. But anything discoverable, you can't later on, in some instances you can, but you have to be careful with that. But most times you can't later on say, hey, they dropped this in on me, and listen, I knew it was there, but they shouldn't have been able to use it as evidence. No, that's not how it works. It's discoverable, meaning it goes into discovery to later on become evidence if the judge says it's admissible. So that's why she said, and I'm gonna let you know about the game, how they were wording things between her and the state. Again, they had to be very careful. They had to put a lot of stuff on the record, more than usual, because if he was represented by an attorney, a lot of the stuff they said most likely wouldn't even been on, being said the way they said it, like they were talking to a 2 or 3-year-old, and like they were making it clear on the record. Okay, so a lot of it would have been done in writing, to be honest, but because he's representing himself, he tried everything in the book, right? So they were pretty much making sure that their process, the case, was sterile. Okay, so if it comes back on appeal, because he's gonna appeal it with his crazy ass, or he's gonna get an attorney to appeal it, he can't say, well, they did this, they did this, whatever, they was unfair, they did this, whatever. They were overly fair to him. You see, the state even helped him with his subpoenas to get his witnesses there. So they did more than enough. That's the setup. Because when you come back on appeal, well, they treated me bad, they did this, whatever. That lady gave you 101 chances. Because when the recording I'll play in a few minutes, you'll see today, after his ass has been convicted, how her patience is short with his ass. Her ass is like, baby, I don't want to hear that today. I don't want to hear that la today. Get your ass out of here. It was funny as hell because now that process, that part of the process is over, and now she can resume court as as regular, as normal. Now she don't have to be overly accommodating to his ass. Okay. But she wanted to make sure that nothing comes back on appeal that will hit at her ass, and the state was helping because you see, sometimes the state kind of acted as an advisory to her. It was all a setup for his ass. See, you play the long game. You don't play the short game. He was playing the short game and the bullshit. You play the long game with these motherfuckers. Let them set their own self up. Because then when you hit them with that, slam that door, explain this. Now you can't explain it. Because you done said one thing here. You done said another thing at another time. But here's something else. Here's some other evidence. Now you can't explain that. Now you got to come up with something else. Now you are a liar. Set up. Oldest trick in the book. You let people set their own self up. They back themselves in a corner that they can't get out of. Hey, it's the game. So, even when he kept, let me see if I can find that clip. Hold on. Hell, I don't know what I just did. Hold on. Hold on for a minute. Okay, let me get this one. Sorry about that, honey. I'm rusty, baby. I don't know what these buttons are. Hold on, y'all bear with me. I saw it.
All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is,
the letter
hold
too?
on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by what's the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you speak
Do
and
you
have
want
contact?
to open up the door to the other act's evidence of
That's not opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. And I have been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or why she wouldn't have contact or not, you are opening the door to that testimony. All of my rulings have been made to prevent what could be seen as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial. But you can open the door to that, sir.
It's unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness can get on the stand and lie on the stand.
Have you turned that document over to the state?
Come on, man. Y'all know that's not right. Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When did you receive the document? Hold on. When did you? I'm having you make an offer. When did you receive the document?
Okay, but I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
that's not true. That's a misstatement of the evidence. That is true.
No, she said it herself.
No, marking an exhibit is not creating an exhibit.
No, not marking an exhibit. She said
we're not going to go down a tangent, sir.
Right,
I'm going to focus on this, and I'm going to give you the opportunity to make a record.
It's not fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It's not claimed. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So do y'all want the
letter?
I want to see the letter. What?
I want to see the letter.
Okay, so I got.
And I want to know when you received it.
I got to bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures, and
okay,
I want you to make a record. If you don't make a record, then I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Oh man.
Mr. Brooks.
Come on, man. Stop.
When you aren't
Stop
even
it.
letting
You're a
me
public
ask
servant, Your Honor. I respect your courtroom. I respect you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, I asked Ms. Ashton to be excused.
Yes, you can be excused. My apologies.
My apologies, too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what he's referring to in count 77. Okay,
What happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make
be
a
found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
Okay,
sir.
whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My guess is maybe to simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in here. And now all of a sudden I can't.
And now you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of the bailiffs of this state. You're accusing, frankly, everyone of moving your papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption that I'm saying?
Can I please make the record without you interrupting?
Yes, you may. Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I will have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't say
You implied it, sir.
But did I say that?
You stated it implicitly.
I never asked the bailiffs, hey, did anyone of you touch my table? I never said that to them. I just said, I can't find my paper, which is the truth.
And the way that you said it, like,
I didn't point anyone out, though.
And like, well, that's kind of interesting. I don't have a document that was just on my table. That is what you said.
That's what I said, but I did not point the finger at anyone.
So
I can
you
see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir. It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering me with questions or comments, statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
I'm sorry.
That's my perspective. That I'm making a rule. You're doing it again.
I mean, because it has no validity.
So I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench. Do you have the letter with you in court?
I just said no. How many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
that just fine. In a quiet courtroom, yes, we can hear it very clearly.
Everybody assumes that it has to be disparaging.
Once again, you're doing this tactic
because
it's
not a tactic. It's facts. It's facts.
To some other reason.
It's facts. Because I find it hard to believe that
I'm gonna
all of a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you believe it's.
I didn't get these pictures from nobody else. Why was somebody else?
The record will reflect you have 2 pictures that you believe were from this witness.
That I know is from.
No, that you believe.
That I know.
All right. I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that that's what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada. And for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
furthermore
to that.
I'm not
because that's a lie.
Let him finish. At the end of the day,
Let him
finish.
If we're gonna open the door on that, no, since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was.
interrupting.
We can ask that question
He is
too. Then
over the top animated right now. Mr. Brooks, I'm ordering you to sit down and to let the state finish.
No, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he can show it is inadmissible, she will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Baby, that ignorance come out, baby. See, they pretending to be smart, honey. Oh my goodness. So listen, that was a perfect clip. So check this out right here. This is when you know somebody is guilty. When they start the diversions, right? And so we know, it's somebody that's trained or whatever, or somebody with good sense. Stick to the facts. Always come back to the facts. What is the original question? What's the subject? What's the subject? Where are we? Come on back to that. Say whatever you want to say, but let's come back to this. Let's come back to this. We're still right here. So as she said, you heard the judge herself say you tried to divert, you try to stall, you go all around the corner, whatever, instead of talking about what it is, what we're talking about. The question on the table. What's the problem? Where we are. At what point? So that was funny. He lit his ass. What's his name? Zach lit his ass up. He said, and not only, he said the child don't even live with you either. So like, what the fuck? Yeah, Sonic. See, those are the tactics of the weak and the ignorant. You know, they don't know nowhere else to go. So you're gonna get fucked in the end, you know, and that's what happened. You know, just sit back there and just wait. Mm-hmm. Mm-hmm. Then we hit them with that boom, they be like, you get upset. Well, what else? Because the ignorant or the illiterate, they don't have too many, you know, options to do. They don't have too many, you know, nothing to deploy. They only got 1 or 2 moves. After that, they're done. Then you finish their ass. Just give it some time. Just finish. You know, just sit back there and just wait. Mm-hmm. And it was so funny. But so, and then again, that's so you heard the word causation, right? We talked about causation a lot. A lot of y'all who, especially being before I had a channel, I always talked about causation, right? You know, I used to describe it as, you know, the prosecutor was going to say R. Kelly was the cause and whatever happened was the effect. Cause and effect. That's causation, right? And that is measured by the but-for test. But for the girls, the women, whatever you want to call them, meeting R. Kelly, this wouldn't have happened. That's the but-for test, right? In causation. So, and when she was talking about, you know, he was going to open the door to wrong acts and all of that. So the prosecutors were going to be very skillful, right? Because and they said that they were not going to take it easy on, because at one point, with some, when they had a conversation about opening the door, they said if he opens the door, we're going to come through it, right? Which means if he broaches a subject, they are going to talk about it, and they can question that witness, not so much as to when it comes to wrong acts and other acts evidence. You can't do it. You can't approach it from the standpoint of their character or propensity, right? Because that's not allowed. But definitely about their intent, their behavior. Remember the actus reus, and as well as, I'm sure my mind, I don't know what my mind getting all fucking confused, but anyway, their opportunity, the motive, the opportunity, the intent, all of that, right? So you sit up there and you call yourself questioning a witness, and you open the door. It's fair game. They're going to be able to go in there. They're going to, you know, make sure they don't, you know, go and get any violations, fucking around with, you know, try to prove somebody's character and propensity, right? But they definitely can do the intent, the opportunity, you know, behavior, all of that. And that's to show ass. You should have kept that white lady and that white man, you know, sitting by your ass. And did I hear that they said that the court, I don't know what kind of motherfucking courts it is that, because that don't happen in the dirty, well, not where I am, where they even give you suits and ties and shit to wear to court. Apparently they got a back room or a lost and found, or suits and ties and shit for motherfuckers to come to court in the suit and shit. And that's all. I mean, they took every precaution, right? Because it is often thought that, you know, when a defendant shows up in the jailhouse blues and whatever, that it could be prejudicial. And again, you don't want shit coming back up on the appeal. So, you know, she even, hey, kind of, I think at one point she said she kind of insisted that he be in a suit. So, you know, that was, I mean, when I tell you this right here, this case, because I know she had to do, she's going to create a lot of case law out of this, as well as it's just going to be a perfect study for, you know, for upcoming law students, because I mean, it was so much going on in that goddamn case that I was like, what the hell? But Yeah, seemed like Mr. Brooks impregnated Miss Patterson when she was 15. Yeah. hmm And he went to jail for it. And this was so crazy, and I just caught this part where they dropped the set, because I thought I heard it was 77 charges. So the 77 charge was a case for Miss Patterson, a charge for Miss Patterson. It must be like domestic violence or abuse or something like that. But because it wasn't enough evidence to prove that, they dropped it. But imagine that, right? They had 77. They didn't want to lose not one count. So they dropped 77, and they said we're gonna ride on 76. But goddamn, I mean you wouldn't be able to sleep at night if you had 76 and one. Goddamn, they offered his head. Like, they wasn't fucking around. But he did everything known to man. And even when he kept asking for an interlocutory review, I think at once or twice she said this after she kept kept saying denied or whatever she was saying when he would ask for that. At some point she started saying this isn't that court. Even with something as small as that, she had to be careful about how she answers that question, because I guess that could be seen, depending on how she answered it, as giving legal advice, because that is the higher court. It wouldn't be handled there. But it was a lot of people. I was looking at different chats or whatever. A lot of people was like, oh my God, why don't you just answer the question or whatever? Like, I know she know the question, and some people was thinking that she was dumb. Like, no, she can't answer that. She can't answer like straight out, give him an answer, because that would be seen as legal advice. That would be seen as instructing him. Suppose he takes advice, something happens, whatever. There's a whole lot of shit you can get into with providing legal advice when you're not on the record. That's why you see so many people say, hey, this ain't no legal advice. Hey, I don't ask some type of questions. But oh yeah. And even the jurisdiction, right? And people was like, okay, surely she can answer the question about the jurisdiction, right? And even when it came to that, she was very evasive, right? And the subject matter jurisdiction, is very rarely handled at the state level. That's a federal situation, because that has something to do with the subject of your particular case, right? Whether it be bankruptcy, whatever it is, right? So that's when it's you most commonly seen at the federal level. In the state and local levels, that's usually territorial and personal jurisdiction, right? So the territorial is just what it says. Whether it's like he kept saying, the Admiralty Court, which that is maritime, baby. That is of the ocean and shit. He was all over the place, baby. You ain't at no ocean. Who is advising you? Is this Admiralty? This the Admiralty Court? No, it's not. You ain't in the ocean. You ain't in the water. So that's like, so territorial be like maritime, the state, international, county, federal, that type of thing. And personal is just the right for the court to enforce the law on that particular person, on him. So that'd be personal jurisdiction. So so she couldn't even go into all that. You know what I'm saying? Because baby would be like, she couldn't even go into all that. So that's crazy as hell. It was a whole lot of going on, honey. Whole lot of going on. But I found that it was the funniest shit. Let me drop this link, because let me find out how to do that. Okay, that's it. She was That was kind of a challenge. But you know, the state, when the state told her that you know, that one that lead prosecutor, the first chair, when she was telling, you know, like pretty much hold on for a minute. She was pretty much telling her that, you know, what she should do, what the other options were and things of that nature, when it seemed like she was kind of telling the judge what to do, which she kind of was. But you know, that was all to make sure that that case stay tight. No bullshit. If they got to help each other out, if they got to talk in code, you know, that's what they would do. Let me tell you something. I'm gonna tell you a little funny story real quick. I pinned that link. Tell you a funny story. One girls I've been knowing since we were 11 and 12, or maybe 12 and 13. We do this thing where we talk in code. Yeah, we talk in code. And I got that from my mama's side because they do that a lot. Then when I went to school, I learned how to do it even more. But even before that, we were talking code and whatever. And then this other girl we was hanging with, she could never catch the code, and we'd be like, "Oh my God!" Like you can't say it. How, you know what I'm saying? You and it we're like, girl. Then after a while, we get so frustrated. Oh my gosh, we'll tell you later. Because somebody gonna be caught on that we is talking in code. Like, god damn. Not pig Latin, we talking in code. You know, or giving like strange looks. Our eyes meeting at the same time. That type of shit. It's crazy. But he's gonna have a hearing, a sentencing. It's gonna start on the 15th and the 16th. Now, he claimed that he got so many people that speak to him. He told me he got at least about 20. Hell, I don't think 5 was in the courtroom, including his mama. I believe his mama. And then it was so goddamn funny. And this is how crazy their ass is. Do they not know that those phones, the people be listening? And I'm gonna give you a little secret. If you want them high profile clients and they expect you are guilty as hell, and you look like you doing some bullshit, they gonna listen to damn near every call you make. Every call. Cause they gonna catch something. And I have no idea why the people and the operator tell you this call could be monitored. Or could be recorded. Or will be recorded, and they still hang themselves all the time on the motherfucking phone. I don't get it. I don't get none of that. None of it. I really don't. So, so what else? What was funny? Some of those people that testified was funny because they wasn't feeling all of that. You know, he don't give consent to be called by that name, Daryl Brooks. They didn't give a fuck about that sovereign citizen shit. They were like, fuck that, it's you. It is you. Oh, that was he, you know, I thought that he would have, you know, if he would have gotten out his own way, he could have, even though the prosecution had him, right? He could have tried to hammer home that he blew his horn, and also the fact that why did he go faster, you know, whatever. You know what I'm saying? He could have tried to build some kind of reasonable doubt to try to get up under some of those charges. Because 1 or 2 people said they did hear a horn beeping. But one thing I was surprised that the prosecutor didn't say that, well, it could have been somebody else blowing their horn, right? To kind of really, you know, put a nail in the coffin of that reasonable doubt. Well, it could have been somebody else's horn. How do we know it? You know, could have been someone else's horn that they heard beeping. Okay. but she killed him on the intent because she said, well, after you hit the first person or whatever, why didn't you stop? I also said he could have went with, there was a malfunction in the car. He tried to raise that. He didn't stick with that. He was in his own way. You didn't understand that when you craft a defense, you got to stick with it through and through. And again, you got to look at it on both sides, the pros and the cons on both sides, the good and the bad. Well, if I say this, what would they say? You got to do the what would they say and have your answer prepared for what would they say, so the case can go, without any interruptions. But he rather do all his diversion tactics, right? He thought that would be dun 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 dun. It is, man. What's good with it?
What's good? What's good?
What's good with it?
What's going on?
But it was so funny. I had caught the ending of your live, and it was so funny. I had got over. I said, "Damn, he must be smelling my goddamn trail," because I'm I'm just catching in on your damn remix shit. I'm like, what the fuck? What the fuck? And I was like, boy, if he don't stop playing that boy trying to say anti-Semitism, I am done. No, anti-Semitism.
But you see how but you see how he put rule as rude. And I was, you gotta listen to it. You just, oh man.
Yeah, I had peeped in. I was like, Lord have mercy. That boy trying to pronounce that word. Just let it go. If you ain't known for reading, don't try to read. We are used to it by now. Shit, we know that you ain't gonna get the words right. Leave it the fuck alone. You ain't got nothing to prove. You got to figure that out.
Right.
You ain't got shit to prove. But leave them words alone.
Right.
Shit. Leave that shit alone. Leave it alone. You bringing it up. You proving.
And he broke it down and said separatism.
Yeah.
How did he break it down like that? Separatism. I'm like, what?
I don't know what. I'm like, where are you getting the P? Like, what is going on? Where is you getting the P? Oh, okay. I was like, yeah. So,
have you read his community wall or tried to?
Boy, I can't follow all this shit out here.
If you read that community wall, you're gonna need Hooked on Phonics dummy edition.
Well, that's normally what happens when you do read it. You're like,
But as far as that case, it was interesting from as far as I got so far. Because I went back and I've been skimming through it. Very interesting.
Right. It was.
And he did a lot of mess ups. A lot. So
yeah, not to cut you off, a lot of people were saying that he's crazy. He a little crazy.
No.
He's more full of shit and a con artist. He a little crazy though. And one reason I think he's crazy, and he definitely got a personality disorder. One reason I think he's crazy because who the hell just run over motherfuckers? And I think it was more people got hit than the counts they put on. But those were the more serious ones they put on. I was like, yeah, I mean, 6 killed and 70 something injured, 71 or 70 injured. Like, that's crazy. They said they picked the more serious ones to charge him with. I'm like, what?
But now watch this though. If he would have really studied why he was locked up waiting to go to trial, instead of trying to listen to them Aryan Nation guys, but I told him that he a sovereign citizen. If he would have studied, he could have had that whole case thrown out.
How you say that, Dana? Because here again, I mean, they got the evidence.
Yeah. See, the thing is this. He could have got it thrown out on basis of venue. nothing else, but on basis of venue. If he would have went as a natural man, they would have charged him, but they wouldn't have been able to charge him with everything that they hit him with.
Now
As a
tell me about the
natural man.
Now tell me about the natural man.
All
And
right.
how does that differ from sovereign citizen?
All right, so here's the thing. Sovereign citizen, that's a terminology or a group of people, but that's been deemed terrorists by the federal government. And because they take paperwork from the indigenous Indians and they take it from the Moors, and then they try to add stuff into the paperwork, but to try to fit them. Sovereign citizens believe that they are above any law. They believe that they're above any jurisdiction. A natural man don't. But a natural man know, but matter of fact, a natural man know that we are governed by the Constitution of the United States. And I'm not talking about the corporation. I'm talking about and the Republic of the United States, or should I say the Republic of America. The sovereign citizens, they believe that no matter what they do, they can't be penalized. And the natural man knows if you don't follow in the Constitution, you can be penalized. Prime example, if a natural man applied the paperwork right, police officers and sheriffs cannot come lock him up. It have to be marshals or deputy marshals, but I have to do it. And you can't, okay, let's take me for example. If I violate any order, right? Or if I violate any constitutional law, the marshals and will have to come get me, and they will have to go through the attorney general, and it will have to have a wet seal signature by a federal district court judge. And it's like, whereas though, let's just say that you live by your social security number and you live by your birth certificate. Let's just say that you call yourself a sovereign citizen. A regular sheriff can come get you due to the fact that you have not reclaimed in your birthright. And that's where it all starts at.
So let me ask you.
Once you reclaim your go ahead.
Oh, I'm sorry. So when you was showing the paperwork and stuff like that, that is that was the question I was going to ask you. That is connected to you being a natural man, not connected to being a sovereign citizen.
No,
okay.
But it comes. See, the thing is, and the sovereign citizen, is really an Aryan Nation movement, but it started in jail. A natural man, and we got to go get our certificate of live birth from the Department of Vital Records, and from there, for the second step is, and we have to go to our state comptroller's office, and we have to get it validated there. Then from there, and we got to send it to the White House, which sends it over to the statuses and department of the military down in it's like a part of Virginia. Matter of fact, it's like a lower part of Virginia. And then what they do is they validate all your stuff, and if everything checks out, and they will do this kind of funky little stamp thing. And from that point, and you cannot detach none of the records. If you detach any of that, you can go to jail and for treason for the rest of your life. But that's why every time I got to show it, I will go make a copy of it, and I will keep that paperwork. I will keep that paperwork in a house in a file. So it's like, just like if they try to claim jurisdiction, they only claim in jurisdiction over the name, but they claim in jurisdiction over the corporation. I can show you one of my IRS forms that I had to do for my new job. But I had to do a W-8 bin. I can show you one of those, and it clearly states in my real name as the corporation, and it states my name but it states my name in all caps as the corporation. Then it states and my name in proper form as the trustee.
Okay.
So it's a process. And it's like, and that's why I get upset. And when people be like, oh, sovereign citizen, and I'm like, man, only if you knew the hell that I had to go through and that I still go through, because a lot of people don't understand that you are a walking bank. You are a walking trust. And it's like one of my homeboys did it recently. He just had a baby, and I told him, but I said, yo, go get your placenta and take it home. And he was like, man, I ain't doing none of that. So then when he finally talked to the nurse about it, and she told him, oh, you making sure that your offspring is alive. And he was like, huh? And that's when he called me. Can I talk to the nurse? And the nurse lady was like, man, matter of fact, help your friend, because you know what you're talking about. I was like, yeah. I don't want none of my friends' offspring to be civic divorce. And civic divorce pretty much means dead at sea, but that's all it is.
Right, but now, but natural persons though, they still, okay, how to say this? They are still held and bound by legal, natural, and human rights.
Constitution only. Constitution only, and sovereign belief. And the sovereign and belief is simply the Bible. If you believe that you came from the earth, if you believe that there's a God, if you believe that Jesus gave his only begotten son, if you believe that and you wasn't hatched or created, but you were made, and that you were born into the earth and not created and pushed into the earth, yeah, that's natural man.
Oh, okay, because see that's about all I can remember from back in the 90s about natural, about all I can remember, that they still have the natural, the legal, and the human rights. Okay. Yeah.
Right, and see,
So
and that's how they catch people. And that's how they catch people. Not to cut you off, but that's how they catch you, because they have you come to regular court. They have you come to like a magistrate court, and then they ask you, but they give you like trick setup questions, like, but they ask you like, can you stand? If you stand up, trust me, they're looking. They ask you, can you swear in? If you swear in, but they got you. Then they ask you, sir, ma'am, do you understand why you here? As soon as you say yes, you already done gave them jurisdiction. But that's why, like, all right, but like, prime example, if I go to a magistrate court, right, I have to either in 15 minutes and before the court case start, I gotta give the judge a special appearance, or I gotta put it on record. But if I put it on record, I gotta put the judge's oath of office on record too.
So let me ask you this. So do you think that he got kind of confused, or he conflated the sovereign citizen with the natural person thing? Or is the natural person, is that a part of the sovereign citizen's indoctrination?
No. See, that's totally different.
Okay.
It's different, but it's a very thin line, slightly online with it. And I'm gonna tell you why. Sovereign citizens take paperwork from the Moors, and they take it from the natural man, and they combine it together. Prime example, a sovereign citizen will tell you, oh, we don't have to abide by the statutes, right? But they'll show up in court without proper paperwork. They will, but a sovereign citizen will tell you, and my name is John Doe, right? But they will spell their name, and they will allow you to spell their name in all caps. Pretty much what they try to do is what thieves try to do. A sovereign citizen try to live public and private and together, and you cannot do that. A natural man lives totally private.
Okay.
A sovereign
Oh,
citizen to tell you, but a sovereign citizen to tell you, I don't have to pay taxes, but don't know what paperwork and to file for you not to pay taxes. And you can't do that. A
right.
sovereign
Because I
citizen,
just go ahead.
yeah, but a sovereign citizen to tell you, oh, I'm exempt from the tax system, but they still using social security cards and they still using birth certificate QSEP numbers and they still getting and they still trying to get taxes. No. If you really trying to make that movement right, if you really trying to live the natural man, I can't use a social security number. If I do, I go to jail. So what they do with us is they give us a 98 EIN number. And a 98 EIN number is nothing but an but it's an offshore non-citizenship workers number, just like your social security number.
Right, right. Wow. I know, that process was so, you know what I'm saying, involving because it seems like that I don't know who his advisors are with this. And again, oh, well, let me ask you this. Do you know
Mhm.
if he was claiming to be a sovereign citizen before this, like, maybe in some other his other court matters or whatever, or do you think that or do you know if he just picked this up? I think he probably just picked this up since this case because he was reading a lot of, when he say but whatever his spills are, when I such and such, he was reading it, and most of these people, I like the clips I've seen and the
Uh-huh.
three occasions I've seen it play out in court, those people knew that sovereign citizens routine or rant right off the top of their head,
Right.
blah 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 blah. He had to read it over and over, you know what I'm saying? Like he was reading something, you know. So
Right. And seeing here's my thing.
Go ahead.
Right. And seeing here's my thing. If he this is what I believe, just by me watching a little bit that I watch, his tactics was nothing but Aryan Nation. That's the stuff Aryan Nation do. And but they get in the court and they try to intimidate you, but they try to stare you down. But that's all Aryan Nation. But that's why I say Aryan Nation was the folks that probably got to him and was like, yo, say you're a sovereign citizen. At that point, and the judge could have really flipped that damn courthouse up. And she could have hit that panic button, but that's up under that desk. And she could have just talked a little bit and her phone would have came and she could have switched jurisdictions on his ass quick and then had him locked up right there. Matter of fact, at that point, but that he said he is sovereign citizen, she ain't had to get a verdict. She ain't had to do none of that. She could have had him locked up and got him for treason, and then got him for terror.
How's she gonna switch jurisdiction? She's in the state. How's she gonna switch jurisdiction? She's in a criminal court.
Okay. Once a judge get on the bench, right? They can switch jurisdictions just by asking you different questions and sucker you into whatever jurisdiction that they want you in. And because 9 times out of 10, when you go to court, it's contract law. But a judge would get mad at you.
Keep going, Dana. Wait a minute. Go ahead. I want to hear you. I want to hear this logic. Go ahead. Go ahead.
No, I'm just saying, but a lot of stuff is contract law. Honestly, a lot of stuff is civil, and a lot of stuff is contract law. It took me a minute and to really understand this part of it, and because I was like, how's it contract law and they saying that it's criminal? Well, in his case, it's contract and criminal, and because he hurt somebody of the United States. If you understand what I'm saying, he hurt somebody from the United States, and that part he hurt and killed a couple people from the United States. If you really look at it, you're nothing but collateral to the United States. So that means that in the United States, you said that 6 people died, right? Yeah. So that means the United States took 6 losses. and they can't collect off of that social security number or QSEP number of them 6 people. That means somebody gonna take a hit. And that means since somebody gonna take a hit, you're gonna spend the rest of your life in jail, if not the death penalty.
Well, when you say she can change, are you talking about change jurisdiction, like what, between personal? No,
And
I
between
don't
laws,
understand.
she can go. You was right. You was right. And she can go personal, and she can go maritime, and she can state contract, and she can go deep criminal. It's so many ways she could have played with that, but for her to play with him that long, it scared me because I thought she was really scared. Because the way she kept saying, "I don't feel comfortable," I'm like, "Whoa, man, get him out of here then." And the man already said that he was a sovereign citizen. Just go ahead and hit that panic alarm, but then have the marshals come and get him.
Well, the only way she could transfer jurisdictions is if it's a venue issue. But like, but with the state, when you kept talking about subject matter jurisdiction, that's typically normally seen, and I'm not going to use absolute, because sometimes it could happen in state, but normally that's federal level. With when it comes to the state, it's either going to be a civil case, that's a jurisdiction. It's either going to be a criminal case in that state, that's a jurisdiction, or like that. But it's, so it has to be a issue with the venue to switch jurisdictions. She just can't, hey, I'm gonna change jurisdiction because it's in the third.
Well, no, she could have changed it on a bench, and she could have changed it on a bench. It all depends on it. It all depends on how deep he's willing to go. Because I'm gonna be honest with you, I went to but I had a child support situation, right? And they was trying to prove that I was in contempt. So what I did was I had text messages and everything, stubs, pay stubs, and all that, showing that I take care of my, offspring. I just don't go through the agency. So then the judge was in conflict about it. And because the judge was like, I really don't see what's going on. So I guess, and I'm gonna be honest, this was like my second time going before a federal judge in this case. And a case like this, so what I did, I prematurely asked them for the bond. And when I did that, that judge went the hell off on me and like, "Sir, you don't ask for no bond in my courtroom. You know what? Better yet, you come back at 2:30. So then when he got up and walked off, I was like, "Look, y'all see the judge leaving bench?" And the judge came back and said, "You know your stuff. I'm going to dismiss this case." But then he told me, "You can't come back in my courtroom if my courtroom is full." But that means I can't come back in your courtroom then because I don't have a witness. That's what I mean when I say there's a lot of rules that the natural man has to follow, that a lot of people be like, "Yo, y'all stuff tight, but man, y'all got more rules." Yeah. Whereas those sovereign citizens don't have no boundaries, no rules.
Because that's just a belief. But well, like with maritime, you can't be, which is admiralty court. That's like if something happened in the water, so you couldn't switch jurisdictions like that. If it's state to state, if there's another pending case in another state, you can switch jurisdictions if the judge learned of that. Or if it's like something with the foreign matter, you can switch jurisdiction, that'd be international, something like that. But
but see, that's when it mainly happens, though. That's when it mainly happens. And by him saying that he was a sovereign citizen, that allowed her to switch jurisdiction, because now you're telling the court that you're not civic divus, that you are born on the land. Well, a lot of people don't know that a lot of the child support stuff and a lot of the murder stuff and a lot of the civil stuff is really, civil stuff is contract. child support is contract. Murder is really in between maritime and what is that other one? Shoot,
How murder gonna be
because the
maritime?
crossbreed of all
Maritime
of them.
is the war. Is on the sea. On the sea.
Because
Maritime
remember,
is usually for the service.
right,
Shit happening in service.
right, because remember, you're dead at sea if you didn't reclaim your birthright. So that's what they automatically thinking once you coming in, but they thinking maritime, and because you're technically dead at sea.
Who dead at sea?
And
Now wait a minute. Hold on. Wait a minute. You saying
all right,
that
all right,
somebody's belief
back it up,
system that they dead at sea? Go ahead.
back it up, Angie. What it is that when you don't do what you have to do after giving birth, mamas, after giving birth and everything, you're pronounced civic divorce after 5 days. 7 days is the 7 days is the closure. 5 days is the cement of it. If you don't, one, get your placenta, after that 5th day, they attach a social security number to that placenta. Then they give you a birth certificate, but you didn't sign for a birth certificate. You signed for a certificate of live birth, but they switch it because that certificate of live birth is a bond and they collect on it on Wall Street. Second of all, the social security number. That's part of the Social Security Tax Act and all that stuff. If you look at the back of your social security number, it'll be a red QSEP or a black QSEP. But if you read the fine print, it clearly states it don't belong to you.
Mm-hmm.
So what they say is you are civic divorce, which is dead at sea. And dead at sea is maritime. But if you reclaim all your stuff, just like if you go to a hospital and you give birth, and they ask you, oh, you want to record your a child's name there? Tell them no. Because what you're supposed to do is run your ad in a newspaper saying what your offspring name is and the weight and the length and all of that. And you run that ad and for 14 days. Once you run that ad and for 14 days, that's your natural clause. And instead of you getting a birth certificate and a social security number, and you would get a direct certificate of live birth. And then instead of you getting a social security number, and you would get a EIN number. And then it'll be up to you if you want to switch your offspring's EIN number to an offshore off account 98 EIN number.
Yeah, but some of that, some of that is only like a theory or beliefs when it comes to admiralty law or maritime law, you know. So a lot of that's not a legal argument. So that would be dead in that court.
Well, no, because a lot of it falls under the Constitution. And if you really look at it, and the Bible is nothing but a theory, right? The Bible is nothing but a belief. But the true country is built on what? The belief of the Bible.
Yeah, but this is just my theory. This is what I teach, and you know, when I found some others that say this, some philosophers that say this, that our legal rights were derived from human rights and natural rights, right? And I believe that a lot of those rights, the human and natural, come from the Bible. You know, and
it wasn't.
You know.
Well, it wasn't no.
Go ahead.
Yeah, but I was saying it really wasn't no human rights at first. It was all natural rights, and it was something called inalienable rights.
Right.
When the corporation came in, that's when they start putting human rights and 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 personal rights and property rights and that's all they was doing was taking and trying to break down the inalienable rights. But the inalienable rights can never go nowhere because they the rights that's given by God. I'm gonna send you something. Matter of fact, I'm gonna send you something tonight for you to look at. But I'm gonna send you a chart, a whole breakdown chart.
Okay. Because, you know, like, and I do remember this, you know, during studies that a lot of stuff, when it comes to the law and what people believe in, whatever, is just pretty much, you know, their theory when it comes to, you know, those different groups. Now, I do know sovereign citizens. I do know that they are on the they are watched by the people that handle, you know, the feds that handle the domestic, you know,
Yeah.
the domestic issues. You know what I'm saying? They're on those lists. I don't want to call the list out. Almost did, but they're on those lists. You know. So, and I didn't know, and to this case, really, I didn't know that they were that radical. I know they, you know, they're on that list or whatever. We weren't, you know, told much about that stuff or whatever, but I know that they're on those lists. I didn't know till I was looking at some of the, you know, some of the stuff, whatever. Because I was wondering, I was like, well, damn, where is he getting some of this from? Because I know he was factual incorrect when it came to the law, because it kept raising maritime, you know, admiralty courts and stuff like that. I'm like, dude, you're not at sea. You're not, this didn't happen on the water. It's not a dispute that's going on between two countries, whatever. So you're raising that, and it's not a legal argument. And I think at one point she finally told me it's not a legal argument. But so now I was like, what is going on? Where is he getting all this stuff from? You know what I'm saying? I went to look, I was like, oh Lord. And I looked at some of the other cases, and I was like, oh, okay. These people did some radical ass shit, you know.
Did you ever see the case? Did you ever see the case of the Virginia shooters?
Virginia shooters.
That it got so bad that they scared the judges off the bench, and they was able to go free, and they lived like 2 years after that, and before they end up getting killed. Well, it's a sovereign citizen couple, and they was going around killing sheriffs, and it came out of Virginia. I read their case, and I was like, oh hell no. Man, I'm gonna pull that case up and I'm gonna send it to you. I swear you're gonna think I done lost my mind. When I read that case, I was like, ooh, I could not ever be a sovereign citizen. Oh no.
That, you know, it's a lot of radicalism that, you know, that, you know, the cases that I put, I was like, what? I was like, oh god damn. I just thought, and here's the thing, right? A lot of it don't take much to end up on the watch list. It don't take much.
Right.
Okay.
Right.
It don't take much.
Right.
So for your ass to end up on there. But so, you know, so that's why I looked to see, and I was like, god damn, they did some radical ass shit. You know, so no wonder, you know, hell, they are groups that are actively watched. They actually but they are. But, so, you know,
but you're right, Angie. You are absolutely right. Anybody that considers themselves a sovereign citizen, just like this Brooks guy, by him tagging himself like that, I guarantee you, once he left that courthouse, he's in a cell by himself. Or if not, but they put him on a cell block with the Aryan Nation, because Aryan Nation believes in sovereign citizenship. And I'm just saying, it's impossible. How can you live public and private at the same time? Courts thrive And the only way a court can live is off of arguments. If you don't have no argument, the case can't go forward.
What you mean? Talking about the defense?
I mean, all right, like let's just say that me and you had an issue, right? Let's just say that me and you had an issue. And let's just say that you wanted to sue me. And you gotta have the legs to the table to sue me on. And if you can't put all them tables out there, and the lawsuit ain't gonna go forward. Just like I gotta come back with an argument just for it to be a case. If I don't have an argument, and if I present a continuous acceptance, it ain't nothing the judge can do. And because I'm trying to offer you a remedy. But in order for you to get the remedy, and you got to prove that I did whatever.
I don't know about that, because listen, they're gonna ask you a couple questions to decide how you want to go. If the if she decide that case want to go forward, it's gonna go forward, whether regardless of what you put in. That's just if they have
Mm-hmm.
everything they need, to prove that a case should go forward. That if they have it.
Oh yeah, if they have everything, it's gonna go forward, no matter what.
No matter what you put in. So
however,
however,
Angie, and the number one thing that people don't understand, if a court don't have subject matter jurisdiction, or if a court don't have any type of jurisdiction, the case is over.
Well, yeah, you got to have a jurisdiction. You got to have jurisdiction.
And a lot of people. Oh, I'm sorry. Go ahead, Angie.
Go ahead.
Yeah. And I was saying, and a lot of people give up their subject matter jurisdiction.
How to do that?
One, and you give it up by showing up, and without paperwork stating that why you there. Two, and you go under the understanding of why you there. Three, you go by the agreement of swearing in. All of that, you falls under that jurisdiction. Even if you cross that threshold, it's like the lower door that you go to stand in front of the podium. Even if you cross that, and without your paperwork being put in, if you cross that, you're now under their jurisdiction. Some judges are
they can give you, they will give you legal rights, right? So, and when I say rights, I'm not saying that
right.
You got a right to not, right. I mean, legal rights mean they can enforce.
Right.
And legal right is an enforcement, regardless if you without your consent. They don't need your consent.
Watch this. You can only enforce it if you have proper standing to enforce it. You can't enforce something, and you can't enforce something if there's no proper standing. However,
and that's
a lot of
jurisdiction, right? That's when they ask for jurisdiction.
Right. Yep. However, and you got some judges who will try their hand and try to enforce it anyway. And then when you take it to federal, that's when you immediately take it to federal court. And you don't waste no time. You don't do none of that. If a magistrate judge or a state judge forces his hand and trying to apprehend you, the minute you get free, you go ahead and you take it and you switch the venue and you take it to federal court. And then you sue them under color of law.
Wait,
9 times.
Go ahead.
Huh?
Go ahead.
9 times out of 10, once it reaches federal court, your whole case is going to get dropped. If you have the proper standing on while you're doing it. But if you just putting mumbo jumbo stuff there. Oh no, that's not gonna work.
But and when you're on the state level,
you gotta have case law, huh?
No, go ahead.
Yeah, and you gotta have case law dealing in the feds, dealing in superior court, and you gotta have case law as well, but not as much. What I found is that district court is more lenient, but it's more strict. Superior court is more freestanding.
Hey, Miss Angie.
Hey, yes, ma'am.
That guy was nuts. I mean, really, freaking, really. That judge, I have to give that judge the Medal of freaking honor for dealing with this dirtbag. Dang, the way he tried to take off his clothes, the way he tried to say he's a sovereign citizen, which didn't freaking work. And then he tried to. What else did he try to do? He said about jury nullification. The judge told him, "Don't talk about jury nullification." I was watching that whole stupid trial. That guy still to his own face. He's going to be like 900 years in prison. He's going to be somebody's woman. He's going to be somebody's woman for 900 years. And I have to say to you, Daryl Brooks, don't drop that soap, please. You're going to be in there. We're going to be in there with guys who don't care. And I suggest to you, Daryl, you better get a soap on the rope and tie it around your neck. Because if it happens to drop, you're on your own, dude.
Ms. Hicks.
Yes.
But I heard you say that he asked for a jury nullification.
Yeah.
What was his grounds for that?
I don't know. When I heard the judge say that, don't ask the jury about jury nullification. That was his reasoning. That was that.
Do you know how dangerous that is?
Yep. And the judge said that she had to tell him because they were going to bring the jury in, right, for the verdict, and he wanted to ask him about jury nullification on his closing argument, and she didn't allow him to do that.
It's too late to ask for it then. Jury nullification, pretty much. Jury nullification, and you pretty much
I don't know much about jury nullification, but
are you pretty much asking the judge?
Yeah.
Okay. With jury nullification, and you pretty much asking a judge to determine if you can get a trial by jury or a jury by trial. Is a difference. I always thought it was the same thing. I always thought it was the same thing. But no.
The first mistake he made was he should have never been his own lawyer. They always tell you, don't ever try to be your own lawyer. Have lawyers that's with you.
Not true. But I'm going to tell you why I say not true. I'm going to tell you why I say not true. Because when you hire a lawyer, you are now bound by the contracts of that court and by the bar. So, and the first thing a lawyer job is, matter of fact, a lawyer job is supposed to be to you first, but no, it's the bar first, then come you.
May I ask a question? Why did he just because the judge asked him, because the judge told him that if he gets rid of his lawyer, he's on his own. Is that right?
He shouldn't have had a lawyer from the jump.
Huh?
Yeah, but when I first started my live, I said because ain't no lawyer was gonna, go with no sovereignty defense. So probably had to get rid of them. Yeah,
that's what that guy said. I'm a sovereign citizen, and every lawyer that I saw on court TV said that hardly ever works.
Because see, first of all, it's a difference. Sovereign citizenship is nothing but terrorism. And that's why I say what I say. Like, a lot of people got to get it misconstrued. A natural man and a sovereign citizen is two different things. If he would have went in as a natural man, dude, you still probably would have got about 30 years.
Well,
But
he's looking at 890 something years.
but I'm gonna say this, and the reason why
Yeah.
I say 30, because he would have got 6, and for everyone that got killed, that's 36 right there. But then he would have had
Yeah.
some stuff chopped down due to the fact that his medication. If he could have proved that the government didn't want to give him his medication, because what I was hearing people say was he used to be in the military and they withheld his prescriptions.
That's wrong for
Well,
holding some
if
people's
that's
prescriptions.
if that's the case, matter of fact, if that's the case and he could have proved that right
Yeah.
there, it would have weighed a little, but you still would have did time. And because you injured 6 parties and you
Can I ask?
injured property
Yeah,
of the United States.
yeah.
That's
And he
why the
ran
United
over
States
people that
brought
didn't know
charges
who
against
he.
you.
May I ask a question? Why didn't he just keep his regular lawyers?
Well, I just told you.
He wanted to, yeah, he wanted to pursue that,
Yeah.
Yeah.
that line of defense. He wanted to pursue
Yeah, but
that.
it was so ridiculous how he
Dang.
didn't handle it very well, I don't think, Miss Angie. Because when I had it on I was
I'm gonna
watching it
tell
on
you.
my show, and I said on Hammer Nation show, I just thought he handled his case all wrong, and the prosecutors didn't care what he was going to say, and they was going to nail his butt to the wall either way.
And Ms. Hicks, check this out. Once
Oh,
you
I've
get
seen
under
your
that,
show before. I've seen your show
one-
before, James J. I've seen your
okay,
show.
yeah. Once you get under them lights,
Yeah,
once you get under them cameras,
yeah.
I'm gonna tell you, it's a different animal once you get in that courtroom. And you
Mm.
might talk all this stuff outside that courtroom, but once you get in that courtroom, you have to be laser focused and you have to pay attention to every word. One little word will change your whole life around. And we seen that in the R. Kelly case.
Can I ask you a
And
question? Could have Daryl Brooks handled his case any better?
yeah. Yeah, from what I see, he was sloppy.
Yeah, he
But
was.
if he was tactful, I'm gonna be honest with you. If he was tactful and really sharp and really studied,
Yeah.
he would have got some time, but he would have had a good possibility. I would say at least 45% chance of having that case thrown out.
Well, can he win
Man,
on
that case,
appeal?
was going nowhere, Dana.
No, it's not going to go nowhere.
How that case is gonna go somewhere? He is driving the truck that's
Yeah,
killing
he was
people, and
driving the
people
car.
saw him. And
Yeah,
you
he was
think
driving the car.
what?
It killed a whole bunch of people.
Listen,
Yeah.
That, you ain't polling the R. Kelly sector. You ain't asking the people over here. All right, now you ain't
Yeah.
no,
asking, you asking people that ask.
no, I'm just saying. That's why I
Dana,
said 45%, Miss Angie. But I said
Dana,
45% chance.
That's way too high.
well,
About 10%.
Mr. Dana, I'm
Mhm.
I'm sure you've seen my show a lot of times, I guess.
Yeah, yeah.
Oh,
But
you
I seen your
have.
show a couple times.
Oh, you liked it then?
But I watch everybody.
Yeah, but I'm just starting out. So I just did a Halloween playlist, but I just wanted to say that I hope you ever around my show, and I would gladly like you. I would gladly like to
Yeah,
invite you.
I'll
Huh?
definitely drop in. But I'll
Oh,
definitely
thank
drop
you.
in.
But I just didn't think he handled his case very well because the judge got tired of his antics and threw him to another side of the courtroom and everything. And it just seems like he just could have handled it a little bit better. But now he's looking at 198 years in jail, in prison for what he did.
So let me ask you this. Let me ask you this. Why did the
Yeah.
judge have to remove him from the courtroom?
I think he was trying to make his points. He objected a lot of times, and she got fed up. She got fed up was because she was, and then she got really scared when he was staring her down. You know, like this mean face look on his face, like this. Remember Angie? He was staring at her like this.
Watch this. A judge cannot, and I want you to look this up. A judge cannot regulate how many times a person objects in a courtroom.
Not because he
Granted,
objects. It was because he was being disruptive.
Yep.
Oh,
He
okay.
Yeah, he was being disruptive. He was just almost cursing her out, and and he was staring her, and he was staring her down like he was about to charge or something. And so she
Did
put
he
him in
ask for?
another courtroom.
Did he ask for her oath of office?
Yep.
Huh? Yep.
Did he ask for her oath of office?
Yep. He went down the whole checklist.
Yeah.
What was her response?
I think she gave it to him. I think she gave it to him, I believe.
It was just
At that point.
It was just messed
At
up.
that point, he could have challenged everything and said that the court had no standings. And
Well,
because at that point she voluntarily gave up power of the court.
Can I ask a question? Can he win on appeal?
Let me see if she.
Hell no.
No.
Hell no, he ain't winning on no appeal. But they won't even give him a appeal.
No, I don't think
He's
they'll
not
give
going to
him
get an appeal.
No.
And the
No.
reason why he's not going to get an appeal is because even if everything checks out 10 or 15 years from now,
Yeah.
he labeled himself as a terrorist. And the only way he will get an appeal is if he reach out to like somebody like Putin or somebody in a different country, but that's willing to come and get him.
I didn't see any of his family members in the courtroom.
His mama was there.
Oh, I didn't see her.
His mama didn't go.
No, she just helped him with the law. She just told him to apologize to the court.
So wait, so how was she able to say that he ain't take his medicine and all this if she didn't go?
I guess he probably told her that over the phone, but
did they get her?
Go ahead.
Hold on, Angie. Now you got me confused. But didn't she like testify as a character witness for him or something?
I didn't see her.
Or did she write a letter?
I didn't see her. I didn't see her anywhere in the court. When I was watching the whole trial, Dana, I didn't see his mother anywhere.
Oh wow!
I didn't see her nowhere. All that people that's was the police officers and the people that almost got ran over by him, but I didn't see his mother or nobody else in the courtroom with him. Nope.
So what about his kid's mom?
Huh?
Because I know his kid's mother took the stand.
Yeah, she took the stand. That's his ex-girlfriend. That's what I understand it.
So was she a character witness for him?
No, I think she testified for the prosecution.
What?
Yeah.
Oh yeah.
Oh yeah, she testified for the prosecution, Dana. Yep, she did.
So he ain't subpoena nobody?
Nope.
Yeah, he subpoenaed the the prosecution witness. It was crazy, but they were,
you can't subpoena the prosecution witness.
Yeah, that's why his case with him was not good at all.
No, in a murder case, you can't subpoena the prosecution witness.
Who told you that, Dan?
No, that's what I always thought. Now maybe I'm wrong, but I looked at a couple cases. I looked at a couple case laws where the subpoena was denied on a murder case, on a multiple murder case. Now, if you murdered more than two people, and you can't subpoena, you can't. I always thought that you couldn't subpoena a prosecution witness if it's multiple murders.
I remember on the Scott Peterson case, he wanted to subpoena that one lady Jill with the red hair, because he wants to get a new trial. I haven't heard nothing about that. I wonder if they gave him a new trial or not. Probably not. On her,
yeah, but that was only one person that got killed, right?
Huh? It was her
and the case.
Yeah, it was her and the unborn baby.
Yeah, but they consider that one.
Yeah, but they were trying to go after this lady juror with the questionnaire, or the red hair, the strawberry lady, and they wanted she lied on her questionnaire about being abused or something like that. and they wanted to give him a trial. I haven't heard anything about that. Did he get a new trial or not? I don't think he'll get one, to be perfectly honest with you. But if he does, well, I just wanted to say that Daryl Brooks was a real character. That's all I got to say. But I
Yes,
just
ma'am.
came on here to
Okay.
say hi to you, Angie, and it's nice to talk to you, Dana. I haven't talked to you
Great
and
talking to you.
since I came to the show, but I just wanted to talk to you and thank you for letting me come up here. And I have a learning disability, but I don't let that bother me at all.
Yes, ma'am.
Keep
Yeah,
going. Keep
I'm a
going.
56, I'm a 56-year-old widow, so everybody has made.
Listen,
Yeah, what?
listen to me. You
Yeah,
can defy the odds just by having faith and believing in yourself. Don't let nobody or nothing stop you. No matter how hard it is, keep pushing.
it was hard because I got evicted from my apartment when my husband died, and I had to help my late father help me through that, and I had to get this apartment for supplemental housing. So I've had this apartment ever since then. So I've
But you have a
had,
place of your own, right?
yeah, it's my own. It's my own.
Right. Right.
Yeah,
For
I had a
the
one
good Lord,
studio apartment.
for the good Lord, for the good Lord made it a way, but that you can have something of your own and that you
Yeah,
comfortable. That's all that matters. Keeping
yeah.
up
My
with the
grandfather was
Joneses
a
is not
reverend.
it.
My grandfather was a reverend. My brother and sister don't talk to me because of the house that my grandmother used to live because she had dementia and Alzheimer's and my aunt. But like I said, I have family that will support me and help me out. But I just wanted to just say thank you for allow me to say what I had to say about this crazy guy, Daryl Brooks. And I hope you come by my show sometime, Dana. That's all.
Okay. No
Thank
problem.
you. And peaches to you too, Angie.
Okay.
And peaches to everybody in Angie's chat. Thank you.
All right. Thank you.
Oh, Angie, you got to get off StreamYard.
Why?
And you got to come over to Melon, Angie.
Why come on the melon? Oh,
You got to come over to Melon. Stream.
shit, I'm
Well, StreamYard be
bad.
having you sound like you underwater quick.
Oh, for real? You can you hear me?
Yeah.
Oh, okay. Lord have mercy. So, what I was gonna say, shit, I don't forgot. So, okay, so as far as his mama and stuff, this is what I was saying.
Okay. Okay.
His mama did a interview with Court TV after the fact, right? And she was saying like, he got mental health and this, that, and the third. And
Okay.
him and his mama was on because okay, she had. Well, this is what the state said because they said they was listening to his calls, and they got they said they had reason to believe, that's how they put it, because it wasn't it hadn't gone through the process of going through the same determining yet that is what actually happened. But
Okay.
so they have reason to believe that somebody, one of his friends or one of the friends of his ex-girlfriend, sent pictures of of his girlfriend and either a baby or his grandbaby or some shit like that. And I think that the mama sent those pictures in. So the reason why I'm telling you that is because he at one point tried, when he questioned when he called the his ex-girlfriend as his witness,
Okay.
he tried to paint her, or he was trying to paint her as a bad parent by trying to suggest that their daughter don't live with her, but the daughter don't live with him either. So that's what the state had said. And
So who
he
did the
was
daughter live
saying
with?
that I think the daughter lives somewhere in Georgia or in Colorado. One of his kids live in Georgia, one of his kids live in Colorado. But
Oh
what they
man.
were saying, what they were saying that he was trying to paint her as a bad mother, as well as trying to say that she was writing him letters after the incident, because the incident started with him and her getting into it in the car. So he was trying to say that, that she wasn't afraid of him or whatever, because if she was, why was she still writing him? And the state was saying They don't believe that letter came from her. They believe that that letter, along with those pictures, came from an outside entity through his mother. So yeah, so it was a lot of shit going
I'm glad
on.
I'm glad you broke that down because that's the part that I stopped listening to, and I'm like, how did it go from murder to pictures?
Yeah, yeah, yeah.
Because
So
the way that the state was trying to make it look, it was like the mother didn't send the pictures, it was somebody else. And then I'm like, well, but I mean, but what significance would being sent pictures have on a murder case, a multiple murder case?
mhm,
I wasn't
right,
understanding that because I'm
right,
like, okay, even if she did send the pictures, how? And you have to, first of all, the state got the burden of proof, right? If you couldn't
right,
poke holes in their case, you're done. And then you help them by saying you're a sovereign citizen. So even if you could have destroyed the state case, by you admitting on public record you're a sovereign citizen, you're immediately going to be found guilty because now you're a terrorist in a court.
right. He see, okay, his whole like that was no way around him being convicted. And by him injuring those people, they have proof of the injuries. So when you got evidence of proof of the injuries and he caused it, the only thing, and this is why, um, you don't have, okay, you if you claim insanity, innocent by insanity, right? Insanity
Mm-hmm.
is a high burden to overcome. So
Mm-hmm.
so and you got to prove that. You got to have all the doctor, all that bullshit, and somebody to come up there and say your ass is crazy, right? But
Mm-hmm.
you can craft a defense around being, trying to get some type of reasonable doubt that you maybe had a mental break, you had mental issues, mental this, mental that, mental this, and hope that they will kind of see it as, you know your intent, that you would have the lack of intent. You can call into question the intent. You can call into question a lot of things, and maybe
Right.
you could get some of those charges off you, or if or maybe reduced, you know what I'm saying? But
Right. Yeah.
but some people don't like to go down that line, of defense because of the stigma. But fuck that, you trying to get off.
But let me
And
ask you this.
go ahead.
Let me ask you this because you're absolutely right. Let me ask you this, and before I say what I'm about to say, did he have any criminal history and before this?
Yeah, yeah,
All right.
yeah,
Was it
extensive.
extensive? Oh, he done.
Yeah,
He
yeah,
done.
yeah. He had
Because I was about to
he went
say,
to jail. He went to jail in Nevada, was it Nevada, for impregnating that 15-year-old girl. The
hold on,
girlfriend he got into a fight with.
hold on. So, so had was this did his record and reflect that he was locked up in different jurisdictions before?
Yeah.
Oh, well, look, even if he would have took a stand as a natural man, he still would have got time. I'm gonna be honest with you. It's only one way out of that I could have saw if he took a stand as a natural man, and it wouldn't have been and reciting no case law or nothing like that. He would have had to take the stand of he would have had to call of the United States of America to the witness stand to confront him. And because you
He
can't
tried.
do that,
Oh, go ahead. Go ahead.
no, I'm about to say, and you can't do it, and because the United States of America is a corporation, or the state of whatever, or the state of whatever state that he was in is a corporation. So therefore, he can't confront his accuser.
So
That's
let me tell you
why,
what he did. Yeah, go ahead.
that's why I'm saying if the state had witnesses, he's screwed. But his stance could have been the person and the person that's bringing the charges against him, which would have been the state of whatever state that he was in. After that, for the court would have been gridlocked. But I want to hear what he did. But I want to hear about this because this sounds like this
So
about to
let me
be
tell you
crazy.
what he did. On his subpoena list, right, that he gave to the state because the state was helping him, he did
Uh,
have the state of Wisconsin. And so he was trying to say, well, you know, is you know, in certain when certain witnesses got on the stand, he was trying to ask that question: is the state of Wisconsin here? And trying to say, you know, they're not a person, and go down that whole theory or whatever. However, you know, however they recite that whole thing or whatever, that didn't work. You
that's what I
know,
mean. That's what
everybody.
I mean when I say. That's what I mean when I say sovereign citizen bullshit. And because at the end of the day, if he's asking and the people that came on the stand, um, about the state, if you're gonna go that route, what you should have did was what he should have did was lock the court, and instead of and his questioning should have been, have you talked to the state of Wisconsin? If so, when was the last time you talked to the state of Wisconsin? They can't give you
He
answers for that.
Mhm.
But they can't give you answers for that. And the thing is, and the judge and the court, they're going to try to move the court along. No, you stay right there. And it's going to eventually make the judge lock the court. And that's when the change of jurisdiction going to come in at. Because then she going to try to get you to understand some stuff. And if she can get you to understand, then guess what? And no matter what you say, your jurisdiction is gone. That's why the first thing a judge will always ask somebody that's being somebody that's being if there's somebody being combative in court, and the judge always asks them a real easy question, and then say, "Am I understanding? And do you understand the question that I just asked you?" And as soon as you say yeah, and she'll say thank you, because now you just gave her back jurisdiction. But if he would have locked the court, it ain't nothing nobody could have done. But because he don't know that, he went and gave consent by stop asking that one question. In order to
He
bring a
tried.
court, huh?
Go ahead.
But in order to bring a lawsuit against somebody, that person have to be present. And a corporation cannot do business with with a man. They can do business with a person, but they can't do business with a man or a woman.
What, Dana? What?
The court. And the courts cannot do business with a man or a woman, but they can do business with a person. A person falls under corporate entity. That's why I said I'm gonna send you this chart and stuff, and I want you to
But
look over it, and we're gonna
yeah,
discuss
but
the
I
chart.
mean, when they, you know, when they write it up. But what I'm saying is, when it comes to personal jurisdiction and all of that kind of flies out the window. Because
No,
at
but
the
see,
state, well, I know what before Miss Hicks came up, I know what I was going to talk about. We was
okay,
talking about jurisdiction, like,
right,
you know, when it comes to state, you're gonna, you know, you usually gonna fall under one or two categories. You know, it's gonna be either personal jurisdiction or territorial jurisdiction. Okay,
or subject
subject
matter, right,
matter,
right,
that's normally, you know, not reserved for the feds, but that's when you normally see that takes place, because that's when they have the different, you know, courts, you know,
right.
whatever type of tax court or whatever, you know. So, but with state, you know, like I said, it's either going to be civil, criminal, It's
Right.
gonna be, all on, one or the other. So it's
Right.
pretty easy to prove jurisdiction there, but he asked for a specific jurisdiction, and because how she had to word it is not to sound as if she was giving him legal advice. So a lot of times she just had to
You can't
deny
ask for a
it.
specific, but you
Go ahead.
can't ask for a specific jurisdiction in the state.
Well, he was asking, but because he's not an attorney, we already know that it's
Man,
you're either going to usually fall upon the territory or the or personal or both. But so it's not really something that um, is challenged a lot. Now in federal court, you see a lot of times they challenge it because
right,
because feds have enumerated powers,
right.
all over these, United States. So a lot of times attorneys try to see if they can get one in there by challenging venue, because hey, this happened in another state. We trying to hear why, blah 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 blah, and then try to see if they can get a win that way. Other than that, it's going, the state is pretty straightforward. So he was, the thing about it is he had a playbook. I don't know who gave it to him. So he talked to somebody.
So let me ask you
And
this. Oh,
uh,
go ahead. I'm sorry. Go ahead. Go ahead.
no,
I'm
I
sorry.
said from the end of time he was in there, they gave him, a bunch of, information,
Right.
but he had no legal argument. He was arguing stuff that, you know what I'm talking about? He tried to challenge the judges. Oh, well, she, can only lose it like if she don't follow the law and whatever. So she didn't do, she followed the law. When she made her rulings and stuff, she gave him, normally gave him the grounds. If she already answered it, she would say she already answered it. She gave him some stuff in writing for her rulings. Um, she gave reasons why she denied his reconsiderations on stuff like that. But he called them redeterminations or whatever he called them. But he was asking for a reconsideration. He just
He
didn't
put
know
a
the term.
motion in. Oh, wait. Hold up. He put a motion of reconsideration in
No, he
during
was
his trial.
no, he was orally asking. He didn't ask for a reconsideration. That's the proper term. I forgot what he was asking for, y'all, or was it redeterminate? He was asking for
You can't ask for
a
that during a
review.
trial.
Yeah, you can ask, or you can do oral motions. You can do oral motions. She just
No, I'm
denied
saying, but I'm saying you can do an oral motion, but a motion of redetermination or a motion of reconsideration that have to be after your but that have to be after a determination and was already given in your case.
Right. So you're not talking, not after a conviction, not no. Anytime she rules, and it goes against whatever side, you can ask for a reconsideration, either written or orally.
But it have to be after she give her guilty or not guilty verdict first, right?
No, That's you could do a reconsideration after that too. But anytime a judge make a ruling, you can ask for a reconsideration of that. You can
But she
do it
really ain't
there.
make
You
no
can
ruling
appeal
at
it.
that time.
Huh? Huh?
But she really ain't make no ruling while she on the bench trying to hear the case.
Yeah. If she when he says judge when what was it, something whatever he asked for, and she said denied, that's her ruling.
Oh.
Yeah.
Oh, so he was asking for heavy stuff right in there, and she ain't had no other choice but to deny it.
Yeah, she was. Yeah, because he didn't have a legal argument. He didn't know nothing. He was just yelling at shit. That's what I call it. He was yelling at shit.
Yeah, he would have made me frustrated, man. And I would have asked him, like, dude.
Yeah, he got on people's nerves.
I would have asked him, like, dude, do you know what the hell you asking for? Because I mean, that's what makes it frustrating when it comes to these sovereign citizens and stuff. It's like they will mix paperwork and mix stuff up and don't have no case law to back it. You have to have case law when you're doing stuff like that. Just like in the paperwork that I submitted. Anything I submit, it have case law somewhere in there. I just, and you know, I'm gonna pray for the brother of mine, man, because it's weird. Like now, dude don't have no standing. He's not gonna get an appeal. If he can appeal it to a higher district, it's gonna go from state to superior. And then what is the odds of him getting a speedy trial in superior? And then if he don't get what he want there, he gotta go to federal district court. Then if he don't get what he want there, and he gotta hope for an appeal, and so and superior court. And Supreme or Superior, one is it? It's Superior Court. It's Supreme Court, I'm sorry. It's Supreme Court. But what's the likelihood that a Supreme Court is going to hear a multiple murder case? And you did it. If there's no infractions in that case, trust and believe, you ain't getting no appeal. You have to have infractions in that case.
Yeah, I mean, it got to be, appeal it based on issues of law, fact, or judicial discretion. So, but he
now let me ask you this.
Go ahead.
Let me ask you this, because now he can be petty. If they made an error on his name or anything on the paperwork, he can call for a mistrial. Just being petty, but what's the likelihood of him doing that?
He tried everything. He said he was scared about the COVID, like the jurors. He tried to delay. He tried every damn thing. Like some jurors with, I think, 2 tested positive for COVID. Then he got a problem with it, and he talking about now he can't taste or whatever, and then she has to take a rapid test. Every goddamn thing. He tried it all. I don't think he left anything else. I don't really think he left anything else. I really don't.
Oh, so 2 people tested positive, and then he all of a sudden got one symptom.
Yeah, so she asked him, said, well, did you take what kind? He said he got tested. I think he said he don't know the results or whatever. He said, well, did you take a fast response test, or did you take one or whatever? I don't know. And he also played the I don't understand game. He ain't understand shit. He claimed he ain't understand what he ain't understand. I was like, damn, they must have a set of objectives with this sovereign citizenship. Because he went down the whole list.
So what to me is that he took part of the Moore playbook, he took the natural man playbook, and tried to mesh it together. Sovereign citizens do. You saying that you don't understand? That's more. I don't understand. I don't understand. I don't understand. Once you start saying honor, I don't understand legal ease, but I understand everything the natural man playbook. What she could have did was easily got her. Can you write your name in cursive? That's another trick that the courts use. That's another trick that the courts use. Because if you can get up and write your name in cursive, if you can get up there and you can write your name in your corporation, because a natural member writes his name in cursive, a court always give you an autograph. It's only play, Angie, but that's it. It's wordplay. It's legal ease versus regular ease. It's wordplay.
Oh wow.
But I'm gonna send you some paperwork, and I'm gonna let you look over it. Watch, you're gonna be like, wow, that's different. And it's gonna have case law with it.
So so what you say the other thing is called you say more?
Yeah.
Now what is that?
It's more science teaching. Those are more science teaching. I really don't know too much about it, but that's more of the I want to say a Masonic, but it's not. But that's more of they're more I don't know how to explain them actually, to be honest. But they have a barrier and a code that they follow as well. And they follow under Constitution law and all of that as well. But some of their wordings are different. Just like prime example, and the Moors, they go in court under pro se. Natural man, and we go under sui juris. But when we put sui juris on our paperwork, and the court reporter, she'll always put pro se there. Until you get in court and you start wilding out, talking about, I don't know why they put me in pro se. Put me in sui juris, not pro se.
Oh man, why I can't think right now. I can't think. Y'all have to excuse me. I can't even think. Shit, I ain't done this shit in so goddamn long. I can't think. He tried to. He asked for. He was calling himself. For, for,
I'm surprised he didn't get up and say.
Anyway, it's the same as pro se. He had me confused. He really had me confused because a lot of the shit they say is based on theory. I was like, well, dude.
Wow. See that right there? That's enough to make somebody snap. Because you can't play in the courts like that, man. But because of state court, a lot of people don't respect state court because, child support court and state court is called kangaroo court. And a lot of people don't respect either one of them like that. And the reason why child support court is called kangaroo court is because they have limited jurisdiction, which means there's not a real judge there. That's nothing but a lawyer in a robe. That's why, matter of fact, prime example, if you look up an income withholding order, there's no signature on it. Can't no family court judge sign that type of paperwork. And that's what makes it not legal. And because anytime there's an order, but there has to be a signature, right?
I can't. What you say?
But I said anytime there's an order, there has to be a signature, right?
It could be added later though. Yeah, I mean it typically, as long as it's some type of date or something like that on there, like a
No,
signature can be.
it's nothing on a with. It's nothing on an income withholding order. There's no date. There's no signature. There's no nothing. It's just a typed up contract coming from the agency. Can't no judge sign that. Yeah, can't no judge sign that.
But if an order is in, I mean, if an order is in, that's what matters. If an order is in.
Now watch this. It's one thing to have an order, but I'm talking about for the income withholding that come from the agency. It's a voluntarily contract. That's why it's nothing on there signed. There's no date. There's no nothing. And it clearly says you agree to every term of this contract. And because guys are in fear of fighting against the corporation, they'll go ahead and sign it. Hell no.
But hold on. So now I'm getting confused. You talking about the print off you get from the clerk?
No. It's a thing that it's a 4-sheet of paper. It's a 4-piece of paper. It's a 4-piece sheet of paper that's actually sent to you from the agency. And 9 times out of 10, what the agency would do is they go get a stamp at the court saying that it was filed into the case.
Right.
But there's no signature, there's no date, there's no nothing but a judge. At the bottom, I think it's page 3. It'll be a page 3, and it'll say this is endorsed by. A judge can't sign it until you agree to it.
You know what? You and Miss Diana ran me motherfucking crazy, along with Mr. Brooks. What? Wait a minute. Okay, I'm telling y'all all wrong. Hold on. I'm telling y'all all wrong. Hold on.
Angie, this is what I'm gonna do.
Let me go back. Let me back because now I'm trying. Okay, that boy was asking for a Lord have mercy, Jesus, a review, Lord Jesus, a review. He was asking for a review. Y'all got me so goddamn confused. Now he was asking for a review. Review reconsiderations after the judgment. Review, he could do it anytime. Motion for review, he could do it or on the record. As far as what you're talking about, if it's a court order, but if it's a court order, that is the document that's going to have the judge's signature with its telling what the amount is going to be and whatever. You're talking about like some shit coming from an agency, right?
No, it's something totally different. All right. And child support, but they give you the child support order, right? In the child support order, right? It breaks down how much you got to pay and all that, right? So check it. So check it. What they send to your job is something that come from the agency. It don't come from the court. It's a separate piece of paper. It's actually 4 pieces of paper, and it's for your job to voluntarily have you enrolled into that system.
At the judge's order and direction.
No.
Yes.
No.
That's how they
listen,
do it.
sometimes you will get the income and withholding order and before you even go to court.
Right.
So basically, so basically it's a contract that they extend into you. And if you sign that contract, okay, you're there. I be hearing a lot of people saying, oh yeah, I know somebody that went to jail and because they didn't pay child support. That's illegal. And you can't go to jail for a civil suit. Child support is a civil debt suit. And you can't go to jail for that. And you go to jail and for violating the contract.
Right, but listen. But the agency has that authority to, just like
Says
the
who?
light bill, just like the light people and all that stuff. If you don't pay your light bill, that's an agency. If you don't pay your light bill, they cut it off and your ass still on.
Watch this.
Departments are agencies
What?
that have you know, the authority to garnish or whatever.
Watch this.
Mm-hmm.
People think that agency have that power because they contracted with the state. But you got to realize child support is not a state fund. It's a federal fund that the state benefit from. If you look at child support, it's nothing but Title 4D and Title 4A. And the same thing that's a Pell Grant. And your Pell Grant is Title 4A and Title 4D. So here's my question, Angie. If, let's just say me and you was together and I took your social security number and I opened up 9 credit card accounts and you got to pay for it. Listen, and you got to pay for it. That's fraud, right?
Right.
Okay, so how's child support not fraud? If somebody take your if somebody take your social security number down, but I mean down to the agency, and they open up a case on you, and you don't contract or give them or you don't give them permission, and they start building, that's fraud.
Well, but here's the thing, and I see where you're going with that. But here's the thing. Well, let me back up something. You and Mr. Motherfucking Time got me all confused today. With the state, okay, the state, the child support is from the state. The government, when it gets to that level, acts as a collection agency for the state. Oh, yes, they do.
No, you got it backwards. The state is the collection agency for the government. Remember, Title 4D and Title 4A is a federal benefit.
Hold on.
The state,
go ahead.
The state contracts with the agency. See, you about to make me go and turn on this computer and send you some stuff tonight.
Y'all got me all confused. Okay, the state is who's supposed to be collecting, who's supposed to be, collecting. When you fuck up with the state, the federal government get your ass on them taxes, and you think you're gonna get them taxes back, you got a child support garnishment coming out for that. Just like like if you pay your student loans or whatever, you know what I'm talking about. I mean that's federal, but you know what I'm saying, that part of the IRS and the federal government, they also act as a collection agency for some state debt, some credit card debt, depending on how you file it and all that type of stuff.
But the IRS is nothing but a contract debt collector, just like child support is a third-party debt collector. I always thought the IRS was part of the government. It's not. I always thought child support was part of the government. It's not. It's not part of none of the judicial branches. That's why they have to have you contract first. Prime example, when a little crazy lady pulled up my stuff and was like, "Oh, they terminated the case because they couldn't find him." Well, here's the thing. It's not that they couldn't find me. It's the fact that you can't bring me into your jurisdiction without my permission. And when I would never give them permission, but they had to dismiss the case.
Wait a minute. What you mean? They have consent under personal jurisdiction. They have consent to enforce the law on a person. What you talking about, Dana?
Okay, watch this. But I'm glad you said that. They have the jurisdiction to force a law on a person. But if I'm not a person, then who are you gonna force the law onto?
Okay, well, see, that's that extra maneuver stuff y'all be doing. I'm talking about the law. I ain't talking about that extra stuff. I'm talking about the law. Now, you're talking about personal
Angie,
jurisdiction.
Angie,
Y'all
it's
got
not
me all confused.
Angie, it's not extra maneuvering. No, it's natural standing. Let me ask you this.
I don't know what the fuck you're talking about.
I'm gonna ask you,
I don't know what the fuck you're talking about. All
Angie.
I know is, like that man said on that clip I said, so listen, you, the person you represent, and all them other people, y'all got 15 days in jail. Shit, tell the other person that you represent, and
Angie,
he got 15 days in jail too. Yeah.
Angie, listen. And tomorrow I'm gonna start doing the child support standing. I'm gonna start doing the child support series, right? I'm gonna send you the link to every last day. I guarantee you, and you're gonna be like, wow, I did not even know that. It matter of fact, it's a lot of stuff that I'm getting now that I was like, yo, this is weird. But it works. At the end of the day, what's going on now is now, and you seeing the collapse of the cabal system. Just like I used to say it a lot about the United States being a corporation, but I mean, but I'm gonna be honest with you. I really didn't believe it until I seen it 2 years ago when the United States went bankrupt and filed for bankruptcy. And I'm glad I kept those papers as well. But I'm gonna show you some stuff for the rest of this week, and you're gonna be like, "Wow, this is crazy." I'm definitely gonna show you. I'm definitely gonna show you some stuff.
But listen. The IRS is definitely, see, this is what I'm talking about. The IRS is definitely a part of the motherfucking government. Well, like what are
They are not.
what you talking?
They are not.
That is another theory. That's another
No,
theory.
no. But the IRS is a debt collection agency. They are contracted with the federal government, but no, they're not part of the judicial branch, and that's why the courts are scared of the IRS. And truth to be told, and the IRS is your best friend. Anybody that have to go, anybody that have to go through the IRS, I mean, anybody that have to go through the courts and they got to prove that the courts is doing dirty stuff, but that's all you got to do is mention the IRS, and the court's gonna leave you alone.
But the IRS is a part of the government, but it's an agency that was created to administer the Internal Revenue laws. So
They are debt collectors,
to enforce it. Yeah, well,
right?
I mean that's what they do. They handle that part. But yeah, so
Right. But I mean, but they're not part of the legislative branch. They are
well, it's not part of
they
the
are,
legislative branch, right?
and they're not part of the judicial system.
Right, but they were an agency created to carry out those laws.
Listen to what you're saying.
That's what I'm saying.
They are contracted with the government.
So then it goes back to having that thing with that the federal government enjoys, which is enumerated powers. In order
Right.
to have the power to create those agencies to go forth and enforce it. But see, y'all
There you go.
y'all with all that shit going on and what you talking about, the more people and y'all got me all fucked up. I don't know what bad information I was about, because y'all got me all fucked up today. I ain't done this in a shit. I ain't thought about shit, on this type of level in a minute. This is the bullshit I do. When I do sign in about 5 hours or a week for work, should I be trying to find out who doing what they assigned me? They assigned me doing little rookie work. Who shit doing breaking into shit on the goddamn internet and shit. Not none of this shit here. Hey, what the hell?
Man,
Y'all
when
got
I tell
all them
you,
theories. Y'all be conflating them theories into the law and doing this and doing that, whatever. And
it's
those
case law.
new, but I those attorneys that took the UBE, you know, I call them the new wave attorneys and shit. They are up on all them little tricks and shit like that be going on and whatever. They be on that bullshit. Motherfuckers that graduated in the 90s, we were like, what? What the fuck you talking about? Huh?
I'm gonna be honest with you, Angie. Just like now, in one of my cases, right? And the first thing I did is I made the child support lawyer excuse herself. I mean, recuse herself, and she put up a fight. But I put on record. When the last time you spoke to such and such? What firsthand knowledge do you have about this case? And she had to answer none. So what are you on a case for? And you can't tell me you come to represent somebody and that person don't show up. But I have a right to face my accuser. That's one of the legs. If my accuser don't show up, then I guess what? I can go about it one or two ways. One, I can turn it on the lawyer and make it fraud upon the court, or I can turn it back and just call for a mistrial.
But see, he tried to be slick and try to call the state of Wisconsin, knowing damn well that wasn't no person. And then he was gonna try to move to blah blah blah, all that stuff. And they was like, they was on that. See, they them the new wave, little Zach over there, little Zach look like he about 32. You know, he in the
see, he already messed up though.
He knew where that shit was coming from. He's like, They was like, you know, he was probably telling me, look here, that sovereign citizenship, let me tell him, give y'all y'all old asses over here in the scoop. Because some of them motherfuckers look like they graduated in the 90s too. Like, what the fuck? They come in with this bullshit. What the fuck?
So here's the thing. Here's the thing. Once he gave them jurisdiction more than once, anything he said after that wasn't going to work. And because you can't call for something after you already gave them jurisdiction, the state, the feds are not going to give you jurisdiction back once you give it to them. Once you give them jurisdiction, they ain't giving it back to you.
But dude, you keep saying giving somebody jurisdiction, like, dude, like it's gonna fall into a category. So it's not like you can't get nobody. That's a theory, Dana. You can't just give somebody jurisdiction. They already got the motherfucker.
Angie, watch this. That's what people believe. I've done it firsthand. And they had to dismiss my case. And because they didn't have subject matter jurisdiction. Anytime jurisdiction is challenged and the person that's trying to bring a suit against you say they got subject matter jurisdiction, by right and by law, they have to put it on record how they have subject matter jurisdiction.
He tried that.
And 9 times out of 10, subject matter jurisdiction falls under address. It falls under the county but you live in. Watch this. That's why they always tell you. But that's why they always tell you when you move, you got 30 days to update your driver's license. Okay, so watch this. What if you say you got jurisdiction over me and because I stay in Georgia, right? But you claiming I live in Atlanta when I actually don't live in Atlanta, Georgia, or Baltimore. You don't have jurisdiction. And the only way you can get subject matter, and the only way that you can get subject matter jurisdiction or personal jurisdiction is if I come in the courtroom and don't present no paperwork and follow by your rules.
Well, then Dana would either be then it'll go to personal jurisdiction or they'll just transfer it to the correct jurisdiction.
Here's the question: what is the correct jurisdiction? If
So
I'm a
you
natural
gonna
man,
live nowhere, but you gonna show up, but you gonna claim you don't live nowhere. Well, how you got the notice?
what? See, watch this. There's more than one way that you can skin that. Okay, let's just go here. Let's just say that.
All this shit seems illegal. Man, see, we going to jail.
Nah.
Go ahead. This whole R. Kelly between Levi and all gonna be in jail. See, Levi, your bullshit, we all gonna be in motherfucking locked up. I swear to God, I'm swinging. I swear for God, I'm swinging and banging. What the hell you talking about? What are you talking about? Huh?
Angie, look,
Hell
look,
no.
Angie, just make sure you're in class the rest of the week, man. Just make sure.
I mean, what you mean? Like, how you gonna get around that?
How?
Yeah.
Because see, here's the thing. Here's the thing. And remember, I keep telling you, it's all wordplay. What the courts are saying, and they have personal jurisdiction and they have jurisdiction over you. How can you have personal jurisdiction over somebody that's not a person? I'm a man. I'm a natural man. I'm not a person. I'm a living being. I wasn't created. You have jurisdiction over the IE birth certificate, over the straw man. I'm not the straw man. I don't represent it. That's why I reclaimed my birthright.
I don't know about all this here because at some point, you let me see how they bestow. At some point, they got a back door where they bestow those rights upon you because
They
if
can't.
it's a criminal matter, because I know they do all that in civil court. Nobody want to be paying shit in civil court. So I know they be, but this was the first time I had ever seen it go down in criminal court. As far as somebody's claiming to be I'm talking about like firsthand like this here.
Right.
I'm pretty sure. That's usually white people shit. How you gonna follow their cases or whatever. Never heard no white person in criminal court hollering about sovereign citizen, but unless it was some crazy motherfuckers in Texas or something like that. But as far as a black
And see, and
dude
that's
that I
crazy. And see, and that's crazy because his defense was sloppy. If he had a solid in defense, he would have been okay. He would have been facing at least 30 years. At least. He would have been okay. And he probably could have got that 30-year chopped down into about 15. Good behavior, he probably would have did like 9 or 10. And he would have been on home monitor and for the other 15. But because he was sloppy and he upset the court, his sentencing going to be brutal. He probably get 25 years for each. Matter of fact, he probably get 25 years. And this is the minimum I'm thinking. He probably get 25 years and for each life that was taken. So if 6 died, and that's 25 years, that's damn near what? That's 100 and something years already. And then he probably get 10 years, and for every person that was injured. Trust me, they gonna try to hammer him in Wisconsin if they don't give him the death penalty.
Well, no, they don't have this death penalty in Wisconsin. That's what they would probably offer him. That's what they probably tried to offer him. Lord, I said offer. See, y'all got me all confused. I'm talking about offer him. They would have tried to gave him the no. They offered him 6 life sentences and 859 years for the 70 people that he injured. But see, the thing that's going that will get those, that I can remember, that they will get those the people that's claiming to be a natural man or whichever, natural citizen or whatever, is that they can enforce the law upon your ass regardless, whatever you calling yourself, because you the person, whatever you call yourself, you the person allegedly did the crime.
I now watch this. In state court, they have to give you a remedy. In federal court, but they have to give you a remedy. In Supreme Court, they have to give you a remedy. So if their remedy was 6 life sentences, what type of life sentences? Were they just natural life or was they regular life?
Oh, y'all got some for all the motherfucking little things. Y'all going to jail like a motherfucker. What you talking about? Is the natural life? What?
Angie.
Y'all going to jail like a motherfucker. What?
Angie,
Whatever
it's
it is.
true.
Whatever long your ass live. The judge gonna come up with that. How long your ass gonna live?
No.
That's
no.
what.
Listen. It's two different lives. It's 2 different lives. Natural life is for how long you're breathing. Life is only 25 years. So that's what you got to find out. If they gave him natural life, if they gave him 6 sentences of natural life, he ain't never seeing the light of day.
Well, I mean, they say life. Now it all depends on the states, okay? Because you can get life,
Right.
and that means whatever years, life with parole, life without whatever. And some states is automatically after 25 years you can eligible for parole, stuff like that. All that, depending on the states and stuff like that. But
no, that's federal. But that's federal throughout all the states now. Natural life is as long as you're breathing. Life is only 25 years. My cousin got 9. Yeah. No, I'm sorry, I'm lying. And my cousin got 13 counts of natural life, plus an extra 944 years because he shot a judge. He will never, he will never see the light of day again. Never. It's so bad for him that in federal jail where he at, because he's at maximum prison and the feds, he can't even touch his own mail, but they scan it across the computer and he read it that way.
They scan. He read his. What you say?
They scan his mail into him, and he read it across the little prompter in his cell. That way, he can't touch no type of mail. It was so bad for him that he was getting judges, attorneys, and people knocked off in pig Latin. So that's part of his order. He can't touch no mail as long as he's breathing. And I think that's excessive, but
he's breathing.
Yeah. But that's in his order.
Well, did he do something with mail or something?
Man, Angie, did he do something with mail? No, he was getting you knocked off in pig Latin. But that's all he do is whatever he had to say in pig Latin, he'd write it and then send it home. And sure enough, it'll happen.
Yeah, doing something with the mail. Yeah, so that's why.
Yeah. And bodies, man. I'm gonna say this. I wish he never got sentenced that much. I mean, that deeply, but it ain't shit nobody can do. And the one thing he said was, if I ever get caught, I'm gonna do my time because I did the crime. I was like, boy, you crazy. Once they would have gave me all that time like that, I would have actually go to the bathroom. I would have hung myself in the bathroom. That's, man, you will never see the light of day again. That's when I found out about the underground institutions.
Well,
But yeah, Angie, I'm gonna send you the link
that's
every day this
crazy.
week. And matter of fact, and you're gonna see the paperwork that I'm gonna show that I'm gonna put up. And I'm actually gonna have some folks to come on there and to give, like, you know, and also talk about it with me as well.
Yeah, cause that's some y'all got a lot of shit there, little, you know, when you know, if the court go this way, they go, but see them new age courts and them people that still practicing and shit, they own y'all shit. They own y'all motherfucking shit. They like you know, they own it
Well, I mean, well, here's the
because
thing. So here's the thing. They have to be able to combat what we're doing.
yeah, but it's
If they
pretty
can,
easy to determine jurisdiction though. Go ahead.
no, it's not.
Ah, it's not easy.
Not for a natural man. It's not.
Yeah,
Prime
not
example.
listen. They gonna count you. Yeah, they gonna count you. They gonna tell you if natural man, whatever kind of man came out somebody's ass and all of that. They gonna tell you we got the right to without you consenting to. Because he kept saying, and that's why I wanted to have this conversation with you because it makes
Right.
sense for an old motherfucker like me. Okay, because. He kept hollering back. I do not consent to this. I do not consent to that. And I was saying to myself, I said, they don't give a fuck what you consent to. They looking at you like we don't
Watch
give a
this
damn.
though. Watch this though. As long as it's on record, and you don't have to give a damn
He
about
kept
it.
hollering that shit
But
too. You sure you wasn't advising him, Dana?
not,
You sure you weren't calling your motherfucking ass when you got off the live or whatever? I promise you he was saying that. He kept making sure, is it on the
Andy,
record? I want to be on the record.
Andy,
Is it on the record?
listen though.
And she had to finally say, she had to finally say, sir, everything we're saying, yes, you're on the record. It's on the record. It's on the record. Yeah.
Listen. That sets up for, and see, and that's all he trying to do is get an appeal.
That's what they called his ass. Yeah. Because I called him.
Yeah.
That's all he's trying to get an appeal.
But that's all he trying to do is get an appeal. If he can get an appeal successfully, by him saying it's on record and by them agreeing, now he can create controversy at a higher level. But see, once again, here's where he fucked up at. When he said he was a sovereign citizen, ain't nobody gonna take that up on appeal. Because everybody gonna think, and you gonna have all these crazy motherfuckers come and storm the courtroom and shoot up the goddamn courtroom. So no, but they gonna leave your ass right where the fuck you at. As much paper as you put in, and they gonna overlook it because of that one sentence. When he sat up there and said, "Yes, I'm proud to be a sovereign citizen," right then and there, I did a Gloria already. I said, "Up, there go the lawsuit. You're done."
Yeah.
If you wanted to sue,
go ahead.
If he wanted to sue under color of law, he can't. Because now he agreed to being a terrorist.
Now, wait a minute now.
A sovereign citizen, right? And the sovereign citizen group, they are deemed terrorists by the federal government. And they'll tell you that. If you get the right person, they'll tell you that shit in court too. They'll tell you right to your face, "Sir, are you a terrorist?" Watch this. If he would have pulled out a birth certificate and started talking rhetoric, that judge probably would have said, "Sir, can you sign the back of that birth certificate for me?" And as soon as he would have did that, and she would have had a big old grin on her face, and she probably would have let him finish, and she probably would have let him finish, and then she would have said, "Sir, I don't have to charge you for murder no more. I'm gonna charge you with treason. You can't sign the back of a birth certificate. That's illegal."
But with the color on the color of law, he got to prove that that their actions violated the law. I don't think she did anything to violate the law, and actually they went above and beyond on the record to break down everything. This one I wanted to play today to show you how crazy this motherfucker is. But I don't know if you saw this, but even when he was saying that I mean, they did every little bitty thing on the record. She made sure it was on the record. She broke it down as like in little kindergarten terms, and people was getting frustrated because they was like, she's weak, she's soft, she act like she don't know what she doing, she blah blah blah. I said, no, they know exactly what they doing, because he's trying to get an appeal out of shit. He's trying to find a way to, let me get it right now, to you know, when something, when he put in a motion for reconsideration, not or review, legal review, as he was asking for. And so he's trying to get something going so that he can get this thing overturned, dismissed, or whatever, because of issues involving the court or some kind of prosecutorial misconduct. And that is not going to work, because she even had, like, the deputies, when he was being put in the other room, she even had the deputies to take the stand. So they on the record. These are the bailiffs, not the deputies. See, I'm all fucked up. The bailiffs, I'm sorry. They held him in the other rooms and shit to say that he could hear what she was saying. He refused to sometimes to, you know, to put the headphones on. That you know, he was acting like he couldn't hear, she couldn't hear, all that kind of, but he put on a whole show.
Watch this. Watch this. Everything you said was true if it involves a person, which it does. That's why your standing would be correct, Angie. However, if that was a natural man, if it was somebody that took a natural man in position and did everything in the right way, by him asking for it to be put on record, it's not about breaking down in the situation. It's about following what you have to follow per the Constitution. So if what he was asking for falls in line with the Constitution and she overruled it, she can be held liable for contempt for that.
But
the likelihood of getting a judge on contempt is a likelihood of taking a Burmese cat and squeezing it through a needle thread. It's not going to happen, especially when you sit up there and admit you're a sovereign citizen.
But
it all goes back to that.
Okay, but do you not think that there is going to be case law somewhere that's going to say, damn, I'm losing my train of thought, that the court determined that whether you consider yourself a natural man, a sovereign citizen, or whatever that more thing you said, they're going to determine that you entered in this world the same way everyone else did. Thereby, the courts will have proper jurisdiction to enforce the law. You don't think they're going to have something like that somewhere?
Well, I'm going to say this. It's a bunch of case laws with that, right? It's a bunch of case laws.
Go ahead on, Angie. Go ahead on.
It's a bunch of case laws, and I'm gonna send you a bunch of them and tomorrow afternoon when I get off for work. It's a bunch of case laws. However, it all boiled down to if the paperwork was filed correctly or not. Like today, I got a call from the a federal court. I was put on the do not detain list today. I was happy as fuck because now that I'm on the do not detain list, my next thing is I can deregister my car from the registration thing. I don't no longer have to wear the regular plates that everybody wear. I can get my natural man plates. So it's like it's steps to this thing. And I'm gonna be honest with you. I didn't think I was going to ever get on this list, but I worked hard. I submitted the paperwork. I learned stuff. I studied, and to show myself approved. And it's like back to what we were saying. It all depends on your correct standing and your paperwork. If you correct your status within this corporation, you can achieve any and everything, but it'll just be on a private level.
Wait a minute now. Why you need to be on a do not detain list? That's like for those people that we had citizenships and shit. What's the proper word for that shit? Asylum and all that type of stuff. What the hell is going on?
Yep. You actually hit on a nerve, and you actually hit it right, and you actually hit that nerve right there.
You're not from them places, Dana.
Who?
You're not from them places that gets that.
How do you know that?
Huh?
How do you know that?
But then you said you was born in Baltimore.
I might have been born in Baltimore, but I reclaimed my birthright. And my birthright is in Taiwan. And my birthright is in a non-Hague country.
Taiwan?
Yep. Any non-Hague country your birthright is in. And
Man,
you can claim, you can reclaim
it. You're going to jail like a motherfucker. Taiwan, Dana. and Bernie might say, you going to jail like a motherfucker. Taiwan, Dana. Listen here now.
No, but so seriously though.
Close your eyes and pick a motherfucking place.
No. That's what I mean when I say, and you have to really study. Because I know one of my homeboys have his asylum in Africa, but it's a certain part of Africa. On top of that, and what people don't realize is that you still got to pay your taxes to that country.
Hold on. Wait a minute. Go ahead. I can remember my question. I can remember.
And it's like, and your taxes might not be that much, but and you still have to pay some type of taxes from that EIN number.
So let me ask you this: Wait a minute.
And you don't put the goddamn golden seal up there, huh?
No. I was gonna start it where he was talking about his sentencing and all this extra shit where he gets into the day when he shows his ass. You ain't see it today?
Nah. Oh, so he went on. Wait a minute. It's still going on?
No, he had to come back in today to get the date that he's going to be sentenced. Of course, he got some more problems.
Did he show his ass today?
Huh? Yeah, he showed his ass had to be removed. What I was going to ask you, so you just, do you go by the ancestry.com to find out what country you going to pick to be chose asylum from, or do because y'all got me confused like a motherfucker.
What I did was, matter of fact, I checked on the tax rate and the tax bracket and stuff. And I checked on the basically, it's like when you go and right before you go to another country and you check out everything they got going on.
Yeah.
It's that right there. That's what I did. But that's what I did. And can I tell everybody? It might not fit for some folks, but I always say pick a non-extradition company or place.
See,
Country I
that's
meant.
where
I'm sorry.
y'all see. This is where the shit gets. This is why where you land on a domestic terror. Oh, I ain't gonna say the watch list. When you land on a lot of these watch lists. See, I'm gonna have to cut you off right there because you know you got enemies out this motherfucker, and I'm pretty sure they are screen recording. They saying this motherfucker just picked that he's from Taiwan. He is not from there, so I was had to cut your ass off. This is where you run into problems, okay?
But trust me, but they won't be able to stop that.
Oh, I don't know,
But
Dana.
I have a White House seal. But I have a White House seal, Angie.
The White House seal.
But I have a but I got a White House seal, so I'm good all the way around.
Well, I don't know if
but
they
I have
seal
my
no
state.
theories, Dana. Well, you got to have some legal. Have a
Nah.
legal stand. You got to have a legal argument to get all of that.
Yeah.
You know, get that stamp to prove. Because I don't know about all that right now. But yeah,
I have a White House seal, but I have a Maryland seal and all that.
Because if you're talking about non-extradition, countries and shit like that, that will land you on the motherfucking on the list. where you will
Angie, boy.
where you will be needing somebody to change a few things in your life on this motherfucking internet, baby. Say that your ass was born in 1932 and you currently have a house somewhere in goddamn Saskatchewan, how you pronounce that, and California and other places, and you have to change some shit in your life, honey, because baby, that's a lot. That's a lot there. Oh my gosh. But I want to show
I'm now. Oh, but I'm about to say I'm now 9 years into this, and if I tell you that it's easy, it's not. It's a lot of studying. It's a lot of learning. It's a lot of just like man. I feel like this. It's so much that I can show you. Even when I send mail off, my mail is different. I can't send regular mail. I gotta have some type of proof. Like I gotta get one of them green card put on the back, or if I don't get one of those, I gotta get a what is that called? I gotta get a postmaster stamp to show the outlines of where I'm sending it from. Because I send from the Republic, I don't send from in the regular government.
you saying
if I was to send you something, right?
Yeah.
If I was to send you something, right? It wouldn't look like the regular mail. That's what it is. I have to send stuff registered mail, which is way higher than any other type of mailing system because it goes directly through the postmaster. So I will go into the post office and I will ask for the postmaster, and they will ask me why. Can I tell them that I'm sending something registered mail, and I give them in my registered mail number, but it's registered with the White House and the IRS and the federal government.
I don't know about that.
Showing that.
I don't know about knocking my door. Don't send me shit to none of my addresses. None of them. Oh no. So, oh, wow,
Angie said,
that's a lot of shit. No, that's a lot of shit to remember,
yeah,
Dana. 'Cause I mean, damn. But you
yeah.
know, he tried to work, and I'm surprised you ain't pay attention to keep up with this, because he tried to work. But I wanted to show them how, you see how after the case now, after the case now, how
Mm-hmm.
she's no longer patient with his ass, how she's very short, she don't want to hear
Or
that
Mr.
shit.
Brooks, if you interrupt me, I will mute you so that I can make an adequate record regarding.
Me anyway, Your Honor.
All right, he interrupted. I will mute him. I need to make a record of his removal. The court did warn Mr. Brooks repeatedly that if he continued to be disruptive, the court would remove him to the other courtroom. It was my sincere hope that that would not need to take place today. I gave him the final warning, and then I indicated I would be turning to the state to ask them some questions, and if he interrupted that process, he would be removed. He immediately interrupted that. And so the courtroom was closed. He was put into the other courtroom. I have confirmed that the audio and visual technology is working. He can hear, he can see, at least the other individuals in there confirmed that that was the case. He was audible for a little bit when I first went on the record, but he continued to be disruptive. And so I did utilize the mute function of the technology so that I could make an adequate
Dana,
record.
you need to stop it to explain something.
Although this is really a scheduling hearing today, I will make a finding under Illinois versus Allen that his conduct was did disregard the elementary standards of proper conduct, of decorum and courtesy. He was disruptive. He interrupted multiple times and challenged this court when this court was making a record regarding the restraints that were utilized throughout this trial. I'm not going to do it today, but
Hold on, stop it right there for a second.
Time.
Stop right there. And you see what she just did? She just gave him case law on top of what she was doing. Now, did he ever do that? If he ain't never do that, that's rhetoric. That's rhetoric. And she don't have to acknowledge it. See, this is what I mean when I say, man, people be making it.
You know, I meant to play from when he was, when you see him trying to get it on record that he was bound with shock, what the motherfucking thing, he was talking them shock chains on his thing. Now y'all, let me come around the front. Y'all remember this idiot had us thinking.
Yeah, play
what's
that.
up, Lavelle? If
play that, please play that, because I want to see this.
Had us thinking that his ass had shock motherfucking chains on his legs and shit. Come to find out today he had it on. Hold on, let me play that. You know, you just telling lies and making up shit. Boy, I was like, hell no. Hold on.
It'll otherwise be under seal.
Why would that?
The record is very clear on the restraint system that was utilized during this trial.
I have a question to that.
Okay.
Why is that remaining sealed, but everything else being open to the public?
I've indicated my reasons are on the record. I'm not going to restate them. So
well, I think that the public, if they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles.
There was no shock device.
It was a shock device. I was told it was a shock device.
Mr. Brooks.
And it was covered up. It was covered up by a black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks. I think the public should know that. The jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your characterization
I respect your
of
ruling,
those
but it should be noted.
It should be noted.
It should be noted that I had a shock device on my ankles. That's fact. It's a fact. It is a fact. I'm the one that had them on my ankles. I inquired about what they were. Obviously, I'm going to require about what's being put on my body. I was told that there were a shock device.
No,
which
dude.
shock device looks, because I've been through this before in Milwaukee, so I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public. Purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed? The
All right,
public
Mr.
doesn't
Brooks,
deserve.
you're
The public deserves
you've
to
made
know.
a record,
The
and
public
it's
deserves
noted.
to know about
And
things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this
it's
voltage.
absolutely false that you
That
have a
is
shock
not
device
false,
on,
and
sir.
you know that it's not false.
Well, I have the photograph
Well, show
that
the
will be
where's
part
the
of the record,
photographs? Where's the photographs?
and they
You
will
just
be
said they would be
sealed
sealed. Why do they need to
from
be
public
sealed?
view
Why
for
do
the
they need
reasons
to be
that I've
sealed from
already
the public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the public?
I need to move on to scheduling.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
All right, so
Can we move on to that?
Mr. Brooks, I really don't want to remove you from the courtroom today.
It,
But I need to
don't,
move
I don't
on
want to
to-
be removed, but you're not going to sit here and tell me on the record what was on my body when I was told what it was. That's inaccurate, and I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record when you know that it was in fact a shock device. That's why I had the black cloth in front of the table so it couldn't be shown. That's
not
why I had
right.
a chair sitting on the side of me that was told needs to cover up the fact that I had a shock device on my ankles. And I think it's very, very, very unfair, and it's dishonorable to get on a record and not tell the truth. I'm not trying to dishonor you, Your Honor. I'm not trying to disrespect you. I'm not trying to disrespect your court. I just want the truth to be told. That should not be sealed. If everything else could be open to the public, then the public should know that I had a shock device on my ankles. That was purposely not shown to the jury or to the public. They should know that.
All right, thank you, Mr. Brooks. I disagree wholeheartedly with your
Well,
characterization.
it's not true.
Mr. Brooks, I didn't interrupt you. Please
It's not
don't
true.
interrupt me.
It's not true.
Mr. Brooks?
I'm quite sure there's cameras rolling right now because there are always cameras rolling. There's always audio on.
Mr. Brooks, I need
There's
to move on to
there's public in the
scheduling.
courtroom. I had a shock device on my ankles, and they purposely did not want to show that to you guys or to the jury. That's
Mr.
why I
Brooks,
can only move
I'm advising you.
here or here.
Mr.
That's
Brooks,
the
I'm
reason
advising
why.
you.
And I always had the chair right here. Everybody that came in this courtroom seen that I had a chair right here, even though I had no counsel. What is the reason for me to have a chair right here?
All right, Mr. Brooks,
Why
any
did I have a
further,
black cloth
any
in front of
further
the table?
interruptions will result in you being removed to the other courtroom
Okay,
because
and
you're
you
not
holding
letting
me in
move
contempt,
on
that's
to
okay.
scheduling.
Is it civil contempt or criminal contempt?
All right, one more interruption and you will go to the other courtroom.
Well, they need to know that.
Stop.
They need to know that. They need to know the truth.
I'm going to ask the state some questions. If you interrupt when I do that, you will be removed to the other
Okay,
courtroom.
remove me
All right,
then. Remove me
Attorney
then. It's
Basie.
not gonna stop the fact that they need
All
to know
right,
that the shock device
he's
is on my
interrupted.
ankles.
I'm sorry, everyone. We'll have to clear the courtroom. He will be removed to the other courtroom. I'll
That's
make the
fine.
appropriate
Tell the
findings.
truth, though, Your Honor. Tell the truth. I had a shock device
Captain,
on my
can I
ankles.
please-
Consideration
All right,
of your
Mr.
ruling.
Brooks.
Okay, somebody popped up. Let me pop in. Oh, that's you, Dana. Oh. Okay, so you saw that?
Yeah. He's an idiot. He's creating controversy in the court.
So he ain't supposed to do that. So now watch what she does
Hell
now.
no.
Oh, okay. See, so well, I know he ain't supposed to do that, but I mean under this sovereign thing or whatever the hell he's supposed to be going under. So now watch how she, gets the bailiff on the record. I don't know. I could call this man deputy. Y'all have to excuse me, honey.
Yeah, but so he was supposed to create a conditional acceptance.
Oh, okay.
Go ahead. Raise your right hand.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you, sir. Have a seat. I'll let you put your name on the record so I don't get that wrong. And so go ahead. Please state and spell your first and last names.
First name Nicholas, Nicholas. Last name Kibler, Kibler.
All right, thank you. And you are employed in what capacity with the Sheriff's Department?
I'm a deputy for the Waukesha County
Oh,
Sheriff's
a
Department.
deputy. See, I'm all fucked up.
You don't have right, sir, were you assigned to the trial of Daryl Brooks?
I was.
And can you tell us in what capacity?
My capacity was specifically, my responsibility was Daryl Brooks, along with Deputy Stengelson.
And
And-
were you in court at the start of the trial on October 3rd?
I was.
And did you come into court or work the court trial every day that we were in session?
I did.
And can you, were you at all in charge of the restraints? Let me ask you this. Do you have knowledge of the restraints that were utilized on Mr. Brooks throughout this trial? Can you describe those, please?
It's a soft restraint that we used. It was not any type of electronic control device. It was just a soft restraint that we applied to Mr. Brooks prior to coming into court every day.
Then let me stop it right there. So through and through, she would have different like when he says this and says that or whatever, she would have she would, have people come in, whether it's the bailiffs or whoever, to come in and certify that, like he could hear in the other room and other little bullshit that don't normally take place in the courtroom. But he was doing this again to, make sure that they will be good on, if anything, kick off appellate, whatever. So yeah, this is just an example of the shit that went on through this whole trial.
Wow.
Would that be a restraint system that was on his legs or something else?
It was around his ankles.
All right. Throughout the trial, the tables in this courtroom had black table skirts. Do you remember seeing those?
I do.
And did that hide from view in any way the use of the restraints from the jury?
It did.
And were the restraints also attached to the table in some fashion?
They were attached to the table by a tether.
At any point in time, were there any other restraints utilized in the courtroom?
There was not.
At any point in time, were there any type of electronic or stun device placed on Mr. Brooks?
There was not.
So
Anything you would want to add to the record regarding the restraints that were used in this case, sir?
So Angie, if he can prove that he had shock restraints before sentencing, he can get this case dead docketed, and then they would have to retry him again just because the judge allowed the bailiff and to lie on record. However, if he can't prove that, that can be hit at sentencing for an extra 10 years for creating extra controversy on the court.
But now, how would that be her fault? Because she's asking, if he's saying on the record that that's what, but she don't know if that's.
But if you realize
his word.
But if you realize when he first started saying that, she told him it wasn't. And you can't make statements like that in court on record if you don't know for sure. That falls under controversy on the court and fraud in the court.
But you think he can get the case postponed indefinitely because he,
Shit, he gonna try.
Lying. Well, yeah, he's trying, but I mean, like, boy, y'all got a whole bunch of shit. All that, yeah, that's.
But if he can't prove it, it's gonna be shit creek for him at sentencing. Because 9 times out of 10, she gonna remember that, and she can give him an extra 10 years just for that. Sentencing is brutal when it comes to state. The feds will be more lenient on you, but the state worse than the feds when it comes to sentencing. And to answer Lavelle Marshall, huh?
Go ahead.
Oh, and to answer a Lavelle Marshall question, I would do it all over again, but I would have did it earlier. As soon as I turned 18, I would have did it then. and because I would be at the legal age of understanding.
Mm-hmm. See, I just don't see no way whether he would have, whatever he claimed to be, he could have got out of
It's
this
ways
shit.
he could have tried it, but the only way he could have got out of it is an indefinite postponement. And they hard to get, Angie. An
Yeah, but that's
indefinite
done
postponement,
by
that shit is hard to get. And you got to really prove that the judge was biased against you and pretty much practicing from the bench.
but that's something the prosecutor asks for. Not, he don't
No,
raise that.
no,
Prosecutor, that's who asks for a dead docket. Prosecutor.
no. If he's defending himself, he can ask for it. I don't mean he'll get it, but if he's defending himself, he can ask for it. And the defense have the same amount of power as the prosecutor. And the only difference is the prosecutor got to prove their standing against him. So they got to prove everything against him.
Yeah, but
and the crazy part about it,
go ahead.
Oh, and the crazy part about all of that is this right here. If the prosecutor can prove that you are X, Y, and Z, then guess what? What can you prove? If you can't prove nothing, shut up and just go along with it. But that's what sovereign citizens do. They create controversy amongst the court. No, if it's something not going your way, you go ahead and make sure everything is on record. And once everything is on record, then you can present your presentments at argument time. You don't try to damage the court like that. No. All of that stuff falls into play. That's why Robert ain't say a word. All of that falls into play when it comes to the appeal. How was he in court? Was he compliant? Was he non-compliant? Was he verbally disruptive? Was he, all of that stuff falls into play for your appeal.
Right. He was definitely playing
for. But I said for you, Angie, he was an asshole.
Yeah, he was. So I don't see where he could endear himself. And maybe that was his whole COVID thing, and try to act like this, that, and the third. Maybe the prosecution would be like, yeah, we'll dead docket for you and whatever. Then in hopes, and he's hoping that okay, they'll stay dormant for however length of time, and it'll never come back active, and this, that, and the third. And he must be had a checklist, because that's like again another move to try to get something dismissed. But shit, that's
But now watch this. He got one way out of this now. And the only way out of this is he got to prove that he was injured by this court proceeding. And he can't do it. If he can prove that he was injured some kind of way by this court proceedings, it has to go to federal jurisdiction.
Well, his rights were violated. He tried that. He didn't prove that no one had jurisdiction, so if that falls upon the rights.
Did he state jurisdiction?
He kept I think she said she gave it to him in writing. I think she gave it to him in writing.
No. Somebody, if it happened that way, whoever is over top of the jurisdictional courts that she's under, she can get in trouble. No, you have to put it on record, and you have to put it on record in writing how they got jurisdiction. Now watch this. If he was locked up and they brought him in, they now have subject matter jurisdiction. But it falls into how did they obtain it? That's a whole nother angle. If they obtained it wrong, then yeah, they can be in trouble. But he got to prove it. And if he can't prove it, there's no need to even bring it up in court.
He brought it up
because if he tried to appeal it to the feds, but if he tried to appeal it to the feds, and the first thing they're going to say is, how did they obtain jurisdiction over you? Because if they came to him and said, look, and we know that you ran over those people and we're going to lock you up, and he willfully went, then hey, he gave up jurisdiction.
But I ain't never heard nobody, no court say how do they attain jurisdiction. We already know.
Oh, man. Angie, I'm telling you.
I don't know. I don't know where you be going. I don't know what the fuck going on. You must be at an Indian court or somewhere. I don't know what the fuck going on.
No,
we already know.
No.
When we file it. I'm talking about we. I mean,
but I'm always in district court. And it's like, and the stuff that go on in state court and all that, it will not go on in district court. And it's like, that be the first thing a judge that asks a person for that claims jurisdiction. Well, how do they get jurisdiction? How was they able to get subject matter and personal jurisdiction over you if you claim that they don't have jurisdiction? It's easy. But if you don't know it, it's nothing that you can say. But once you know it, can't nobody take that from you, Andy. And it has something to do with those 3 words that the New York Attorney's Office or the New York Fed's office used against R. Kelly. Those 3 magic words are so powerful in district court.
Which is?
Entice, coercion, and what is that third one? Shoot. I know the first 2 is enticement and
induce.
Yeah, and induce.
Coercion, induce. But listen, so when a attorney, when a defendant or an attorney comes in and they want to challenge the jurisdiction, if it's not in the proper jurisdiction, they just transfer it. So you're gonna get handled somewhere.
Say it again.
If it's not in the proper jurisdiction, they're gonna transfer it, or it gets refiled in the correct jurisdiction.
And the question is,
civil cases get refiled, but yeah, I mean.
And the question is, where would they transfer it to? And because sometimes, just like sometimes they ain't gonna transfer it where you want them to transfer it. And I seen that happen once, and that kind of freaked me out. Like I had a friend that was in his case transferred back to Michigan, and they transferred it over to New York. And he was like, wait a minute, huh? Well, yeah, hey. And the judge said, and you asked for a transfer. So he gave it to him.
Well,
Just
you know,
not in a place where he was going to get it.
but if it's a federal crime, you know, it's based on you know, other things. If it's you know, if it's happens in the state, it's kind of, you know, cut and dry. You know, if it happened
Okay.
in Cook County, it's, you know, it's gonna take place in Cook County. You know, in Illinois, you know, Illinois. So,
Right.
but let me hear what he said after this.
Not at this time.
Do you have any questions?
Just briefly, Your Honor.
Sir, you indicated that the restraints were connected to the table through a tether. Is that correct?
Correct. And then we would secure them with a padlock.
And how
on the
long was that
restraint.
tether?
The tether that was in here was 4 feet.
So Mr. Brooks could stand up.
Correct.
He could walk to his left briefly and walk to his right. Is that correct?
That's correct.
And that was the same rule that the state had, that we had to stand up and use our table to question witnesses. That was the same rule that applied to Mr. Brooks.
Correct.
Okay, nothing further.
Mr. Brooks, you're muted. Do you have any questions regarding the restraint system as testified to by
Yes.
Deputy Kimber?
Yes, I do. And Your Honor, you can't practice law from the bench.
Your question, sir?
So
Oh.
none of your fellow deputies
Oh.
shot the device when I asked what was being placed.
What's up? You see something?
Oh, no, I was listening to what he said. He told the judge you
Oh,
can't practice law from the bench. Like, dude, you crazy.
oh yeah. He was real disrespectful and crazy.
On my ankles at the start of this trial.
Not that I'm aware of.
Not that you're aware of. Do you know for sure that I was told that they were a shock device?
I don't believe that's the truth. I believe every time you had those devices put on, I was in there, and it was either myself or Deputy Stengelson putting them on, and I did not tell you that, nor did I ever hear Deputy Stengelson tell you that they were an electronic device.
So you were here every single day for every single moment of the trial.
Correct.
And you never heard any deputy tell me that they were, matter of fact, let me back up. Do you recall me asking what was being placed on my ankles?
That I don't. If you did, we would have told you it was just an ankle restraint.
And you said that it was an ankle restraint. Did it have any metal parts?
Yes.
And what are those metal parts?
Metal part is where a strap went through and the locking device.
And what are those, particularly, let's say if a defendant in a trial attempts to, let's say, attack someone, what would be the purpose of those ankle restraints?
The restraints we had on you would limit your movement. So if you did try to do anything, we would have had enough time to control you.
And you state that, well, the prosecutors stated that the same rules were in effect for the defendant as the prosecution, but were they not allowed to put up exhibits to go to the front of the courtroom and put up exhibits?
They might have a few times, but
The record will reflect it was one time in the presence of the jury, and after that, I called them on it and said that would not happen. And then after that, it was only with the permission of the court and then outside the presence of the jury.
I don't believe that, Your Honor, you can practice law from the bench and answer the question that was asked to the.
Mr. Brooks, I'm in charge of the record, not you, and the record's going
I
to
didn't
be
say I was-
accurate.
I didn't say, well, it's not accurate. You're practicing law from the bench.
All right, Mr. Brooks, do you have any other questions for this
Yes,
witness?
I do. Yes,
All right,
I do.
it has
Before
to
you
be
start-
about the restraint system. Please
Okay,
continue.
and was I allowed to approach the bench and put up exhibits at any time during this trial?
you were not.
And so how is it that the prosecution was able to do something that I was not able to do?
That's not for me to answer.
It's because of the shock device that was put on my ankles, correct?
My
There was no
answer,
shock
bro.
device on your ankle, sir.
I was told that it was. And you said that you don't recall.
Don't go
that
back and
being
forth.
told to you, correct?
No, it was not told to you by me.
Yeah, by you, but you also said that's the point that I'm getting at. I'm asking the question. You said that it wasn't told to me by you. I never asked you, correct?
You never asked me, but I also did not ever hear Deputy Danielson tell you that they were a shock
I
device.
never asked you. I never asked you, yes or no.
No, you did not.
So do you know for sure if I ever asked any other deputy?
Well, considering I was in there when the restraints were being placed on you, I did not ever hear anybody while I was inside the bullpen while they were putting restraints on you.
So it'd be fair to say that you don't know for sure if I ever asked what the device was that was being placed on my ankle.
No, I can't be for sure.
So how do you know I didn't ask?
You don't have to answer that. That's argumentative.
I mean,
He's asking all the wrong questions.
Cutting off the questioning. I'm just muting him for a moment. The record's been made. Deputy, you may step down. Mr. Brooks, if you have additional information that you want to provide to the court, I'd ask that you do so in writing and you provide the identity of any and all individuals you claim provided you with information that you were in a shock restraint. But I'll make a finding based upon the testimony of Deputy Kibler and also my knowledge of being in the courtroom every day and seeing Mr. Brooks being attached, meaning they would secure him to the table, they would unsecure him when he needed to move and other things. I'll make a finding that the soft restraint system was what was utilized and at no time was he ever in a shock type of device. All right, with that then, ladies and gentlemen, it is going to conclude the hearing today. We have the sentencing dates. I would also ask that any and all written material that either side wants this court to consider also be filed by the 11th by noon. So that's November 11th at noon. That will give this court ample time to review it ahead of the hearing on Tuesday, November 15th.
Yeah, so pretty much, you know, that was just.
I see what he's trying to.
You see he tried everything under the sun.
On top of that, he's setting himself up for an insanity plea.
You think so?
Hell yeah. Just by him asking all the wrong questions at the right time. Yeah. That's grounds for insanity.
Yeah, he you know, now this go ahead.
I'm gonna be honest. If I was him, I would ask for a bar of soap and pee on myself and try to wash myself up in it.
Huh?
That right there would have locked me in as true insanity. And they would have put me in a mental institution
That's
instead of locking me up.
crazy.
Yeah. Man, Angie, it's tricks and trades to the court.
I see.
It's tricks and trades to the court.
I see. That's
it's tricks and trades to the court.
Ask for the soap and pee on it. The fuck?
And
Get your ass out
and
my
pee on
goddamn
yourself and
courtroom. Ass out my damn courtroom.
pee on yourself and start washing up with the soap. I'm telling you, it's tricks and trades to the court now.
This guy, and I know this guy got this wrong because this attorney.
But
So I would say that we
something wrong with him,
expect to know what his claims on appeal are.
Yeah.
With an appointed lawyer for at least a year.
He didn't do himself any favor during this trial, did he?
Hold on, wait a minute.
That is the understatement of to know what his claims on appeal are. Sense and logic, as well as Mr. Brooks' wishes, but I have no doubt that will be considered. There may also be evidence that because he represented himself, he was unaware of, and the appeals lawyer may find it, may add that to the claim, because in Wisconsin, before you go to the appeals court, you first have to file a motion for a new trial if you intend to seek it on any grounds. So I would say that we should not expect to know what his claims on appeal are with an appointed lawyer for at least a year.
This is a dude that said
literally based on the cold record. And so it will take probably, I don't know, 3, 4, 5 months to just prepare the transcripts from the trial alone. So his case will not even reach the briefing stage for 4 years. But the lawyer representing him, appointed by the public defender, no doubt, will also have to investigate whether there are claims. This is going to sound strange. The lawyer can actually claim ineffective assistance of counsel to himself, as crazy as that sounds, and can claim that he didn't get a fair trial in the interest of justice because
yes, he can.
Now, wait a minute, he's incorrect there. Let me tell you why he's incorrect. There's actually two case laws that the judges factored in. Well, one case law followed another one. They factored in a rule. And when I say rules, so when it comes to things like severance and other little, different little procedures with regards to the court, you have to go through a test, and you have to go through rules. So, and if they find that this rule or that rule, whatever, and sometimes you have to meet all the rules. If it's 3 of them, you got to meet all 3 out of 2 4 to have it, change or have it, affirm and it stays as is or whatever. Whether you pass the test or fail the test, whether or not you get severance and stuff like that. With that, you have to there are rules factored in, and the judge in those cases, and I listed them on the damn community wall when I was thinking. I can't think right now, but the judge in that is one case just politely adopted the decision from the other case, but they are, we always cite those 2 case laws from those 2 cases that a person who decides to represent themselves cannot come back and say, hey, claim ineffective assistance of counsel. So he was incorrect in stating, and let me finish listening to what he said, because he might have some type of caveat that I didn't hear, but I know that right off. Hold on.
Seems to fly in the face of common sense and logic, as well as Mr. Brooks' wishes, but I have no doubt that will be considered. There may also be evidence that because he represented himself, he was unaware of, and the appeals lawyer may find it, may add that to the claim, because in Wisconsin, before you go to the appeals court, you first have to file a motion for a new trial if you intend to seek it on any grounds. So I would say that we should not expect to know what his claims on appeal are with an appointed lawyer for at least a year.
He didn't do himself any favor.
Go ahead and talk, Dan. Let me find those 2 pieces of case law.
So what would be his rule? What would be his reason for ineffective counsel of self?
That's what I'm saying. That so I know you can't claim it, and not to get nobody confused. Like when I say, even though he gets for his appeal, he gets an appointed attorney or he hires an attorney. When I say he can't claim it, you do know that an attorney only speaks for his client. So that's speaking for his client. That attorney can't claim that it was ineffective assistance of counsel, even though he's taken over, just because his client was ineffective. But let me go get the pieces of case law for that. Go ahead, Dana. I don't know what would
that's weird, because I would be interested to hear what would be the ruling for that. Because if that's the case, they would have to call him incompetent. But then if you're incompetent, why is you creating controversy on the court? So either way, he lost again.
Mhm. Oh yeah. Oh, and one other thing I wanted to point out to y'all that the judge, she used a piece of case law that they used in R. Kelly's case towards the end, Bajorkas. Yeah, they didn't use R. Kelly, but they used a case law that I think, and if I'm not mistaken, I think it was Bo and them, McDavid's attorney. I believe they the one that raised Bajorkas. Let me see. Y'all putting on my ass tonight.
Lavelle said, all right, y'all. Y'all heard it here. Y'all heard it right here. If Dana acts with soap in the courtroom and pissed on himself and tried to wash off right in court, it was premeditated.
Oh, Lord, right. Okay, what kind of shit is that? Pissing on soap. The hell?
Man, but they told that man 895 years plus 6 life sentences. Man. So was all that running consecutively or concurrent?
That's what he's facing. I think that was out of the offer of what he was facing. I'm not sure. Okay. So here's the
Angie,
rule.
that ain't no goddamn offer. That's a lynching.
Listen, hey, we could have gotten. I think that she said offer.
Man.
If I'm not mistaken.
Hey, Angie, if that was me in that situation, it would have been like, can you please pass the offer? And when they say, can you please pass the jelly? And that man fell out.
Yeah,
I'd have been like, what?
I've been pissing for real. That's crazy as hell.
Shit.
It was Brunson and Petrick. Okay, that was the
Okay.
two cases, and the rule is and I'll read it off because I logged in my official shit. It says the basic rationale for this rule is twofold. First, courts reason that a defendant who has made his bed by electing to represent himself and thereby retaining direct counsel control over his defense must lie in it by accepting the consequences of his decision. Second, courts worry that allowing pro se defendants to claim ineffective assistance would give defendants an incentive to sabotage their own trials. So yeah, so I knew that was the wrong time he said.
Angie, listen to what they said though. Will give pro se defendant.
Yeah, he's even though during his case he's pro se, but what you trying to say pro per?
But no. Watch this. What if he turn around and say he was sue jury? That changes the landscape.
Explain, Dana, how it changes the landscape here. Because you got more shit and y'all got twists and turns and shit. Go ahead.
But he's so stupid that he would never think about nothing like that.
Let me see.
I just think that guy's an asshole, man. But that guy's a butthole, and he deserves everything he gets. Because it's like, at one point, but the judge was trying to help him. And he got mad at her. Like, dude, are you, he can cry mental insanity, though.
Right. Yeah, and they even expanded it out and Collier versus Sullivan.
Yeah, that's a case
to
law that's the case law that covers a lot of ground.
that it says that there's no distinction between an attorney that was appointed or retained. So they and this is Supreme Court. This is a Supreme Court rule. So I don't know. So like I said, when I say he can, like, when he gets to the appellate level, even during, if he had a lawyer, whether it was retained or appointed, and he fired him, he took over. When he gets to the appellate phase, he gets an
I
attorney.
don't think it's going to get there.
Well, I'm just
I don't
saying,
think
but
it's
he's
going to
going
get
to
there.
file an appeal. He's going to file an appeal, but it's whatever. But he,
I don't think it's going to
cannot,
go. I don't think it's going to make it
well,
because
I'm
he's a
saying
threat
that
to
even if
society
his
and
attorney,
himself.
right? Unless the appellate attorney try to say that, oh, you know what, but this still ain't gonna work. That appellate attorney
Yeah.
can try to say ineffective, and maybe it was caused by the judge. The judge maybe but see, she protected herself. That's what I'm saying. You have to be very careful from them pro se's, because she could have said something or whatever, and it could have been misconstrued as giving some kind of advice and shit. And then
Well,
now she's, now he might can raise that, hey, I was ineffective because the judge led me to be ineffective. You have to be careful how you help the motherfuckers.
well, let's go here. By him yelling, she practiced in front of the bench. He also can challenge the fact. Well, no, that's not gonna work. That's not gonna work. Because then at the end of the day, even if he challenged coercion, he got to show how the judge coerced with the bailiff and everybody against him.
So other thing I wanted to talk about with the R. Kelly thing real quick is so I'm thinking that we haven't seen Avenatti yet and whatever. And I'm thinking Avenatti, let me come right in the front with y'all. I'm thinking we're gonna see, there's a good chance that we should see Avenatti and the dude that said he found the tape in the garage and I was watching a basketball game and end up watching ass and all this here. I think we it's a good chance, if any, for us to see them pop up in the state case. Now, my question is, were the tapes, I don't think that the tapes or whatever they were using were the tapes produced from Avenatti and the dude in the garage, the old man in the garage and shit.
Well, I'm gonna be honest with you. In the old man in the garage, I don't believe there was any tapes of that. Avenatti, his CGI stuff that he was doing, of course they used that. Because if they didn't use it, then they wouldn't have had no reason, and for Freeman being there, Charles Freeman. And remember, Avenatti was Charles Freeman's attorney.
Avenatti was?
Yeah. For 6 years.
Oh.
And a friend of Freeman's was being tried by, I believe it was one of Angelo's lawyers, and Angelo lawyer turned him on to Avenatti, thanks to Charles Freeman. But see, what they need to subpoena is Kim Fox, Jim Darriaga's, and Avenatti's records, along with the Homeland Security Office records that happened at O'Hare. That's what they need to subpoena, because that's what set the motion and for them to come get robbed. When they kept doing all them meetings and stuff at O'Hare, oh yeah, all them records need to be subpoenaed. And what was shown at the meetings, and Jim Darriaga's is all up in it, and they should strip his broadcasting, but they should strip his broadcasting rights and make him testify under oath. But see, with him, I take it a step further. I will make him testify under oath and then immediately give him a polygraph.
Wow. But see, my thing is, the reason why because remember that whole Avenatti and all the hype surround him, that largely had to do with Kim Fox's office, right? That was,
Right.
So my thing is, are there going to be additional tapes? Because because if it was Avenatti, and I said this before Greenberg said it, Avenatti could only, because everybody was remember, Avenatti should be discredited and blah 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 and blah blah blah. And I kept trying to tell people, calm down, because Avenatti is only going to be a chain of custody witness. That's the only thing he could be. He can't be no witness to any other thing but the chain of custody. And everybody was,
Why can't he?
fast out. He should, huh?
Why can't he when he had 4 clients?
He got 4 clients, but that's not relevant to the charges.
Why ain't they? All of his clients had something to do with Rob being booked in both jurisdictions. Faith Rogers, New York. Geronda Pace,
talking about the
New York. Azriel, New York. Charles Freeman, Chicago. The parents, New York. Lizette Martinez, Chicago and New York. So yeah.
Okay, so
he had clients.
Okay, he had clients, but let me ask you this: they did not call him for those 2 jurisdictions. They didn't call him for Chicago or New York, right?
They couldn't call him for that.
Yes, they could. Why they couldn't?
But they couldn't call him for it because he was locked up.
Yes, they can. You can testify when you locked up. What you talking about?
The government wasn't going to call him.
I can't even mention his name.
Right.
Right, so
because it's for the CGI tape.
Well, that's in
all
theory.
Of that.
I'm talking about you. So that's what further make me think that he is probably going to show up. And I may or may not be, right? But he's probably, if he's going to show up, he may show up in Chicago, because they ain't even mention him. because I'm sure
for the appeal.
Check this out right here. If those tapes, if that was the whatever it was, the tapes or whatever that came through Avenatti, much as everybody hit Avenatti, they would have wrung his name in New York and wrung his name in Chicago in those two trials. Ain't nobody said shit about him. So I'm thinking he might show up in Illinois. If it depends on how the prosecutor put on that case. Now, I don't see if he is connected to one of them tapes or whatever, I don't see how it would be avoidable. Because they would need to show, because they're gonna challenge those tapes or whatever it is. They're gonna need to show how the
Well,
tapes
his name came up in Chicago.
Huh? Go ahead. His name came up in Chicago? Huh? Sound like you writing with a magic marker. So, okay, so if his name came up in Chicago, when his name came up in Chicago? Let me see. Dana, when his name came up in Chicago? Oh, he had me on mute. I don't remember his name coming up in Chicago. And transcript man on read they had them damn transcripts. I don't remember Avenatti's name coming up in Chicago. Do y'all remember his name coming up in Chicago?
But it came up when he said he took the tape to Avenatti. Freeman took the tape to Avenatti.
Oh, okay. Oh, okay. So maybe if that's the case, then okay, so I see what the prosecutors may go with. They may not go with Avenatti because he is now a convicted criminal, and there's no need to, further call the case into question by having somebody else up there, and that's questionable as a witness, and they saw how that worked out by having all those flawed ass witnesses in this latest trial. So I can see them avoiding him. If his name already came up, maybe but it's going to be, I don't know. Do you want to take that risk? Do you want to leave that piece of the puzzle out? How the tape got from point A to point Z, or do you want to risk
and you
putting
can't
another
leave,
witness on the stand, huh?
and you can't leave no stones unturned.
Right.
So you have to take that risk.
Definitely call them. Well, the defense can call them, but I'm just saying, the prosecutor, do you want to risk putting a flawed, unless the rest of your people, and see, you got Rashana, she come with some questions, you got Rashana up there, you got JP, that's you got Hair Braider, got Heather.
I'm gonna be honest with you. Angie. If I was Jennifer Bonjean, I would have subpoenaed Kim Fox. I would have subpoenaed the one that was coercing and Rashana. Then I would have showed the courts how Rob was charged with coercion and enticement. Why can't the federal government and be charged with the same thing, and they did it times 10? On top of that, I would have showed how Kim Fox solicited people to come and lie. I would have showed how Kim Fox met with Jim Darriagas. Huh?
That's not factually true. She ain't encouraging me to lie. She just said if anybody want to come forth, which is equivalent to a 1-800-TIPS line, Crime Stoppers, and all of that.
That's enticement.
That ain't enticement.
And you,
That's 1-800.
Angie, and you can't do that as a public official. And you can't
Yes,
entice the public. No.
you're not
But a public
enticing.
official cannot. So what are you doing?
Okay, if somebody say come to, and they do it all the time, they come to the podium, however they get the message out, and they say, if you have more information, or if you've been violated by this person, or if you have any, know the whereabouts of this person, please contact us at blah blah blah. You can do that.
That's enticement.
That's not enticement. No, that's just asking for assistance from the public.
Angie, that's enticement.
No, it's not.
And
No, it's not. No, it's not. No, it's not.
You know what? Y'all court officials, y'all court officials think y'all can get around stuff. Ooh.
No, yeah, what you call a crooked ass cop. As JoJo say, you ain't nothing but a crooked ass attorney, crooked ass lawyer, crooked ass.
Ooh. Y'all court officials think y'all can get around stuff.
No, we just simply
No matter how you slice it.
That's not enticement.
But no matter how you slice it, that's enticing the public. Okay.
No, that's just calling in
and no matter how you look at it, that's enticing the public.
And there is a built-in protocol. All of those leads are supposed to be investigated for the truth. So here, if somebody called in, and if they're lying, we don't use it. If we find any bullshit in there, you don't use it, because you find that it ain't factual, it ain't truthful. It's a lot of that has occurred, and I mean that's
so
the risk you take when you ask for assistance, but you got to do it. You don't have to.
So if that's the case, why do they use all the liars in Chicago? Because everybody lied in Chicago.
I've said that this is before the trial any trial started. I said nobody on both sides is telling 100% the truth. Now, I didn't know that all them people, I ain't know Lisa Van Allen gonna turn out like that. But we should have known something when they moved up from.
But I've been saying it for the longest.
Yeah, you did call her a liar early on, but we ain't know that it was all like this now. We ain't know that she was gonna try and be 18.
But it's the same thing that she did. But the same thing that she did back in 2008. And see, and I still think it should be a rule out there where the judges cannot change the language of the charging docket after it's been voted on already. After it's been voted and agreed on, I don't think a judge should be able to change the language, because that was the reason Rob. That was the difference in between Robert winning 7 cases versus walking all the cases. Because if he would have never changed that language, Rob would have been found not guilty. But when you change or to and, yeah,
they consider those that falls under the category of administrative changes, and they state that changing order and a little the to whatever stuff like that falls upon the administrative changes, and that does not change the actual indictment. So that is allowed.
But it did.
You can't.
But it did though.
If you read it into meaning, it didn't. But I see what you're saying. I and here's another thing, right? And then when the judge, they support that by the also saying, and in conjunction, the judge gives their instructions. So that supports what is written there. But even with that, even with that, the combination of the two, right? I can look at it and say, and an or could really make a difference. And I can
It
see
does.
it wait, because when you think about it and you read it, it does. Because check this out right here. In other applications of and or, it means just that. And means both, or means one or the other.
Right.
In that scenario, when it falls under judicial, it means the same thing. Now, so I get it. That right there, you get no argument from me. I get that. Because in the other application of and or, it means just what it says. And means you got to do both of them. Or that's one or the other. But when you back it up, when you support whatever meaning with the judge's jury instruction and the instructions to the which is the instructions to the jury, then that's what give the okay to accept it, that it means the same thing. Oh, okay. So that and you know what, and what's so crazy by now, and this is not just happens in R. Kelly's case, it happens, here and there, whatever. But by now, they should already know. Just put it in there. At the when it's written up, just put it in there. So you don't have to go back and have all this confusion, and you understand what I'm saying too. You already know. Just put the shit on in there and
Yeah.
and so and give it and present it to the grand jury that way, and it travels on through to the end of the trial. But I mean, and or that's just what it means. It means that way in just about every other application. And or.
Yeah. Give me a second, Angie. I'm gonna drop down for a minute, but I'm gonna listen.
Okay. So, but yeah, y'all. Yeah, that was. Well, see, I knew this would be a good, really thought provoking, information driven ass live. That's why I kept saying that's one I wanted to do. Before I, get busy. I'm still busy, but get busy again. Before we was doing all right before I got all confused. Shit, I got all confused. I'm like, huh? But yeah, a lot of what happened, and check this out, right? Like I said, I was peeping in, the chats of like the news media and all those places, and people, it was different views and stuff like that. People were getting confused and blah blah blah. With the case, and it was easy because it was a lot going on, because you had the defense, which was majority just in theory that he was presenting, versus what the law to be. So you had to and if you don't know shit about either, you looking like, huh? like how can it be so different? You know what I'm saying? And then you get no explanation in between. Because if he would have had an attorney there, one, of course, that particular defense wouldn't have gone forth. That's number one. And number two, they would have everybody would have been speaking in the same language and the same with the same legalese, same terminology, and all of that, where it would be more cohesive, right? It was like, are they on two different planets? You'd be like, what the fuck is he talking about? Okay, what is he talking about? He kept hollering, prepare persona. I mean, that means pro se. Like what, like all kind of shit like that. So and it was a lot of, and I'm glad we got that good basis from Dana, because he was like, the dude is pretty much taking this stuff from three different train of thoughts. What do you call it? Okay, I know we got the natural, we got the sovereign, and what do you call it? The mute, or the, what do you call that type of man? The rooted man, some kind of shit. Whatever that other shit he called it. But what he called it, y'all? Like three different mindsets. And he said he kind of, looked like he conflated them all into one and came up with something. What was it? Right, and right. Because listen, you would have been like, am I on two different planets? But see, over here, the people that listen to us or whatever, we knew that, hey, what them elements, what's up with them elements? We knew he kept harming by relevancy. And that word he was using was judicial review. I don't know why I call it emotional reconsideration. Honey, I'm trying to tell you, I was confused. I got confused for a minute. But it was a judicial review. That's what he kept asking for. Which, like I said, the motion for reconsideration is after somebody's been adjudicated. But yeah, he kept asking for that 1,000 times. Kept asking for subject matter jurisdiction. And here's the thing, right? Jurisdiction, a lot of times, most times you see that challenge before the trial even starts. Because like I said, almost more than likely, a court knows if they have jurisdiction. Somebody's going to catch that early on, But when you are operating under some type of alternate theory outside of the law, you can, you're going to, ask about subject matter jurisdiction, challenge jurisdiction, whatever that checklist Dana went down, all that other, all that stuff they be doing. Straw man. That's right. Thank you, baby. Straw man. I don't call her mute man, mutant. What the hell? Straw man. So, all that shit. So they got a whole checklist they go down, baby. You be like, what the hell is going on? So, so you have that. But like I said, he kept objecting for leading, right? He didn't know what leading was. Lead, like I said, it's very few questions you can ask on direct that's leading. But on cross, you can ask leading questions. But he didn't know what leading is. Leading questions be like, well, you were wearing blue at the time of the accident, weren't you? That's leading. If you ask somebody, were you wearing blue? That's not leading. He would say he would object for that. He objected for, I don't know, every goddamn thing. So he extended a trial that wasn't supposed to last that long for a week or so later. So, but it seems like with those beliefs, that's pretty much what they are, right? With the sovereignties and all that stuff. It's like your belief, and based on your beliefs, your rights, and based on your rights, it's what you allow to have, you allow the control you allow, right? When I say the control you allow, because it seems like, and I may be wrong, they may not be against benefiting from the government, maybe getting an income tax or getting this or getting that, but they are against the enforcement from the government. And I'm not talking about all people, whatever. I'm just saying. So it seems like that may be the takeaway from it, the whole narrative. I don't know. I don't know. But like I said, I only seen it done a few times, and it was in civil court. And I said to myself, these people just don't want to pay these motherfucking bills. It was 2 in child support, and then 1 under civil. I was like, Lord have mercy, So he went that route. I just don't know. I think he spent too much time concentrating on trying to get all those points those guys like to raise, rather than mounting a defense that would have created more reasonable doubt. And he needed to concentrate on the intent, and he definitely needed to show some remorse, because there was no doubt. You can't say that it, he was trying to go to the fact like he ain't answering to Daryl Brooks, and like, trying to say that, kind of like it wasn't him, that, at some point, a little bit of whatever. You really can't do that, because they see you driving the truck. They caught your ass. It's too much from the time. And then here's the thing, right? You had evidence from before your ass start hitting people, because your ass there near the scene of the crime, arguing with your ex-girlfriend. She called for help. You in the red truck that done killed the people. So you had evidence before you had evidence. So, he spent too much time on bullshit, and he needed to go at the intent, because if he could have some way show that, hey, his intentions was not to kill these people, he lost control, or he could have lost control of the car. What about that? I lost control of the car. The car malfunction. He could have patched them all together. The car malfunction. I was beeping my horn because the car malfunction. I lost control of the car. That would have gave you reasonable doubt with regards to intent, because intent was something they hammered. Because she said, if he didn't intend to kill the next person, he should have just stopped after he hit the first one. How you gonna get out of that? when you got a prosecutor over there saying that shit, like, you can't come over there talking about, I don't consent to be called Daryl Brooks. What? That ain't gonna work. That's not a counter. Like, man, everybody got time for all that. So, and so I think, he's pretty much have talked a good game, right? Maybe he's one of them dudes that have talked a good game in his life. And Wait a minute. Mm. So I think he is, is he crazy? Yeah, he can look crazy. And you see his mama trying to push the mental health narrative in the streets. And yeah, you got to be a little crazy to kill up all them people and hit kids and all this bullshit. Yeah, you got to be a little crazy. But I think he's more full of shit than anything. And he tried with the diversions. Oh yeah, with the, oh my God, the Reddit thing, right? So the prosecution and the court, they addressed the Reddit post. But I'm gonna tell you what kind of con man he is. He tried to make like, it's not out of concern for me, but trying to say like whoever made the post kind of was painting the court and the prosecutors in a bad light. So I think for that reason he wanted a mistrial or throw the thing out, dismissal of the charges. This is very concerning. This is very concerning. Does anybody know if I can play Law and Crime? Because that part, when I tell you his ass need to be an actor. Because that part, when I saw that part, I was like, this nigga, him is a con artist. Yes, this nigga, let me see if y'all don't mind. Because that part right there just, let me see if I can get that part. Brooks. Reddit. Why I keep pulling up the wrong shit? Y'all, I'm so rusty with these goddamn buttons. Hold on. Oh, here's something. Wait a minute. Let me play this real quick. Somebody got fan letters. Let me see. Was it to the judge or was it to his crazy ass? Because these crazy ass people. They fall in love with these type of people, honey.
But first at 10, the Daryl Brooks trial put Waukesha County Judge Jennifer Darrell on the national spotlight. And tonight, we're getting a look at the stacks of mail sent to her from people across the country.
Mary McCarr shows us the common theme in many of these messages.
Have you ever been to Wisconsin before?
I've never been to Wisconsin. However,
Laura Lewis lives in Austin, Texas. She hadn't even heard of Waukesha or the Daryl Brooks trial until she saw a clip of it on TikTok.
I don't know, just like caught my attention. And so I then got into a TikTok hole and looked it up on Court TV.
She then became one of the many pairs of eyes across the nation watching the trial unfold, with Judge Jennifer Darrell at the helm.
To watch a strong woman command the courtroom in that way, but she also did it with a lot of respect for him, which I'll be honest, I'm not sure that a lot of people could have done.
Laura was so inspired by Darrell in the courtroom, she wrote her an email saying thank you. And she wasn't the only one. We went to the Waukesha County Courthouse today to see what other types of mail and reaction the judge received from the trial. This is a stack of 25 individual letters, all praising Judge Darrell. Nearly half of these also came with a bouquet of flowers attached to them. And this isn't even a fraction of the hundreds of letters sent her way.
I was abundantly patient with you yesterday.
What told you to make sure that she knew that what she was doing was appreciated?
Yeah, look, I'm a woman in like a male-dominated space, and I think when you see someone doing something like that, it's important to let them know.
Letters in this stack alone came from 11 states across the country, from California to Massachusetts. The most common thing mentioned was her patience. One note saying, "You have taught me patience, and I don't even know you."
I hope that she knows that, there are people all around the country that saw it. And she represented certainly Waukesha, but I mean, Wisconsin really well.
Miriam McCarr, TMJ4 News.
Judge Darrell and Daryl Brooks are back in court today. She set Brooks' sentencing for November 15th and 16th. He is expected to spend the rest of his life behind bars for killing 6 people and hurting dozens more at Waukesha's Christmas parade. The state says that nearly 40 survivors and family members of victims plan to speak before Brooks' sentencing is handed down.
That boy, they're gonna be there so goddamn long. Like, what the hell? I'm trying to get the part where Daryl Brooks Reddit post. How he reacted. Let me see if y'all can tell how this bullshit reacted to that Reddit post. Reddit. I appreciate y'all hanging on in there with me. Okay. So yeah, he tried to get a mistrial, his slick ass. He tried everything under the sun, child. And none of it was working. And I believe he's behind all these little stunts. Because he clearly, okay, I think he lied. I don't say clearly. I think he lied about those things on his. Ain't nobody told him he had no goddamn. Because when he said he had shocks on his legs, I just went with it because I was like, well, he's been acting a fool in this courtroom, and I didn't catch the case from the beginning, right? And I don't know if because he's been in there for a year. I didn't know, like, early on, was he acting a fool like last year or whatever in his court appearances, was he acting a fool? I know he was acting a fool now. So I was like, okay, well, shit, hey, they got a shark thing, and in each state do things different. Like, I ain't never heard nobody having old suits and ties and shit for your ass in a goddamn lost and found court outfits closet and shit. I don't know, So, but yeah, so watch how he reacts to this. This right here was just
It's very concerning.
That's why there's an investigation, sir. It's anytime there's an allegation that the integrity of this judicial process has been compromised, especially with a juror, I take that incredibly seriously, which is why I turned it over to the sheriff's department.
I would like Your Honor to, if it pleases the court, and if it pleases Your Honor, I would like to look at some alternatives. If I may bring up the in regards to the language, I also want to state that for the record, this did not come about from the prosecution side, from the defense's side, and certainly not from Your Honor's side. This is something that just pretty much sprang up. A lot of my concern, though, just not from just the language in the actual post, but I was kind of concerned that I was the last one to learn of this information that had been known. I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere around that time.
It was shortly after 7.
Oh, so it was after. I didn't know. I thought it was. I knew it was after 6:30, but I didn't want to incorrectly state the record. Your
I can
Honor,
address that for you right now if you would like.
yeah, If it pleases Your Honor, I would like to request some alternatives to this issue.
What's your specific request?
My specific request would be to look into a mistrial and also any alternatives along those lines, short of that or along those lines, or a mistrial. I was looking at some, obviously, yesterday was very, very long for everybody. And as you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
One being United States versus Perez, 22 U.S. 579. And that specifically, I think it's referenced because that one is pretty old in itself, but it's referenced in a lot of the other case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that each one references in regards to issues similar to things like this when it comes into play. And it specifically points to trial judge's discretion. And I think that's kind of like the leading one. Also, I looked at Brown versus Rushton, 572 F.3D 198, which speaks to the language is basically, it speaks to the same thing. It speaks about manifest necessity. It speaks about if there's an issue of exculpatory evidence, things of that nature. Also, United States versus Bates. That's BATES 917 F2D 388.
Now notice how with this particular Reddit situation, I'm glad I did relook at this Reddit situation. Notice how his ass have ready all that case law. But you remember at several points in the case, yeah, like he didn't understand shit. Notice he got all that case law ready. And he knows, here's the thing, right? Several times during the case, he would act like the case law the judge was quoting shouldn't apply because it wasn't the same exact scenario. And I remember I had to on one of my lives and on the message board, I remember addressing that because other people were saying, you know, why they use this case law in R. Kelly case? That ain't had nothing to do with it. It's not that, it's not going to be the same exact scenario. You know, you don't have to use a case law that says, okay, you know, a person is a sex offender or whatever the situation may be, right? You don't have to use that. The case law only needs to be applicable to the situation, to the matter, right? So if it has something to do with reasons to remove somebody from the court, as you know, a lot of the case law she had pulled up, the case law she read, that the defendants weren't doing the same exact thing he was doing, nor did they have the same exact charges, but it was applicable because it gave the reason why you can, it could justify, I said not the reason why, it'll justify why you can remove him. And that's because of being disruptive, or he was failing to comply with this, or he refused to answer this, and things of that nature, Also, he also tried to get her on, giving a tacit agreement, right? Which is agreeing that this is what it actually means. It means to form an agreement with someone, not expressed or implied, but form an agreement because both parties know what the intended results are, right? Or what the intentions are. Can't be a tacit agreement if only one person is agreeing to the intended results or knows the intentions. If the other person doesn't agree, or doesn't comply, or doesn't have the same understanding, then a tacit agreement hasn't been formed. He tried to get the judge on that several times if she didn't, respond or whatever. He was just doing a whole bunch of shit. He was all over the place, child. He would have had me confused as hell. I'd have been saying, I've been giving him giving y'all the wrong information, giving his ass the wrong information, like I gave y'all about that motion of reconsideration. Hold on.
And that speaks of potential for an impartial verdict. Specifically, it says along the lines of impartial verdict, if an impartial verdict can be reached, or if a verdict of conviction could be reached but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to. I also looked at Arizona versus Washington, 434 US 497, and that speaks to what I was stating before. It says neither party in a case has a right to have his case decided by a jury which may be tainted by bias, and I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with this. The defense had nothing to do with this, and certainly you, Your Honor, had nothing to do with this. But just for the concern factor, the language, it's pretty clear that this, if not directly came from a juror who sits on this panel, it came from someone who sits in this courtroom every single day. The language, it directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning. Extremely concerning. And then going back to some of these case laws that I cited, it talks about something to the effect of the ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it. Obviously, I'm not educated in a lot of the laws in itself, but how I was interpreting it, this is definitely a concerning issue. It's definitely something that I would request Your Honor to take a a long look at some options, look at some alternatives. And those case laws I cited talks specifically about that, options that you, Your Honor, can look at and use your discretion to see if it's appropriate in any way. But I'm extremely concerned about this. If anything, for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here in these case laws and
What's the request though that you're making based upon the case law that you cite? I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You say request for
Relief.
relief.
Like, what are you asking me to do based upon the information that the limited information we have about the Reddit post in this trial?
I guess my request would be, because of the concern of this, to look at a mistrial or at the very least a discharge of the jury at this time, so this can be resolved. This is alarming, to say the least. This post, and I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different. I don't know the extent of this website. I don't know who. Well, I think the name of the person who sent who alerted the clerk, of course, to this post. I think his name is in the email. But then that even begs the question of, how did this person come across this site? What is their significance to this? What is their role in this? It's just so many questions, and I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming. It's very alarming. And if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later. This is very concerning.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond, and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start, and that the original poster didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor, that, like you just stated, it's an investigation going on. And if there's investigation, then that clearly says that something is amiss. We have 15. We have 15 jurors. There's still too many questions that we don't know. Too many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue is put to bed when there's still so many questions left out there. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever it is, thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think. I mean, common sense would tell you that this is someone who's very close to the case, whether they were intending to be funny, whether they were intending to try to prank the court or anything like that. We don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think. They point to certain language in the case. They make references to saying when we were in the room, they got certain feelings from when where they specifically refer to themselves and a group. That would be we, plural. They say, and I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. This is if this is someone's idea of fun, is anybody's guess, but I don't believe that it is, clearly by the way it's formatted and by the language that is in it. This is clearly someone with intimate knowledge of the case and what's going on. Clearly.
Malicious intent.
There's no other way to interpret this. You can tell by what they're laying out in the language that they're speaking with, that this is clearly someone close to the case. And because of that, it still has to be, I'm informed of the investigation, but there's still too many questions left in the air just from this. How can we say anything's put to bed when there's still an investigation? For all we know, what if this turns up that it was someone on the jury, or what if it turns out that more people are involved in it than just whoever this anonymous person was who left the post? It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better part of 3 weeks. And even in court days leading up to the trial, we've never had anything like this happen. Nothing like this has been brought to your attention. Nothing like this has been brought before the court's attention. This came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out? I mean, it begs so many questions. It's too uncertain. It's too concerning, and it's too alarming. It's too alarming to just overlook and say, "Oh well, we'll just set it to the side and let them." No, this there has to be some type of alternatives, and something has to be done. Something, and if that's a mistrial, if that's discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that these case law speaks to other options that could come into play. They deserve to at least be looked at. if anything, to protect the integrity of the trial. I find it very hard to believe that this close to the trial being over, and all of a sudden these issues are being raised. So this is obviously not a prank, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
Well, let me address your concerns, sir. I cannot make conclusions at this point about whether this is legitimate or prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity of these proceedings were to be put at issue by a juror. I'd remind you though, every single day, these jurors were read the bulk of jury instruction 50. They all took an oath, and I have no reason to doubt that they would violate that oath at this time. So I took and I made the decision to withhold telling the parties because we were in the middle of instructing the jury. I was in the middle of instructing the jury, and I wasn't going to delay the proceedings because it was so speculative at that point and remains speculative at this point. As you know, the case went to the jury. I brought this up. I waited about a half an hour once the case went to the jury. Frankly, we had had a long day. I wanted to get a bit to eat, and then I wanted to come back out and make a record of what I had. Once again, the forensic unit with the Sheriff's Department has taken lead of this investigation. I'm not a part of that investigation. Law enforcement will handle it. From my perspective, not only did the Clerk of Court's office receive emails regarding this, it sounds like the district attorney received emails. I may have even gotten one. I don't remember the time. It was later regarding the post. Frankly, people figure out my email all the time. It was not solicited by me in any way, and I did not respond to it. And I simply forwarded that email on to law enforcement. So it's pretty clear to me that a lot of people have access to Reddit. I personally am not a user of Reddit, so I don't know the ins and outs of it, other than it is a social media site where people can create accounts and post, and there can be like chat rooms, for example, or just various, as this is called, subreddits. And at this point, you've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. And right now, the record is speculative. There are no facts to support a mistrial or discharging the jury. I trust the parties will continue in their own independent investigations, that you will continue reviewing case law, make whatever requests that you deem appropriate. I certainly will take time to look at the cases you have cited to see if there's anything based upon the requests that you have made that I would need to further review. But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury. That is how I will address it at this point. I know the state, I believe, wanted to address something else. I'm not sure if that was it, but you had deferred to Mr. Brooks. So go ahead. Is there anything you want me to address or at least bring to the court's attention at this time?
Just a minor point, Your Honor. You had noted the defendant is in his orange jail uniform today. It's my understanding the jail did offer him the ability to put on his street clothes, and he declined. So I just wanted that on the record. There may be occasions where this jury has to be brought into the courtroom for one reason or another, and he should be in civilian clothes if that occurs, if he chooses to.
It's a good point to bring up. It is possible the jury would need to be brought out if there is any question that I need to answer on the record. If for some reason the technology were not to be working appropriately when videos or other evidence are displayed to them. And so it is possible that the jury would need to come out. Of course, they'll come out if and when a verdict is reached. So I would certainly give you the opportunity, sir, if you want to change into the street clothes, that I would certainly direct the Sheriff's Department to make that available for you, should you choose.
Isn't it my choice?
Yes, it is.
So why do I need to be in street clothes? Why does that need to be on the record? That
your choice should be placed on the record. So
if not, I was offered to be in street clothes. If I made it the choice.
Do you dispute that, sir?
Yes, I dispute it because it's my choice.
Well, no. Do you dispute that you were given the choice this morning?
At this point, there's no reason why that should be on the record. That if I was not offered street clothes, what relevancy does that have to?
Could have potential relevancy later on if you were to challenge that you and claim that you were required to wear your jail uniform or jail attire. You're not required. This is a trial. You have the right to wear street clothes, and I will certainly provide that opportunity should you wish to change at any point in time. But what you're telling me is it's your choice to be in jail attire. I'll respect that choice, of course.
So why does that need to be stated for the record?
I just indicated why, sir. So
I don't see the relevancy of it.
All right. At this point, unless there are any further issues, I am going to go back into my office. The courtroom will remain open, and we'll let you know when the jury communicates with us, either about a question or verdicts.
There is something that needs to be addressed. Subject matter jurisdiction.
The court declines that. I'm stepping off.
Why hasn't it been proven on the record yet?
Child. Oh my gosh. Listen. Yeah, and so you caught. Oh my gosh, this man here, liar. When I tell you, now, she said she got it that the day before in that morning. Did she say that? She delayed giving it to both parties, right? So you see how in the beginning he just looking over it like it's his first time reading it in the court, but yet you read an arm with all kinds of goddamn case law, and who all have been open. So you know, I told you a good motion should have all different types of remedies, right? Also known as relief, and if you have alternatives, right? And that's a very, very good motion. You got some alternatives, right? Most people just stop at remedies, right? He's sitting up there acting as if, child, he know damn well, him and his little crew behind that, the act is ridiculous, and he wants the damn case dismissed because of that. First of all, the language wasn't even strong enough. I mean, to really make a good case for for the case to be dismissed based on that. That's crazy. It's just so much shit. And yeah, I wish I would have covered this with y'all from the beginning, but baby, your girl be working, honey. Your girl be working till her toes be hurting. Baby, I don't see how y'all do it. I said I can do it about 2 years. I don't know. I don't know. I just might. Shit, cut back. And just be okay. Well, what I already got in the bank, baby. I ain't got time for this shit. This was some bullshit. Go back to my regular. Oh my gosh. I don't be having time to come on here with y'all, but I'm glad I put that to subscribers only, so I don't have all them goddamn weird ass distractions and shit. So we can talk about this in depth. Yes, honey. Child, I was so confused. I was sleepy and I'm out of the goddamn source. I was sleepy damn near like an hour and so into this live. I was like, oh my gosh. I thought about it. I didn't had no soda. Had all the sweets in the world, but hell. But yeah, that was crazy. And I'm telling you, with these little clips and pieces and shit, you end up watching this all goddamn day. And I just be, a lot of times I just put this on and just be looking at various points in this case. And it's like
Shortly after this happened, the next day, is that right?
Yes.
And that's the description you gave to that officer?
Yes.
You've seen news reports about this case in the days or the time since November 21st, is that right?
Yes.
And you've seen photographs of Daryl Brooks in other contexts, is that correct?
Objection. Yes. I do not consent to being called that name, nor do I know that individual. And it's
Go ahead, you may answer the question.
speculative.
It's not speculative.
Clearly.
Yes.
The person you saw get out of the driver's seat of that SUV on November 21st, do you see that person in the courtroom today?
Yes.
Objection is hearsay. How he's speaking as a first eye-hand witness.
Overruled. I believe you answered, but could you state it again?
Yes, I see him. He's sitting at the defense table wearing a suit with a blue tie and a white surgical mask.
And just to be thorough, could we please have Mr. Brooks remove his mask for a moment?
Please. Mr. Brooks, please remove your mask. Thank you. The record should reflect the mask has been removed.
How confident are you in your identification today?
100%.
Is your identification in court today colored in any way by seeing pictures of Mr. Brooks in other contexts?
Objection, speculative.
Overruled. He may answer.
No.
Can you describe the difference, if any, between Mr. Brooks' appearance today and his appearance on November 21st?
Objection, hearsay, and speculative.
It's neither one of those things. The objection is overruled. The witness may answer.
Objection is irrelevant.
It is relevant. He may answer.
Not if he identified me already, so he said.
Mr. Brooks, please. The objection's been overruled. The witness may answer.
He's got very short hair right now, and he didn't then.
What did his hair look like on November 21st?
Objection,
Overruled. You may answer.
relevancy.
Go ahead. You may answer, sir.
He had longer hair.
I'm going to ask that we put up for the witness only exhibit number 65, please.
Go ahead.
So you were able to see the vehicle behind houses?
Between houses, behind.
You said
houses.
behind. You said behind.
Right, through the yards behind the houses.
And you were able to see that from where you were?
Yes.
Can we take those marked lines and stuff down?
Oh, wow.
Can you play it a little bit? I'll tell you when to pause.
You just confirm you want it full speed?
Yeah, but I guess that would be regular, whatever is the regular speed.
Yes, please.
I'm sorry about that.
Go ahead.
Would it be fair to say from,
Do you want to pause?
no, not yet, just, you can let it play. I'll say, I think it's 36 seconds, so. Would it be fair to say from,
Well, hold on. The video's showing, so wait till it's done playing and then ask a question. Or have us pause where you want to pause.
pause? So it's paused at 18 seconds for the record. Would it be fair to say that in the 18 seconds shown to this point, you're pretty much just walking the dog, moving around, just walking normal? You don't make any sudden moves to the left to look, or you don't stop in your tracks or anything. You're just walking. Why would you not investigate that if you heard something crash? Why, being an officer of the law, why would you not investigate that if you heard that?
I was with my daughter, and I would in no way put her in harm's way.
Well, I would think it would be fair to say that you can't handle yourself. You You're obviously a officer of the law. You're trained to be able to handle yourself. Would it be fair to say that you could have at least investigated the sound that you heard? It sound like a crash, at least?
Objection.
Grounds.
Sustained. It's also a compound question. Please rephrase.
So all these thoughts, maybe it was just a drunk driver and they're gonna run anyway, and all these thoughts, and that never piqued your interest to investigate?
Sometimes being a good witness is the best thing to do. That's why I called 911 to report it immediately.
Now that's fair, but being an officer of the law, you're right there.
Again,
Objection. That's not a question. Also asked and answered. Also argumentative.
Sustained as to the form of the question. You don't need to answer, sir. Next question, please.
What if someone may have been hurt at that point? You don't think you would have an obligation to investigate if someone may have been injured at that point?
that's why I called 911.
Can you play the rest of the video?
We sure can. Go ahead.
I ain't never seen this one.
It did a weird little like motion thing. That was probably from the camera, I would guess. But in that entire video, is it fair to say that you did not reach for a phone and take out a phone from your pockets or anything in any way?
I can't tell if I did from the video itself. I know.
So when did you make the call?
At some point after you started running.
Who is you?
The defendant, the driver of the vehicle.
So how long after you saw the driver of the vehicle did you make the 911 call?
Within seconds, I believe.
Is it fair to say that we don't see that on the video?
The video is very small at that point. It's hard to
Is it fair to say we don't see you do that on the video?
Yes.
Can we pull the video back up? Can you take it to 27 seconds and pause at 27? Maybe 28. I may be mistaken. Maybe just go one more second. Maybe to 28. Or you know what? No, keep it paused right there. Would it be fair to say that you noticed the vehicle in this area right there?
Yes.
Can you remove the X? And what do you see right there?
I don't understand.
Do you see anything right there? An individual, anything? Do you see anything right there?
It's
inside
hard
the
to tell
circle?
from that picture what I can see.
Can you move it? Can we blow it up a little bit or move it closer? Just a little bit?
I don't know that it can be zoomed in. Does that
Can it-
state
can
have
it be
that
zoomed in?
capability?
So we can zoom in as long as the defendant's okay with dispensing with any technological foundation issues there. But we can zoom in. We have the ability to do that.
Would you like it zoomed in?
What do you mean by not, say that again? I'm sorry.
We can zoom in if you want to.
Can you zoom in just a little bit?
Zach on his ass, baby. Zach from that new era.
That's the extent of our zooming capabilities with this
No,
software.
that's fine. That's fine. Can you see anything there?
It looks like something white. I don't know if that's the driver.
Looks like something white.
Yes, it's light colored.
White color what?
It's light colored.
Light colored, but you did say white. Is that fair to say that you just said white?
I just did say white.
Can you erase the circle? Zoom back out, it's like a box there in the corner that's kind of throwing the whole exhibit off. take it back to the regular. You testified earlier that you saw the driver with gray hoodie, as you referred to it. Do you recall saying that?
Yes.
Would I just circle right there? Would you, from your recollection, say that that was the driver you saw?
I don't know what that is at this point.
You don't-
It's
you
just
don't
a
know?
paused video. It could be a glare, could be a person. I don't know. You could play it again.
Well, let's play it again.
From the 27th.
Stop right there.
Okay.
Yeah, from the 27 mark. I think it just played maybe what, half a second or something like that. Did you see that whatever you said you didn't know what it was, could have been a person, could have been something else? Did you see it move from the position that it was before?
Yes.
And you also identified that that was white, right? That's what you said, correct?
I did say that.
And would it be fair to say that you saw the driver in gray? Would that be fair to say?
Yes.
Take the circle off. You also stated that you were about 50 feet from the, well, you added the vehicle in too. You said maybe 50 feet, and then depending on the length of the vehicle. Would that be fair to say?
Yes.
And from where you are here to here, because it would be fair to say we can't see a vehicle in the picture at that point. Would that be fair to say? We can't see a vehicle that would be facing you because you said it was facing you. We can't see a vehicle. Would that be fair to say?
From this angle of vehicles obstructed, yes.
So that would be 50 feet from, approximately 50 feet from X to X.
Approximately.
And you were able to see the driver and a description from where you're standing now to where the other X is.
Yes.
And you were able to make out the race of the driver from where you were at.
I guessed.
You guessed.
Raced.
So you're not for certain.
I wasn't for certain at that time.
When did you become certain?
So what conclusion were you coming to at that point? Just an educated guess, or
can you explain further?
Conclusion for what? Would it be fair to say that your guess could have been inaccurate?
Could have been.
And you also stated that you saw news reports and the description of the driver on the news. Would that be fair to say?
Yes.
And you made reference to the driver's hair. Would that be fair to say?
In my testimony, yes.
You brought up the hair is what I'm saying. You said long hair. That'd be fair to say?
Yes.
And you will be able to see hair if you describe the driver wearing a hoodie?
Yes.
You'll be able to see hair and tell the length of the hair.
If it's hanging out of the hoodie, yes.
Well, you didn't say, all fairness, you didn't say it was hanging out of the hoodie. You just referred to the hair.
Yes.
That's not a question. It's argumentative.
Is it?
Hold on, there's been an objection. I believe the witness understood the question, so I'll overrule the objection. His answer may stand. Next question.
Is it any possible way you could have gotten a description from the news reports instead of what you actually recall?
No.
And how did you determine that?
In the report I gave in my statement, I described what I saw that day, not what I saw in the news.
And you also described two different colors of dress. Once you said gray and one you said white. Would that be fair to say?
I said that the item in the video appeared to be white.
Did you not say that the item moved? As you say item, did you not say the item moved from where it was at?
Yes.
would it be fair to say that there can be no movement to an item if it wasn't a person?
Yes.
A person that you described wearing white?
On the video screen, it appeared white. It appeared light colored or white.
Would it be fair to say that you said white? That was your first?
Yes.
Honey, he done been and got on my goddamn nerves.
At any time in that video, could you see hair?
In the video?
In the video.
You can't see very much in the video. No.
After making the 911 call, did you return back to the scene where you noticed the vehicle?
Yes.
And did you investigate at that point?
Yes.
So what changed from the point that you heard a crash, as you say, and then returning back to where you saw the vehicle? What changed between those times?
As I was talking to the 911 dispatcher, I wanted to give them better details about the vehicle. So I walked back over to.
So at the time that you initially made the 911 call, there was still details about what you saw that you were unsure of. Would that be fair to say?
I believe they asked me what the license plate was, and I couldn't see it from where I was at. So I walked back over to give that to them.
So you couldn't see the license plates of the vehicle from where you were at?
There was no license plate on the front of the vehicle, so I could not see it.
So you came back to investigate if there was a license plates that you can identify?
Yes.
Did you investigate what you may have heard the vehicle strike?
No.
Any reason why not?
By that time, a large crowd had gathered and there were sirens. I could hear them in the distance, and the police were responding rather quickly.
So you didn't take the opportunity to see if anyone from saying that you heard a loud crash, you didn't take the opportunity to investigate if anyone may have been hurt from that loud crash?
I didn't know.
Any reason why not?
No reason.
He's doing a decent job with this line of questioning, though. I've never seen this one.
Any other details about the driver that you can recall as far as further clothing?
No, I thought at some point I saw a Packers logo on his clothing or something to that effect.
Did you put that in your report?
Yes.
At any time, have you read or saw a complaint in this matter?
No, just my report.
Any other officers that came to the scene? Because you made reference to officers was responding by the time you came back to give more details to the dispatcher, more officers were arriving. Do you recall if any one of those officers investigated the loud crash you heard?
I'm unaware.
But it would be fair to say that they gave reports from what they observed when coming to the scene. Would that be fair to say?
Yes.
Do you recall any of them asking you of a description of what you saw?
I didn't speak to any officers on scene that day.
Any reason why not?
I just left.
Seeing as how that you made the initial 911 call, I'm sure the officers were probably responding by that time anyway, but seeing as how you made the 911 call, you didn't collaborate with the other officers to try to,
That may be argument.
you know, like piece together what you may have saw?
I'll object to the characterization that that was the first 911 call.
Sustained.
I didn't say first. I said he made the initial 911 call.
Initial means first, so sustained is to the form of the question.
Form, that means you got to re-ask it a different way.
Besides, well, let me back up. After seeing the description on the news, did you say to yourself, that's the driver that I saw?
I recognize the driver as the person I saw on TV.
So this is the reason why, as a prosecutor and in defense, you need to know your case, right? And the only way you know the people the attorneys that's gonna know the case are attorneys of record, because they don't want to get the files. They don't want to get the files, right? We don't have them. So Zach right off knew that was to object to mischaracterization, because Zach knows the file. He knows that he is talking about the initial call to 911 and not this call, that the line of questioning that Mr. Brooks is proceeding with, right? So Zach is on top of it. See, Zach took that UBE, right? Zach is on top of this bullshit. See, he would probably take Dana ass down with all that shit that Dana was talking about, all that born in Taiwan and all this bullshit, whatever. Zach would have been on it. Zach over there rotating that pen through his finger and shit, sitting on the edge of that chair. Zach is on it. The rest of them, them old motherfuckers that's sitting on the other side, that took a series of tests. UBE, that's just one test. The rest of them old motherfuckers took the same test. I took like about 5 of them. They about sleep. Zach is on it. He the only one. Objection. But I never heard this, so this is funny.
Social media.
Social media or the news?
I don't recall. Probably both.
Both. Did you report that?
When I gave my statement, that's what I told them. Yes.
And did you report that description before or after you saw it on the news or social media, or both?
I gave a statement the very next morning. I worked at 6 a.m. I reported it to my supervisor, who contacted Waukesha investigators and had one of our detectives take a statement from me that morning. The statement that I gave them was from my experience at the scene, not from what I saw on TV or social media.
So it would be fair to say by that next morning, you had already seen reports on the news or social media?
Yeah.
Or
yes.
both?
Yes.
And your report was the next morning. So could it have been fair to say that that's where you got the description?
No.
Did you learn any additional information that you don't recall having via social media or the news after you had already made your report?
I don't understand the question.
Did you learn any additional information after you had already given your report?
Learn information about what?
About the description of the driver, what had happened at the parade, anything?
Well, originally I had no idea what had happened at the parade. I thought it was just, I witnessed a hit and run crash. I had no clue what had happened at the parade.
So you just said now you witnessed a hit and run crash, but you also said that you didn't investigate the crash that you heard.
Correct.
So how would you characterize it as a hit and run crash if you never investigate what you heard?
Because I heard a crash and then the driver ran.
Well, you also stated, to be fair, that you didn't investigate the crash. So how was it any way to know what you were witnessing if you didn't investigate it?
Because I heard a crash and I saw the driver run. So in my mind, I assumed that was a hit and run crash.
So it was an assumption, you didn't know?
Yes. I heard a crash. I didn't see the crash.
Correct. So would it be fair to say that from the assumption that there was a hit and run crash, as you say, the only way to know for sure where the crash came from would be to investigate it? Would that be fair to say?
Yes.
And you stated for the record that you did not do that, correct?
Yes.
So why would you report it as a hit and run crash if you were not sure what it was?
Well, based on my training experience as a crash investigator, that's what I thought it was.
Nice comeback. Look at Zach. I knew he had that pen. Look at Zach. Zach ready. Zach is on it. She ain't got to tell him shit.
Did you talk to any of the people that lived in those houses to see if they had heard the same thing you heard?
I spoke to maybe a resident of the apartment or the house right there who just said that the vehicle didn't belong there.
Did they report to you that they heard any crash?
No, not that I recall.
Did they report to you that they saw a driver?
No.
So as far as you can recall, you were the only one that heard the crash?
As far as I know, yes.
No further questions.
Any redirect?
Yes, please, thank you.
Oh, he ready.
You testified that you didn't investigate the sound of this crash, correct?
Yes.
Were you off duty that day?
Yes.
When you're off duty, do you carry a police radio with you?
Objection.
Is she a sworn law enforcement officer?
Objection, irrelevant.
Overruled. You may answer.
No.
At the time you heard the crash but didn't investigate it, did you know that the vehicle that you saw had been involved in hitting dozens of people on Main Street minutes earlier?
Objection, asked during cross, answered.
Overruled. He may answer.
I had no idea.
When the driver got out, and just to clarify again, who was the driver?
The defendant.
Daryl Brooks.
Daryl Brooks.
Objection, I don't consent to being called that name, and
Mr. Brooks, I'm sorry.
I don't consent to being called that name.
So noted. Next question, please.
Did you see anybody else get out of the vehicle?
No.
When you went back to check the vehicle, was there anybody inside?
No.
On this issue of the white clothing, can we please show for everybody exhibit number 120, which has previously been published?
Go ahead.
Zach, so man, I'm gonna tell you why. Tell you why in a minute.
You see exhibit number 120 on the screen in front of you?
Yes.
You see the person who appears to be behind the driver's wheel of the red SUV in that picture?
Objection, what is the relevancy?
Overruled. He may answer.
Yes.
How would you describe the color of the shirt that that person's wearing?
Light gray or white?
Boom. Boom. Tell
That's
him,
all I have
Mom.
for this witness.
All right, thank you. You may step
I
down.
knew they was gonna rest that. That was gonna be the last question. Listen. Oh, that was beautiful. That was beautiful. Oh, good night, baby. Good night. That was beautiful. That was beautiful. Let me tell you what just happened, child. Zach had to get him because actually Daryl Brooks did pretty good during that line of questioning, right? What Daryl Brooks left off, where he made a mistake is he didn't he didn't. Okay, let me rewind. Right. One of the chief objectives is when you get somebody on the stand is to make their whole entire testimony, if their entire, at least bulk of it, not credible, right? Or incredible. Okay. Same thing. And one way of doing that is pretty much what Daryl Brooks did, make him seem unreliable as a witness, as an eyewitness, right? He's unreliable as an eyewitness. He's challenged, his sight, right? He's an eyewitness, challenged his sight. One of the first things you want to do, right? So he said the color was white. I mean, he zeroed in when he said white, right? And he clearly was wearing something gray. He challenged his protocol. Okay. See, Darrell didn't, and this was probably done, but he probably didn't even know he did it, but it was good that he didn't distinguish whether he was on duty or off duty or blah, 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 blah. At that point, it matters, but it doesn't in his case, right? So he was asking, because guess what? See, if Darrell was sharp, if he was attorney, he would have kind of reinforced the fact that whether you are off duty, but he had no way of knowing that Zach was on his ass. But if he would have thought about it, he could have reinforced that, hey, your protocols, your procedures, your practices, teaching in pairs, is to say, hey, that would be something that should be like a routine to you, whether you off duty or on duty. Okay? Whether you off duty or on duty. You know what to take note of in your head if you don't have a right instrument. You know how to call it in. You know what you're looking for. You know how to keep your eye trained on the movement. You know all blah, 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 blah. You know to give the person that you're calling into enough information as possible, right? To feed to the specialty of the units and blah, blah, blah. Y'all know the routine. Okay? So he did pretty good. He just didn't, go to places that he needed to go. But he was calling in his question his eyewitness account. Zach seized in on that. That's why Zach came back with his line of questioning. All right? Because it ain't too often when you get a pro se defendant, unless they, are pretty sharp, that you got to come back and do a redirect, right? So Zach asked, that's why he asked, were you off duty or on, were you off duty or on duty? The dude was off. That's to give an excuses why he didn't follow the normal protocol, right? Then he said, what does he said? He came, asked them, and see, they both of them, they know what they was doing. Zach was hoping the cop picked up on when he asked, he said, well, what color, when talking about the shirt now, what color does that look like, right? That cop automatically knew to say, because he knew he had them fumbled a little bit. And Daryl Brooks was on his ass a little, you know. He knew to say that looks like light gray or white. Now you and you know, my ass can't hardly see. But that looks like gray in that exhibit. That clearly is darker than what Daryl Brooks zeroed in on. But that caught that telepathy, right? Then knew to say light gray or white. You see how you put white in there? Okay. And I knew right then that they were going to end on that last very strong question. Zach was like, we ain't gonna let your ass get goddamn shit a BB in. You know, we ain't gonna let you get shit in. Okay, so he did pretty good on that. Sound like when we can do it like this and have something to break down. I hope that I want to play Mr. Irby so bad, but I don't want them to get me. But that testimony about Mr. Irby was the funniest shit ever. Hold on. And I hate to keep y'all, but hell, I ain't been here in a minute. I got some time if y'all don't mind. If y'all don't mind, let me know if y'all mind or not. I'm gonna play it anyway, but let me know if y'all mind. Y'all can go to bed if y'all want to. I just want to play what that dude name? Honey, this shit here was so damn funny. I played this several times. I hope they have it. They don't have it with I hope they have it with oh shit, what the dude name is. What the damn dude name? Oh gosh. What is that goddamn man name? What was the dude name? Say it's you. The little smart aleck dude. Oh, I ain't never seen that one either. The funny one, y'all, he says you. I'm gonna play this law and what the dude name is? Nicholas Kirby. I'm gonna play this one by Law and Order, and I hope they don't get me, but shit. This is when it got kind of dicey in there. Hold on.
No.
She was mad, baby. Hold on. I appreciate y'all. But this was a good one too. She got mad as hell. It's Nicholas Kirby. That's his name. I hope Law and whatever don't get us.
This is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well aware.
He said social media.
Nothing
he didn't say what it was.
Sir, stop interrupting. We have to make a record of it. You've
Make the
interrupted multiple times. I've been abundantly patient with you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at me. Stop rolling your eyes at me. Stop mumbling.
I'm looking right at you. I'm not rolling my eyes.
No, you have throughout. I've seen it and I've made note of it.
I'm looking at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Go ahead, Attorney Opper.
Thank you, Your Honor.
I'm gonna take that
and
as
just to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks
He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video, which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video.
So remember, I just talked about challenging the eyewitness. He's an eyewitness. What you want to challenge the site, right? You want to do that. So I'm just recapping what she's saying, as well as we talked about when one side open the door, the other one gets to come in, right? That means you broach a subject, we get to go there, okay? Because you brought it up. We get to, hey, we get a part of it too. If you don't want nobody asking questions, you know, on a particular area that is going to be, you know, it can go either way, but it may blow back on your ass. It may hurt your case. You probably shouldn't go there.
He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought, would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up, and whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law. He can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks, because again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands.
So that was a lot right there, let me tell you. So this is where I was trying to tell y'all on the message board, where the court, which is the judge, and the state, they were covering each other's ass. Okay, what you heard the prosecutor say, all was laid out on the record, right? That's why the judge thanked her instead of saying, she didn't like her tone, or not saying, she could have said something else. She thanked her for putting that on the record. You notice that? She didn't have to say that. But she's acknowledging that I know what you're doing. You're covering both our ass, just in case something comes up on appeal. All right. They also, you see how careful they are playing with him as a pro se defendant, because playing the words to that video could have been some kind of kill him, murder him, shoot him dead, whatever lyrics in there. That could have been prejudicial because it could have made him look just like a murder, right? What he did. So they didn't play it. She had a second thought. So yeah, let me not play it with the, with the words. Just show him in the car that's in question, right? The red SUV. Also in that powerful clip, she was able to put on the record that exhibit of the video was discoverable, right? Because one, it already existed. He knew about it. It had the SUV in question with him in the video, and it's admissible. And it went right into discovery, and when it got published and everything, became evidence. So they're doing everything above board to cover their ass just in case something comes up, because they have caught on to this guy can throw a lot of bullshit. Okay, can deploy all these little schemes and this little scams and all this sovereign stuff and all this so they are on his ass. So they are, dotting their I's and crossing their T's. And this is what, they should be doing. So, hold on. I want to play Nicholas Kirby, and I'm going to try to get up out of here. But Nicholas Kirby, y'all, was so funny. I know y'all saw him. Y'all was laughing. Where's Nicholas Kirby? Oh, wow. Trying to find. Oh, is it? That's him. Okay. Here we go. This funny shit here. Oh, I don't want to play his. I don't know him. Where is I strike my ass. I don't know him. What is Nicholas Kirby? This was so funny because Nicholas Kirby went at him about that, not like questioning that sovereign citizenship, but talking about, it's like, no, it's you. That's your name, which was hilarious. Sorry, y'all. Hold on. Let me see. Is this it? Oh, yeah. This is. Yeah, this is funny shit. Hold on. This white man was so goddamn mad. When I tell you, and back for the record, I do not like this dude. I don't like no bullshitter and all this wiggle around shit and all this here. Just I don't like all this. And he did too much of it for too long. But look at all these antics and these faces and shit.
Just want to make it go smoothly, sir. That's all.
Since I'm working off this list, I wasn't expecting that to be first.
Who do you want to call first?
Full of
We'll see if
shit.
they're here.
Well, sorry.
That's okay.
Apparently, this list is who's here, I'm guessing.
That's my understanding as well.
He's full of shit.
Not you. Is there someone you expected to be on the list that is not?
Kinda.
Do you want to make a record of that? Do you want me to address it in any way?
No, not right now.
He lied.
All right, well, then I'm going to instruct the jury to come out, and then you can call your first witness.
Look at all this shit.
To go meet with Mr. Brooks.
You made reference to.
Hold on.
And what were you doing that day?
What time of the day?
Around 3 o'clock-ish.
3 o'clock-ish. Around 3 o'clock-ish, I was walking with Corey around Waukesha. Earlier, well, yeah.
And you made reference to walking with Corey. Who is Corey?
Corey is a friend of Miss Patterson's.
And would it be fair to say that it's also a friend of yours?
Mutual friend, yes.
In reference to Corey?
Yes.
And what were you doing?
Walking around Waukesha. She was waiting for Miss Patterson to get done meeting with Mr. Brooks. You?
At 3 o'clock?
Around 3 o'clock-ish. Around that time, I had advised her not to go meet with Mr. Brooks.
You made reference to Mr. Brooks. Who's that?
That would be you.
And why would you say it would be you. That's you.
Because that's your name.
And you were privy to that information at the time?
I was privy to the information about you about a week prior to this incident.
About a week prior. And during your walking around, what were you doing with Corey?
Walking, like literally walking. We went from one store to walking around downtown after Erica told us she was going to be going to meet with Mr. Brooks. That would be you. I had advised her not to do it because it was a bad idea, and I was in fear for her safety.
You made reference to going from one store to another. Which stores are you referencing?
Dollar General and Speedway.
Did you go anywhere else?
No.
Did you ever go to a park?
No.
You made reference to knowing about a Brooks a week prior to these events, you said?
I didn't know everything about him. Miss Patterson had showed me his rap sheet, if you will, and a picture of him, and that was about it. I had heard prior
I'm going to stop the witness unless you want him to go there, not to discuss what may or may not be conduct of Mr. Brooks prior to November 21 of 2021.
Okay, because that would be opening the door, and that would be discussing other like wrong acts, evidence, that type of thing. And like I said, that could lead into the area of talking about his character or propensity, right, which is not allowed. The prosecutor will be skillful enough to get around that. But the whole problem is, if he would have continued with his answer, that would have been opening the door, because Mr. Brooks wouldn't have known. And as you see, he did not stop him and say, Judge, can you instruct Mr. Brooks to strike the rest of his testimony, that the any part of his testimony, or should have stopped him. But you see, he did not know, so the judge stopped him before it could have created an appellate issue for her court. So
With that understanding, go ahead and ask the next question.
oh, I'm sleeping.
You made reference to a picture you were shown?
just a photograph with a rap sheet behind it.
And at some point, did you and your mutual friend Corey meet up with Miss Patterson?
Yes.
Do you recall where that was?
Corey and I were in the Dollar General area of Waukesha, which is between East and Broadway Street. We were walking away from Dollar General towards where Erica had said that she was being assaulted and attacked.
And do you recall where that area was?
Yes.
Where was that area?
On White Rock Avenue, right across from White Rock Elementary, in front of the red apartments across from that area.
Red apartments?
Yes.
Do you know what those apartments are called?
I do not know the name. I'm guessing they're called White Rock Apartments.
And do you know if there's a park in that immediate vicinity?
There is a park there named Frame Park, yes.
Did you ever go to Frame Park?
No. We were in that area near the park where the elementary school is and the apartments are.
About what time did you and your mutual friend Corey meet up with Miss Patterson?
Ms. Patterson called me and said that she was.
About what time was the question? About what time?
And I'm getting to that.
The witness answering those questions specifically. What time?
Honestly, around what time the parade started. I would have to say like dusk. I honestly don't wear a watch, so sorry, I don't remember the time. But if I had to put it at a time, I'd probably say about 4:35-ish.
Let's back up a little bit. Around what time did you and your mutual friend Corey first hook up that day?
I had worked that whole day, so we didn't meet up until I was done working, which was probably about 2:30, 3 o'clock.
And at some point, you received a phone call from Miss Patterson?
Yes.
You yourself?
Yes.
And then at that point, what did you do?
When she told me that she was in trouble and she needed help, I went to her aid, which means I took off from where I was near Dollar General and ran to where she told me to go.
And when you got there, what did you see?
When I got there, well, halfway towards White Rock Elementary, I stopped a police officer at a barricade and I let him know that a woman was being assaulted in a vehicle.
And do you recall giving a description of who may have been assaulting your friend?
No.
Why not?
Because at that point in time, the description didn't matter. I had the identity of the vehicle. So I told them you need to be looking for a red SUV with a woman screaming out of it.
And how did you come into the knowledge of the description of the vehicle?
Because I saw the vehicle.
At what point did you see the vehicle?
When Corey and I were walking up White Rock Avenue on the apartment building side of White Rock, which would have been my right if you were walking towards the train tracks that crossed White Rock. On my left was White Rock Elementary. I walked past the red vehicle, didn't realize that she was in that vehicle. Then Corey and I crossed the street to White Rock Elementary and started walking down the sidewalk. And I heard her scream, Miss Patterson scream. I don't remember exactly what she said, but she screamed and I knew it was her. So I walked back across the street and escorted her across the street over to White Rock Elementary.
I don't think that's what
I'm just giving you full description.
Let's back up a little bit because that doesn't make sense. You stated that you had a description of the vehicle. Would that be fair to say?
Yes.
The question was, how did you learn of the description of the vehicle at that point?
Ms. Patterson told me over the phone that she was in a red SUV. There aren't many red SUVs with young women screaming for help in Waukesha.
So I'm assuming, because you made reference to stopping law enforcement before arriving to the scene. Would that be fair to say?
Yes.
So I'm assuming somewhere in the time of you stopping the law enforcement officer to report what you were being told, and then actually walking past the vehicle as you said you did, and then hearing this and all this, did you give a full report to law enforcement?
At the time when someone was in help and needed help immediately, absolutely not. I said there's a woman being attacked in a red SUV. You need to call for backup now.
And then you just ran.
And then I ran towards the person that needed help.
He's so mad. That's good white people. That's what I'm talking about right there. Good
Did
white.
you at any time give a more detailed report that evening?
No, not that evening.
Did you speak with any more law enforcement that evening?
Yes.
Do you recall whom that was?
I do not recall the officer's name that showed up in the SUV coming down White Rock, in the police squad SUV. I don't even know the name of the officers that turned into Frame Park and went to the boat launch instead of where Miss Patterson, myself, and Corey were. But yes, I did speak to an officer.
How did you come into the knowledge of where officers turned and went?
Because me, Erica, and Corey were arguing with Mr. Brooks on the side of the road of White Rock, right in front of White Rock Elementary. And the officer that I had stopped at the barricade when we were coming to Miss Patterson's aid had radioed for backup, and obviously given them description of the vehicle that I had described to them, the red SUV. That backup came, but they went to Frame Park. They did not go to where we were on White Rock.
Any idea why they went to Frame Park if you specifically told them a description of a vehicle and where it was located?
I did not tell them where the vehicle was located because at first incident, Mr. Brooks had taken off in his SUV.
China people was calling him George Jefferson, all kind of shit. Look at Zach. Zach, boy, he want to fight him.
In the police report, and is it fair to say that the officer that took your report was writing down what you told them?
You mean the officer that I alerted about the trouble in the SUV?
Well, let me back up. On the next day, the 22nd of November of 2021, did you speak with a detective at that time?
Yes, I did.
And during that interview, were they writing down what you were saying?
I believe so, yes, but I believe it may also have been recorded on tape. I'm not sure.
And do you yourself recall stating to the detective that your friend Miss Patterson was being assaulted somewhere near the area of White Rock School?
Objection, lady.
Overruled. He may answer. I'll just caution Mr. Brooks about leading questions since it's his witness, but this particular question you can answer.
Yes, I mentioned that I had received a phone call from Miss Patterson and that she was being assaulted while in a vehicle.
At any time, did you identify White Rock School?
I identified the street, which is named White Rock, the apartment buildings, and the school as well as Frame Park.
So you did identify Frame Park.
I identified the entire geographical area.
And at some point, you said you heard your friend Miss Patterson screaming.
Yes.
And do you recall what she was screaming? I said, do he recall?
As the form of the question, he's asking, did he hear? So you may answer. It's a yes or no.
I do not. Yes, she screamed. Do I remember what she was trying to say? No, I'm guessing it would be help. I'm in trouble. I would assume that that's what a person would scream when they're in trouble, is for help.
Ooh, that good white man is getting upset.
Do we still have the exhibit with the footage from the White Rock School available?
The security footage?
The security footage, I'm sorry.
We do. Would the state be willing to pull that out?
I guess I need the defendant to identify which exhibit he would like us to publish.
There's 3 and 4.
Let me show y'all about good white people. Hold on.
6 of which belong to her.
And all around the same time?
All around the time. She obviously didn't want to get off the phone because no one calls me 6 times in a row unless they need some help.
Can we continue to play from 138?
Go ahead.
Parked in that general area?
You literally just played the video where the vehicle
Just
turned
answer the
around.
question, sir.
And mark this video. It's a little hard to see houses and things of the like. Can you point out
He's so full
in
of
what
shit.
area the red apartment you're referring to might be?
It's a touch
It's
screen.
a touch screen, so you can.
You can make an arrow point in the direction if that's helpful.
Not good with technology, guys. Sorry. I'm a dirt digger. Okay. This is the entrance. This is the entrance to White Rock Elementary. Across the street and up maybe 20, 30 feet, there's an intersection leading from an apartment building to the White Rock campus. That would be up here in this general corner right here. This whole area.
Would it be fair to say that from where we're paused at in the video, we can't tell if there's any vehicle parked in that general area?
You literally just played the video where the vehicle
Just
turned
answer the
around.
question, sir.
No, you cannot see it from this angle.
We please clear the
Yes.
arrow. Thank you. Would it be fair to say that where the video is paused now, that Miss Patterson is not, or who you identified as Miss Patterson is not inside of a vehicle?
She is not inside of a vehicle in this video, no.
Can we play it from 1 minute and 47 seconds?
Go ahead.
pause there. At this point, had you come into a range where you can see Miss Patterson at that point?
No.
The record video's paused at 2:13.
I'm sorry.
It's all right.
2:13.
Keep going.
I mean, they have to
And
give
you
the
made
time
reference to your
so
friend
it can
Corey
be on the record.
spotting her first.
Yeah.
Is that correct?
Corey had said that she thought she had seen her across the street, and we looked, and we crossed the street once, and then we crossed the street back over. Then we crossed again for a final time.
I'm trying to
That
get
was
the
until
part
later
when
when the
you
incident with
got
Mr. Brooks took part. It took place.
And at this point, we're referring to?
Where that intersection is, where I just drew that little X, that intersection cuts across from the other side of White Rock to the other side and leads to the.
Can you see Miss Patterson where her position is at that point?
No.
Can we play it from right there?
Go ahead.
Can we pause? It's fair to say that we can see you and Miss Corey running towards the area of the vehicle that just stopped. Is that fair to say?
Yes.
And where was Miss Patterson at this time, if you recall?
At that point in time, she had met up with Corey. Corey had walked ahead of me, and her and I were looking for her. I didn't see her right away. Corey did. And she just told me she's in a red car. So that's what we were looking for.
At that time, was Miss Patterson inside of the vehicle?
I do not recall. But what I do recall is the owner of the vehicle getting out of the vehicle, and that became my primary concern.
So fast a little bit. We observed the two, you and Miss Corey, running towards the area of the vehicle. Why such the urgency?
Miss Patterson is a mutual friend of ours. She said she was in trouble. I don't play around when people are in trouble.
Can we play it from, it's paused at 3 minutes and 8 seconds. Can we play a little bit of it from there?
Go ahead.
Pause right there. Can you see Miss Patterson? It's paused at 3 minutes and 11 seconds. Do you see Miss Patterson in this video? Where's
Yes.
paused at right now?
Yes.
Is she inside the vehicle?
No, she is not.
Had you seen her before that?
Corey had spotted her, not me, before that. She did.
But it is fair to say that you're also in the area at
I
that
am
time, correct?
not in this general frame, no. I'm
Not
actually outside of the frame.
not the video, but you are present on the scene. Would that be fair to say?
Yes.
And what happened at this point, if you recall?
At this point, there was a physical altercation between Mr. Brooks and Miss Corey and Miss Erica. I was more worried about Miss Patterson being hurt, so I went for her to get her out of the way. I stepped between them as best I could, and I told Mr. Brooks he needs to leave. He needs to get out of here. Does not belong out here.
Do you recall if there was a knife involved at that time?
No, that is a miscommunication. And I will clarify that. The Monday.
Hold on, there's not a question yet.
Okay.
He'll ask the questions. I appreciate that, but just answer the questions that are asked at this point. Go ahead.
Did you at any point during this
I can't stand his ass.
Did you at any point during this altercation, did you observe Miss Patterson get back into the vehicle at that point?
I observed her reaching into the vehicle for something. I don't know if she was grabbing a purse or something or whatnot. She she was grabbing something of her personal property out of the vehicle
Did you observe
while
her?
this was going on.
Did you observe her get into the vehicle?
No.
Can we play it from 3 minutes and 11 seconds, please?
Go ahead.
Pause it right there. Did you see yourself come into the frame in this vehicle at that
Yes.
point? Would that be you there?
Yes.
It would be fair to say that you had some type of jacket on, or a black jacket?
At one point,
that
yes.
evening? What happened to your jacket at that point?
That jacket hit the ground as soon as Mr. Brooks started going for the two women.
So you threw the jacket off?
Mm-hmm.
Is it a yes?
Yes, ma'am.
Thank you.
And what was your reason for throwing the jacket off?
Well, if the court don't hate me for it, I'm just going to say it's a good thing that there were two women in my way at that point in time.
And what do you mean by that?
That means when my jacket comes off, trouble's going to happen. Especially if you're trying to assault a woman in front of me.
So that gesture was an aggressive gesture.
Oh, that was a completely focused gesture.
Well, you did make reference to, let me back up. Would it be fair to say that you just made reference to trouble following you throwing off your jacket?
No, not trouble following me.
Well, maybe that's the wrong way to put it, but
I'm confused by your question.
Excuse me?
Can you rephrase your question?
Oh, I will. I'm sorry about that. You made reference to there being trouble when your jacket comes off. Is that fair to say?
Yes.
Would it be fair to say that that would be, or that could be, perceived as an aggressive gesture?
You mean as an...
Objection. Calls for speculation. How it's perceived calls for speculation.
Sustained as to the form of the question.
If you recall, who gave the report that there was a knife involved?
That was not put into a report. That was a miscommunication between me and an officer. I had been knifed earlier that week and had 12 stitches in one hand. I said, now I have a friend being assaulted and I need backup here. So when the police stopped and asked if there was a knife, I said, no, there was never any knife. I didn't have a knife. Miss Patterson, Miss Corey didn't have a knife. You didn't have a knife.
Did you get a chance to see the report that was taken by law enforcement from you?
Well, I'm the one. You mean you're talking about when I was on White Rock going to Miss Patterson?
No. The day of November 2020, the day of November 22nd, 2021. You made reference already to being interviewed by a detective, correct?
Yes.
And had you, after that, seen that report from that day?
No.
And you stated that the reporting of the knife was a miscommunication. You
Yes.
referred to it as.
Yes.
Did you at any time tell law enforcement that there was a knife involved in the altercation?
No.
Do you know if your friend Corey told law enforcement that there was a knife involved in the altercation?
No, she did not.
Do you know if your friend Miss Patterson told any law enforcement that there was a knife involved in the altercation?
She did not as well. No.
This shit is so nice. That white man so goddamn mad.
And how long before the incident on November 21 of 2021 had you known Miss Patterson up until that point?
Probably maybe a week and a half, 2 weeks.
Good white people.
I want to back up to the phone call that you received from Miss Patterson.
Okay.
When she called you, did she give you a name of whoever may have been assaulting her?
She didn't have to. She was meeting one person that day, and I knew exactly who he was because she had showed me his picture and rap sheet prior. Her child's father, the father of their 15-year-old daughter, is who she was meeting up with that day. And I told her multiple times, it's not a good idea. I have a bad feeling about this.
Do you recall stating, well, actually, you testified to that here today. Do you recall stating that you walked past the red SUV that was parked?
Yes.
Would it be fair to say from the two exhibit videos that we watched today that you in fact did not walk past any SUV?
I most definitely walked past an SUV that was red on White Rock Avenue. Whether or not it was your specific SUV, it was still a red SUV. Up until this point, knowing Miss Patterson, I didn't know anything about the father of her child. I didn't know anything about his background except for what she showed me over the phone. Anything about his vehicle description, why would she need to tell me that?
Is it fair to say that the video doesn't show you walking past any red SUV?
If the video,
is that fair to say?
If the video proves that, then yes.
In the report that you, well, in the report that was taken from you by detective, do you yourself recall stating that the alleged defendant tried to punch and push you?
The alleged defendant being you? Yes. Attempted to.
Would it be fair to say from the video that it doesn't show you being pushed or?
No, it does not. It shows me pulling two women away from the situation.
Any reason why you would state to detectives that the alleged defendant attempted to punch and push you?
Probably because there were three different people's fists flying, and I was just trying to get the people that I cared about out of the way of danger. So if my statement to the detective is off a little bit after watching a bunch of people get run over, I can understand why.
So you were at the parade that day?
I was not at the parade that day. I was in the area
So
trying
how
to get back to my house.
so how can you watch people being run over if you weren't at the parade that day?
I wasn't attending the parade. I was in the area that the parade route was in. My street is the parade route.
Did you see anyone injured that day
When
during the parade?
Yes, after I walked back through that area,
You saw someone get injured?
I saw a red SUV take off like a bat out of hell down Main Street and
you
go
see-
through a crowd of people.
The question was, did you see this take place?
With my own freaking eyes, yes. How many times do I have to say yes for you to understand it? YES spells yes.
I'm sorry, Your Honor, I don't know how to.
You moving to strike the last response? The jury will disregard the last
I can't stand him.
response. I'm just going to remind
oh.
those of you, please answer the questions that are asked. Follow-up needs to take place. Either Mr. Brooks or the state will ask.
Is it
Just don't
fair
let it go.
in reference to the Exhibit 3 video that we just viewed?
You're talking about the one by the elementary school.
Yeah, the one
Okay.
the one that we just viewed,
Just checking.
which would be Exhibit 3. Is it fair to say from that vehicle? Got me.
Video.
I'm sorry. From that video, is it fair to say from that video that, in fact, there are not 3 people throwing punches? That'd be fair to say?
There are 3 people throwing hands in that video: Erica, Corey, and Mr. Brooks. Not myself. If you watch the video, you will see 3 pairs of hands go up towards one another. Whether one is stepping in to pull someone away from another or not, hands are being brought up.
Do you recall where you went after that altercation?
You mean where me and the 2 girls went? Where me and Miss Patterson and Miss Corey went?
Where you and
we
your 2
started.
friends went? Yes.
We started walking back. We turned to walk back the direction we had came, so taking White Rock to Main Street, and then cutting through the neighborhood there to get over to where the women's shelter was. That was where we were going at that point in time. However, things took a drastic turn when the red SUV that I have described multiple times went down the opposite direction of White Rock Avenue, across the railroad tracks and the intersection of Perkins and White Rock, and then turned back around and came back down. That is what you saw in the video here when the red vehicle pulled up on the school side of White Rock. After the altercation between Miss Patterson, Mr. Brooks, Miss Corey, and myself, the 3 of us, Miss Patterson, Miss Corey, we started to leave. I told Mr. Brooks, you need to get out of here. The police have been called. You need to leave. You need to leave now. You do not belong here. I did not expect.
Can you strike everything that's not pertaining to the question that was asked?
Actually, I'm just describing the entire event in its entirety.
I understand. I'll strike the responsive and non-responsive to the question. The jury is to disregard it. Re-ask your question again.
Okay. Do you recall where you and your two female friends went after the altercation?
We started to head back in the direction of the women's shelter where they lived, where they were staying at the time.
Do you recall at any point during your travels to the women's shelter, as you referred to it, do you recall at any time coming into contact with another law enforcement officer?
Within that point in time, no. Except for the one that pulled out of Frame Park.
Do you recall at any time being stopped by a law enforcement officer on your way back to the women's shelter?
We were stopped partway down White Rock, and that was when I had told the officer, because he wouldn't get out of his SUV, I had let him know that they need to be on the lookout for a red SUV that took off back down White Rock towards Perkins Avenue, or street or road, whatever it is. The officer had asked me if there was someone with a knife, and that was when I held up my left hand, and I said, no. I said, I have 12 stitches from a knife injury on this hand, but this is what you need to be looking for, is this red SUV. And I'm guessing that's where the miscommunication of the knife came in, and I don't know where that officer went after that.
And would it be fair to say that that was the second law enforcement officer that you had spoke with that day at that time?
Yes. You are referring to November 21st?
Correct.
Okay.
During that interaction with the second law enforcement officer, do you yourself recall stating that a black guy just assaulted my friend?
No.
Any reason why the officer would report that?
Objection, calls for speculation.
Rounds.
Sustained. Calls for speculation.
Did you yourself sustain any injuries during the altercation?
I ripped open 3 stitches on my hand, but that was more so from pulling Miss Corey away from Mr. Brooks so we could get out of there.
Did you report to any law enforcement? Well, I guess that would refer to the second law enforcement officer that you spoke with. Did you report that to that officer?
No. Because at the time I didn't notice it. I didn't notice my hand was ripped open again until I got home.
So perched up.
So it would be fair to say that you don't know how those stitches opened up. Would that be fair to say?
No, I'm pretty sure I know how they opened. My stitches got caught on the zipper on Corey's backpack. That's how the stitches were ripped out of my hand when I was trying to pull her away from Mr. Brooks and intervene between her, Mr. Brooks, and Miss Patterson.
Knowing a little bit about stitches, would it be fair to say that a wound that was stitched being reopened would cause a little bit of pain? Would that be fair to say?
Objection.
Relevance.
Rounds.
Sustained. Relevance.
Did you notice any blood from the stitches being reopened?
Didn't feel anything until I actually looked at it when I got home. 12 stitches coming across my thumb in kind of like a fish hook type pattern. It was the 2 over here that ripped open and the 1 up here. Or actually, I take that back, the 1 up here.
So just for the record, he's holding his left hand. He had his thumb out, extended almost like an L, but with the other fingers almost like a C, and he was pointing to his left thumb near, I would say, the middle of the thumb, and then the curve of the thumb where on the inside where it goes up toward the index finger. Sorry, I have to make a
Now-
record of all.
No, that's just fine.
Go ahead.
So was it 2 stitches that opened or 3?
Question, relevance.
Grounds.
Overruled. He may answer, but then move on.
It was 3.
And do you recall what time you made it home that evening?
Absolutely not.
Was it immediately after the altercation or sometime after? Or
No, I took the girls back to the shelter, and then I started running back towards Main Street to try and see if I could avoid the parade traffic. And that's when I saw the red SUV go down Main Street.
Let me see how much longer I'll cut this off. About 5 more minutes. Oh, look at this. Yeah, I pledge you smile on his face. I can't stand this motherfucker. And for the record, you know, I hate me a bitch ass nigga. I think they don't have no place on this earth. That's just my opinion. Ugh.
And do you recall speaking with your women friends after you had made it home that evening?
Yes.
Did at any time you indicate to them that you,
Hold on, let him finish the question. He was asking what he indicated to
the
them.
question? I thought that's what I said.
You can ask your question. That's what I thought you were saying too.
Did you yourself at any time indicate to your female friends that you had sustained injury during the altercation?
No.
Objection to relevance.
Overruled. His answer may stand.
In the time that you had known Miss Patterson up until that day of November 21st of 2021, had you yourself ever heard Miss Patterson refer to the alleged defendant by a different name?
Objection to relevance.
Grounds.
Overruled. The witness may answer if he knows.
No. You mean like an alias or something?
A different name.
Well, okay, that could a nickname, an alias. I mean, let's be specific here.
Did Ms. Patterson ever refer to him with another name? If you recall.
Not that I can personally recall, no, no.
All right, thank you.
That man can't stand his ass.
you recall if, to your knowledge, was your friend Miss Corey, as you referred to her, do you recall her stating that she was injured during the altercation?
She did tell me that she I believe she like hurt her finger or her fingernail or something like that, but I don't think it was relevant to the incident that had happened.
What do you mean by you don't think it was relevant to the incident that happened?
Just relevance.
Sustained is to the form of the question.
No further questions.
Before I decide whether to do cross at this time, how long do you believe it will be?
0 minutes because I have no.
All right, thank you. And you can step down, and we're going to take a break. Give me a second. I'll rise for the jury. Let me excuse the jury for a second.
I want to see his facial expression. He think he is so fucking smart with his crazy, demented, probably.
All right, thank you. You may be seated. You may step down, sir. And I presume he may be released from his subpoena, Mr. Brooks. You're done questioning him?
Yeah.
All right, you are released from your subpoena, sir. All right, let's take about a 15-minute break. Anything we need to address
Oh,
prior to
remind
that,
me
or
of somebody we know.
no, when we come back? No, thank you. All right, Mr. Brooks, work with the state, please, for the next witness. We have them available.
Oh gosh, I can't stand him. Listen, listen. So I'm about done for this evening. But listen, oh my gosh. Y'all know, if y'all didn't know, I am allergic to bitch ass niggas. They make me want to throw up. He's not dumb. He's full of shit. He's full of shit, and he's thinking he's getting one over. But see, what he don't know, the joke is on him. Although they ain't let him know. He is just putting himself in situations that at a later date it's going to be hard for him to explain. And that's what you do to motherfuckers that think they got the ups. Well, you're going to be like, you're going to look stupid. And that's exactly what happened to him when that goddamn verdict came. You know what I'm saying? I think he thought that he would be found guilty on some case, but all 76, shit. You know what I'm saying? And I can't stand him. But listen, I absolutely love that guy, that witness. That's good white people. You need to surround yourself with good people, period, right? It's just listen. I'm telling you, it's like the law of averages, right? If you're familiar with that, if you went to school, law of averages, right? Chances are you surround yourself with bad people, you're going to experience bad shit. Good people usually brings about good shit. Okay, that's good. White boy, even though they was calling him, that white man, meth user and stuff like that, I sincerely hope that, I ain't, been out here and around. Sincerely hope that it wasn't no one, shit, I don't know, child, the greater people are so low around here. I don't know. It probably was some people defending this motherfucker. And I don't want to hear shit about that one. I don't want to see no black man in jail. I don't want to hear none of that bullshit. You do the crime, you do the motherfucking time. It don't matter who the fuck it is. Okay? Who gives a fuck? You take your weight. But his ass is, and I don't know why people think that color is exception to the rule. It's not. I just don't get it. I don't get none of this shit. But again, I'm just glad to be. Be with my kind, my type. But if y'all get a chance, and whoever goes back and listen to this, the rest of this, whatever, because got a few more minutes, I'm gonna shut it down. There's no telling when I'll be back on here, honey. It might be shit next year. We have something more to talk about, but listen. That dude, I hope ain't nobody around here defending this motherfucker. But listen. Oh, and you know what? I got one message. It was like, ask me why I called him an idiot. He has rights. See, and no offense, but I'm not answering no more crazy ass questions, sensitive ass messages, unfair. I'm not dwelling in none of that. You can be an idiot, but I mean, you can have rights. That don't mean you ain't no idiot. Duh. It's like, having an exchange with some of these people, going back and forth, arguing with them, it is a waste of time. Okay? Unfortunately, I found out too late. Okay? Should have figured that out a long time ago. Stick to your kind. Okay? Life would be much easier for you. Okay? Just stick to your kind, your type. And you won't have these fucking issues. Because, I mean, that little motherfucker, he said acting, and causing all that motherfucking drama, thinking he getting one up on the people and not knowing they got your ass dead to the goddamn wood. They are playing for the long game. Okay? They are playing for the appeal after the appeal. Okay? They're gonna make sure you constitutionally fuck yourself and that you never get out. That's what they do. Don't try to outsmart the game. Be smarter than the game. It's the dumbest shit I ever seen in my damn life. Dumb. But like I anticipated, we got a lot of answers to all of that. Listen, I'm so tired. And I'm trying to tell you, I was tired hour in. I was going to call it the birther. Now, I'm crazy. Damn well the sovereign citizen ain't no birthers or whatever. Shit. But this dude is a piece of goddamn work. This dude was a piece of fucking work. I can't believe this shit. But yeah, but again, shout out to the people that still keeping the lights on in the sector. People that's and this is crazy. People that's informative and they're still bringing information. It might not be on just R. Kelly, it may be on other stuff. People that's bringing bullshit, still bringing bullshit, irrelevant ass bullshit. It just never changes. Like, Lord have mercy. Jesus, help me. So I don't be in a rush for all that. I want hopefully next time I come on, maybe we could talk about sports. It will be about basketball and boxing. Maybe I'll upload some stuff. Let me see. What else? Y'all know I'm preoccupied. Please, 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 if anybody want to talk about some fashion and shit like that, let me know. What else? No telling when I might ask to be back on here. I don't, and I've been trying to do so good because, baby, I was told not by one person, by two. I was like, ooh, that how I talk to people and my delivery is rather harsh. Yes, child. Imagine that shit. So I'm working on it. Oh, Florida Georgia game. Oh my gosh. Listen. Ooh. I saw this dude. And man, the co-worker, we standing up there. So he walks by there with an FSU shirt on. Now, mind you, she is a flirt, honey. And I'm talking about, child, she flirts. That ain't my thing. But, so he walks by, and this guy was flirtable. She flirts with some people that's not flirtable. But this particular guy was flirtable, right? So, he had on the FSU shirt, and I said, hey, because this was the day of the game. I said, hey, you do know that today isn't your day. You're being selfish. He said, well, let me tell you something. He said, in a few hours, the day ain't going to be your day either. Meaning that Georgia was going to beat the shit out of us. And I didn't know, I didn't know that, that Florida was that bad. I never have heard a time when they've had a bad team. You leave it up to the fans and everybody I know that went to Florida. Shit. Hell. It's like Tom Brady is their quarterback. Hell. So shit, I don't know. And so, I don't keep up with no football, baby. I went to look on that little app to see the score. At one point, it was 14-0. Joe, I said, God damn. So, and then I found out, y'all, that, and I posted this, that the Pittsburgh Steelers are the only NFL team that has, a logo just on one side of their helmet. Yes, honey. I told y'all a long time ago any type of man talk or something like that, some shit I need to put y'all up on game, I'm gonna bring it to you. See, that's relevant shit, not bullshit. I heard some shit. I'm so preoccupied, y'all. Wait a minute. I hate when I do this. I can't keep up with. Not that I can't keep up with it. It's like I don't want to keep up with it. So you know me, and that name change. I am not. You have people that constantly come with the gossip and the bullshit and keeping up with this and being nosy about that, whatever. I'm shit. Like I be like, God damn, like if you don't, like get a life. You don't have one, find one. I don't know what the fuck is going on about no Bruce and I'm confused with the HN News, and somehow HN News equates to Hollywood Next, whatever. And I don't know what she got to do with it or whatever. Are they saying she behind HN News? I don't know. I don't know nothing about this bullshit, but and I really don't care, to be honest. I was gonna read the updates about his case. Let me do that and get on the hell on up out of here. Cause I saw something drop. But yeah, that guy is a bitch ass nigga. And guys, keep your hands off these women. His little ass, I would have worked with his little motherfucking ass. I promise you, honey. My feet would have been moving like Muhammad Ali. Oh, I'd have gave his ass a rope-a-dope around that big old motherfucking head. Boy, he throws his head back and talk unnecessary bullshit, and just like somebody we know. Hold on. But it's luckily that girl had that white guy to come save her. You know? Oh, these 3 pages. I'm trying to read this. I'll read. I ain't read this in a minute. All right. This is a motion for extension of time to file post-trial motions. We know what those are. Now comes defendant Robert S. Kelly by and through his counsel, the Bungie Law Group, PLLC, and moves this court for a 2-week extension of time until November 15, 2002 to file his post-trial motions. Wonder when were they supposed to be in? Okay. It says, After a month-long trial, the jury found defendant Kelly guilty as to counts 1, 2, 3, 4, 5, and 7 of the indictment, and not guilty as to what that is. What is it? Oh, 4, 5, 6, 7. That's a repeat. This should be 8. Wait a minute, 7, 8, 11. Oh, she repeated. Oh, well. Okay. It's of the indictment on September 14, 2022. Post-trial motions are presently due on November 1st. Oh, which is today. Oh, with responses due on November 15th. For the reasons set forth herein, counsel for Kelly is seeking a 2-week extension of time to file his post-trial motion. Oh, hell no. So it seemed like I'll be, oh, hell no. I'm going to be busy. Oh, y'all got people to do this. Hell. Damn. Over the last few weeks, defendant Kelly's counsel has done their utmost to manage an extraordinarily demanding trial schedule and several pressing deadlines. As this court may recall, prior to trial in the present matter, counsel for Kelly was on trial from May 23rd, 2022 through June 22nd, 2022 in the Superior Court of Los Angeles in the matter of Hughes versus Cosby. The back-to-back trial schedule for Bonjing Law Group boutique law firm created a significant backing of work for which counsel is still trying to catch up on, and that's why they be all styling and profiling in the bathroom, taking selfies. It says during the Kelly trial alone, Bonjing Law Group filed 2 opening briefs in the Illinois Appellate Court in People versus Rodriguez and People versus Blue, as well as post-trial motions in the Hughes matter. Our firm also filed a brief in the United States Court of Appeals in the Sixth Circuit in USA versus Baker on September 3rd, 2022. In addition to these briefs, since the conclusion of the instant trial, our firm had a restitution hearing in the People versus Kelly, September 28, 2022, which involved extensive briefing, plaintiff deposition in Ochoa versus Lopez on October 14. Now, you know I'm tired because I don't read all those numbers. 2 depositions in the matter of Massonet versus Guevara, and a reliability hearing in a criminal matter on October 20, 2022 in People versus Bryant. Furthermore, counsel has petitioned for a rehearing due today in Williams versus Kelly, a final pretrial order due in Allen versus Leonard. Oh my gosh, and an impending expert discovery deadline in Massonet versus Guevara on November 4. These are just a few imminent deadlines and do not include several other depositions and hearings over the next few weeks. Finally, and significantly, yesterday, the government produced a letter to counsel for Kelly related to Dr. Daryl Turner's testimony at trial, which requires additional research and may warrant an additional motion that was not previously contemplated. The government has no objections to this request and requests until December 6, 2022 to file their response to our motions. Okay, so he probably approved this. For the foregoing reasons, unsigned counsel respectfully requests until November 15th to file post-trial motions. Let me see. So, most likely, they said, okay. Oh, I want to know none of this, y'all. I'm sorry, I'm derelict on my shit. Sorry. I ain't even updated nothing. Okay, so the notice of motion. Please say no on Tuesday, November 1st at 9:30 a.m. Council shall appear before the Honorable Judge Harry Lena Weber and present the defendant Robert Spencer Kelly unopposed motion for extension of time to file for post-trial motions in the above captioned matter. On November 1st. So when do you want it? When will the motions be in? So I know. Shit. So we all know what the post-conviction motions are. It says, men injured or harmed in Lena Weber Kelly's unopposed motion for an extension of time to 11/15/2022 to file post-trial motion is granted. Okay. So, wow. That's going to run damn near to the bottom of December. So, November the 15th. Oh my God, that's going to be a lot of reading. Shit. All right, folks. Well, I'm going to shut it on down. Thank y'all for coming through. So I guess I'll try. I don't make no promises when those drop. So I guess I'll try to make some time to come back. I'll see what day that's on. And I will see y'all later. Thank y'all so much. Peace out and good night.